Hi everyone, welcome to Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and before I move ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone. I am your host Rajni Bharara, and today we have the privilege of hosting attorney Ruby L. Powers, a distinguished leader in immigration law and the founder of the acclaimed Powers Law Group, PC, based in Houston, Texas. Ruby is a board certified immigration attorney with nearly 20 years of extensive experience in navigating the complexities of immigration matters, including family and employment based cases, asylum, and deportation defense. Well, Ruby's commitment to her clients is unparalleled. She combines her professional expertise with personal insights as a child of an immigrant. Her compassionate approach has earned her recognition as a respected author and speaker, with her insights featured in major publications such as the Washington Post and the New York Times. She has been honored with prestigious awards like the AILA Advocacy Award and has been listed in the Best Lawyers in America and Super Lawyers. In today's episode, we will delve into recent immigration updates, what's next for DACA recipients in 2025, and Ruby will share her insights on evolving landscape of immigration policy and what it means for DACA recipients moving forward. So join us for an enlightening discussion that promises to empower and also to inform. And now, without any further ado, let me very quickly give a warm welcome to Ruby because it's her first time on Immigration and Jobs Talk Show. Hi, Ruby. Welcome to Immigration and Jobs Talk Show. How are you?
Good. Thank you so much for having me. I really appreciate it.
Of course, it's a pleasure having you. I mean, it doesn't happen every day that we get a chance to actually do a show with you. So thank you so much for being here, Ruby. And now, guys, I would also like to tell you that Ruby will be sharing a presentation on recent immigration updates, what's next for DACA recipients in 2024. So without any further ado, let's get into that presentation. Let's listen what all Ruby has to say about the future for DACA recipients and what's going to happen in 2025. And Ruby, the stage is yours. Please go ahead.
Thank you, Rashi. I appreciate it. So this is a hot topic, and we also are going to take other questions. I'll just briefly go over this for those who this could be of interest. We don't know the future, but we can take a lot from the past and make some suggestions on what we think might happen. And so I wanted to share this, and you did a great bio intro of me. So thank you. Board certified law firm, 15 years old, Powers Law Group in Houston. I'll go ahead and keep going. So for DACA, the Deferred Action for Childhood Arrivals, it was announced in mid-June 2012. I remember that moment. And it came live only 2 months later in August 2012. And it really gave a hope and for many people who were brought to the U.S. Many of them didn't even know they were not U.S. citizens. I remember having many consults with those, finding out for the first time when this program came out. And it was a way for those to get work authorization, a status, and be able to be in the U.S. for 2 years at a time. And it's been a great program for these last 12 plus years. But the thing is that we've seen a lot of different litigation. In September 2017, under the Trump administration, he was challenging the legality of it, which, the long story short, is it went all the way up to the Supreme Court. And the Supreme Court said the reason why you're trying to get rid of it is not valid. But it didn't it didn't say you couldn't get rid of it. It just said the way you're saying the reason why is not good. And so then it was continuously challenged. And so basically from 2017 to now, it's been in litigation of some sort. And what that really means is that the people who were eligible to apply new DACA have not been able to since around that September 2017. And the thing is that you had to be a certain age to apply. and meet certain requirements. And so many of those people who were just not old enough to apply before September 2017 have not been able to take advantage of the program because it's been in litigation, and it continues to be in. And so in 2023, a federal judge in Texas ruled DACA illegal, and then it went up to the Fifth Circuit, which listened to oral arguments not too long ago. And honestly, it hasn't given a decision. The Biden administration, which really only has about 1 month left, does support DACA, but they haven't been able to get a DREAM Act, which would make it more solidified. See, DACA is part of executive action from the presidential power, from executive order. And so that is the thing, is that we really haven't had immigration new laws in such a long time. And so that's really where basically what happens is that sometimes the presidents are making opportunities based off of their executive power, and then it later gets challenged in other administrations. But ultimately, we've been waiting for Congress to actually act and make laws that apply to immigration, but we haven't seen that in many years. And so as we've seen it, if the Fifth Circuit were to rule against DACA, we know it definitely would go up to the Supreme Court. But we have seen the circuit be more favorable to, anti-DACA and more favorable to Trump mentality. And we've also seen the Supreme Court rule not in favor of DACA necessarily. And so we think that what could possibly happen is that Fifth Circuit will probably say it's illegal, move it up to the Supreme Court. Supreme Court will either take it to be heard or not. But ultimately, the fact that right now all you can do is renew and advance parole is what you can do. You cannot apply new DACA. And if you look at the numbers, you can see that a lot of people are not in. The numbers have dwindled since originally. It's because a lot of people have been able to move on to something else like legal permanent residency. And so we're a little confused as to what's going to happen, because there was a lot of talk, maybe even just a few weeks ago, with Trump, President-elect Trump, saying that he was not so favorable about DACA, let's say, especially in the campaign trail. But then just recently, it sounds as if he's more favorable. So that's really where the confusion lies, is that we don't know what to expect. So the DACA recipients are primarily from California, Texas, are living primarily in California, Texas, and New York. And there's about 500,000 right now. The oldest DACA recipients is about 43 and a half years old. Many of them are married with children in school. Some could even be a grandparent by now. And they've been educated in the U.S. by virtue of being eligible for it. And so we see a lot of, unfortunately, it's like they're having to, build their lives on their home on the sand, because they don't know what's going to happen. And many of them are have American spouses, American children, and have been living in limbo. So this is that contradictory approach. We're honestly confused. We don't know what to listen to, because we've also seen this quote from Donald Trump: we have to do something about the dreamers. The people were brought here at a very young age. I've also heard about when I did a lot of advocacy in DC, I once heard in an office, they said that if we were to give a pathway to citizenship for DACA recipients, then it's a way, one sort of approach is that it's a way of rewarding the parents for bringing in children illegally, and because one day those children who could get a pathway to citizenship could petition for their parents. And so I think that's been one argument from the Republican side as to why they weren't pro DREAM Act. But I haven't heard that out in the world very much in the news, but that did give me a way to think about different perspectives. So it's confusing because what do you listen to? Is he pro DACA? Is he against it? What's going to happen? I mean, I think very likely it'll go to Supreme Court. Whether Supreme Court will take the arguments, I mean, listen to it and cert. I don't know, and I think that's where a lot of uncertainty is. But one thing that could happen, because they have the White House and narrow numbers, but in the House and the Senate, is they could try to put a DREAM Act through. And I don't know why they wouldn't if they finally could move it forward. So we'll see. I wish I had more certainty, but I think that's one of the things we're going to see a lot in this on this times is that we don't know. What was said on the trail is the campaign trail is going to be done. What's not going to be done. I think one thing just to be in a precautionary mode is to go ahead and renew DACA maybe early. You're supposed to do like 150 days. Some people are applying even earlier just to make sure that they get it because they don't know what will happen. Getting your documents in order, having a consultation, evaluating what your options are. And so that's really what we're seeing, a lot of people wanting to renew early. And we're also seeing a lot of people wanting to do the advanced parole because one aspect is being able to apply brand new, and that you cannot do that right now. You cannot apply brand new DACA. And if you don't apply on time, if you have more than a year lapse between your DACA expiring and it's considered a new DACA if it's been more than a year, and you wouldn't be eligible for it because there's no new DACA. It's just renewals. And so that's the reason why it's so important to be timely filing. And the advanced parole is an option that gives people a legal entry, if you will. And the biggest thing to note is that you would have to have enough time on your DACA. You would have to have a valid passport that has enough time on that. And then you would have to have either humanitarian, educational, or employment reason. And then by doing that, you would have to have the proper information, evidence to establish that. Now, one of the things to note is that it's been taking about 3 months to get the advanced parole. And we only have a month left of this administration. So when the election results came out, some attorneys were saying, like, should we even offer this? Should we not? I think that as long as people understand the risk and consequences, then people should feel free to apply. But we don't know what will happen. We don't know if January 20th, he says no advanced parole or something. But then again, the other thing I will say is it's important to note, where is the source of power? Is executive action, order? Is there a rule? Is it a law? Is it a policy interpretation? And honestly, this is huge, especially under the Trump administration, because then it gives you clarity as to how long and how it could be changed. Could it be changed with just the stroke of a pen by the president, or would it require a lot more action by multiple people or Congress? And so these are all the things to consider. And I think that's just a good takeaway in general as we analyze the future of so many things, including H-1B, other visas, interpretations. So much of immigration is not necessarily because of a law necessarily. It's about interpretations and policies and different executive actions and orders. So this was just an example of the documents that would be needed. We're still filing for folks, but we are letting them know that we might not get approved in time, and under the new administration, we don't know what will happen. The advanced parole, so if a person hasn't already gone advanced parole, traveled and come back, then you're really on borrowed time right now because we don't know what to expect. But if a person entered illegally, let's say one time, and then later got DACA, if they did have the advanced parole entry, then and they're married to a U.S. citizen, then all things being equal, no other complications, we should be able to adjust. We should be able to adjust them inside the United States, and so that's why that legal entry is so critical. And hopefully, people have already gotten it. It also can be helpful for traveling if we're going to do like a perm process and trying to do consular processing with DACA, which gets more complicated. I think one thing to note is that finding alternatives. So like there used to be almost 1 million or so DACA recipients, and now we're down to 500,000. And I don't think that many it's because they had a DWI and they got disqualified. I think it's more because they were married to U.S. citizens. They were able to do the provisional waiver or the advanced parole, DACA belly, what we call, and were able to find a way to a pathway to legal permanent residency. The other thing would be is if they were the recipient or a beneficiary or a derivative of an I-130 or labor certification from April 30th, 2001. This is under the 245I provision. It's old. It would probably be because if their parent was a beneficiary and they were underneath it, potentially they didn't even have to be alive at the time. That could act as a legal entry. That gets more complicated, so I'd rather explain that in a consultation. Provisional waiver is still an option. The provisional waiver right now, but they were taking on a line. They're saying they're 4.5 years. The most recent waivers we got approved were 2.5 years. Just recently, we've seen a lot of approvals. Asylum could be an option as well, but the biggest issue is if you don't apply within 1 year of entry, you need to have an exception, change circumstances, exceptional circumstances, and being in DACA up until it goes away potentially, and then applying could be considered exceptional circumstances, but that would be something I'd say look at the moment. The other potential thing would be like military parole in place. If your spouse or child is in the military or was in the military or a ready reserve or a vet, that could be an option. We also, during the Trump 1.0, I'm just going to call it that, the first administration, there was a lot of concern that the military parole in place would go away, but it never did. But I think I'm still going to bring that up because we don't know. There's also the U visa, which is a victim of a crime, but it has to be a specific a qualifying crime, and you have to get the certification. One of the things, a couple of things to note is that under Trump 1 is that he had said that judges could still deport someone even if the U visa is pending, which really gives pause because under Biden, they said, no, you can't be deported while it's pending. There's discretion, but that's not going to be their policy. The other thing is that, what do you mean pending? Well, it's because there's only 10,000 visas a year. And there's a lot of demand since this program came out around 2008. And so it's taking about 10 or 15 years to get a U visa right now. And those are the estimates with the application rate plus the visa availability. T visas are not met as much, so it's a little bit faster. Like within a year or two, you can get them, more like a year and a half. But what those are sort of more of a unique thing. I think a lot of attorneys are screening better for those. You could be a victim of trafficking through labor or sexual. Doesn't have to be just one, but the labor could be like withholding payment, coercion, holding documents, and things like that. Cancellation of removal is when you've been here 10 years or more, good moral character, and extreme unusual hardship to U.S. citizen, spouse, parent, or child. That means it's more defensive. You have to be in court for you to proceed in that way. There's also special immigrant juvenile status, and that one is really more for younger folks and things like that. So it's a two-part aspect of family law, order, and then USCIS. I think just in general, what I'm telling a lot of people is that be prepared. We don't know step one, good, you're listening to this, good, you're looking into it. It's know your rights, know your information, know what your options are. Having a consultation with an experienced immigration attorney, I think, is so critical because I think a lot of times people just go with whatever they hear in the news, and sometimes that can be very sensational. And it's not specific to their situation. One of the best things that came out of DACA back, 12 years ago was that it got people going and having consultations. And I kid you not, some people were already eligible for things, but they didn't know because they didn't go to an attorney to evaluate, or they were given bad advice. And so that's why I would say is check the reviews, make sure that it's a reputable person, attorney. Make sure that they've had cases similar to yours, that they've had experience, and and if anything, go get a second opinion as well. It doesn't mean you don't trust them. It's this is your life and this is important, and you want to make sure that you have the right information that you're making that decision. And then write down what is being said, so that way, if some key facts were to change later, or laws or interpretations, it could mean that you might be eligible for something later that you didn't know about. So it's important for everyone to know what their rights are. And I mean, for those who are in the U.S. and don't have a status, it's important to have children or spouses, having guardianship arrangements, having wills, having documents in order. I think having the taxes and civil documents scanned in one place, so that someone could quickly email that to an attorney if they're hired, if the person's detained or held. Having the key numbers ready so that someone else can jump in action, such as maybe calling a lawyer that's been like pre-screened, and that maybe they're not hired, but at least the lawyer knows about the case and has document. For example, all my consultations, we keep notes and we have an intake. And so if someone were to call later, which, the firm's 15 years old, we can quickly pull that information, start from there. That helps us to be able to move forward, especially if there was something we had to act quickly. And what I mean quickly is that if a person is detained, if, for example, they have a prior deportation order, like even just in the news, there was a woman with a deportation order and 2 U.S.-born twin children that are only a few months old, and she was deported. And so, there could be options with stay of deportation, having ways to do prosecutorial discretion, but that's what we know now. But in the future, a lot of those things are going to change and be a little bit harsher from what we're hearing in the news and from Trump's campaign policies and promises. So we'll see what happens. And I think having a few trusted sources that you can always go to and stay up to date. For example, we team up with a lot of the consulates and nonprofits, so that we're finding out about things maybe before some things are out there in the news, and that can help us give that information to our clients. But also, we put out a lot of content in on our Facebook, our X. We're also on Blue Sky as well, Instagram and TikTok. We regularly have a lot of content, and we also have a newsletter in English and Spanish that is out there, and we just summarize the key points from those 2 weeks at a time, so that way it's sort of a digest, if you will, of what the key things to know are. So as there's information about how to reach us, our rubypowerslaw.com and our number. But for the most part, that's more about what's going on in the DACA. And it looks like we got a lot of questions too. And we can talk about non-DACA things as well. But if anyone has any questions, I'll do the best I can.
Thank you so much for that amazing presentation, Ruby. It really helped a lot to understand each and everything about DACA. So guys, if you have any questions from Ruby that you would like to know, that you would like to get an answer of, so please make sure to comment down, make sure to post your comments in the comment section, and we'll be taking your question. Also, you can give us a call on the number 425-436-6335, and you can put the access code, which is 988888. Yes, make sure to dial this number and put this access code, and we'll put you through. Thank you so much. And Ruby, I would like to come back to you, and I would like to ask you a really controversial question related to DACA, because
Okay.
some people who don't side with DACA and who don't favor DACA call it a way to support illegal immigration, right? So, but what do you have to say, and what do you think? Does DACA encourage more illegal immigration, or does it provide like a humane solution for integrated young people?
That's a good question. So I see both sides, having even mentioned that what I had heard when I was at a Republican senator's office about why there's some pushback to having a pathway, because what they were saying is if we were to give green cards and citizenship to DACA or Dreamers, that there's no restriction on petitioning for their parents. Like with the special immigrant juvenile, you sever parental the relationship, so therefore you can't petition for the one that is the one you sever from. But with this scenario, you couldn't put a pause. I think the way I look at it, I mean, there's a way I look at it, there's way different, there's a whole spectrum, right? Is
Right.
that the children were brought here with no control over anything. In fact, like I said, some of them thought they were US citizens because their parents didn't tell them otherwise. And then to wake up one day and find out that they don't have a status, like this was, just a wonderful gift that helped quasi remedy the dilemma. Because when I say quasi, because it's still in limbo and it's been pending 12 years. And unfortunately, the people who were too young to take advantage of it by the time Trump, paused it in September 2017 haven't been able to take advantage of it. And they are still very much dreamers outside in the world. I think it's a humanitarian quasi solution for something that we should have given more of a permanent solution. I think when you do things like this to fix problems, it can appear from like one perspective that you're encouraging illegal entry or unlawful presence in the US. But the reality is that they were so stringent on the requirements. Like you had to be here by this date. It was like 5 years before the eligibility, and you had to be this age and you had to go to this school or do this program, In fact, a lot of people, when I still talk to people, I'm like, why don't you have DACA? And they're like, oh, I didn't do this school, or oh, I didn't have enough evidence, or oh, I came 2 weeks or 3 weeks too late or something. And there's still a lot, what we still call dreamers, the people in theory, the large group, and then the DACA recipients are more of a smaller section. Anyway, I'm more of the pro-immigrant side, and that I really think the U.S. should still do something more. But
I mean, as
I'm
you
glad
should,
that
and I think as everyone should, because America is the nation, US is the nation built by immigrants, right?
right.
So people should be pro-immigrants. But then, how do we? Is there a way to, Ruby, also balance national security concerns with humanitarian considerations for undocumented youth?
Yeah, there is, but let's just go on DACA, for example. If you get a DWI, one DWI, you're out of it. You're out. You're out of the running. I mean, TPS is easier than DACA. DACA, you had to have, if you had more than a few misdemeanors, you get kicked out of TPS, but they didn't specify DWI. I mean, one DWI. I mean, I'm not saying that you should have that, but that's an example of something that could put people in danger. You get one, you're dead, you're gone, on the DACA, for example. So it is really stringent. And the fact that a lot of them have been in the US for so long, I mean, the DACA recipients that I know, they're stellar, community members. Yeah, there's always the concern about, security. I used to work for the Committee on Homeland Security many years ago in DC. That's always a concern. But I think that the dreamers are really a subsection of those who are, quasi-American citizens in a way, because they've been here so long, and in the culture. And I think that's what makes it so much easier for them, to marry U.S. citizens. And it's almost like they're already citizens, but they just don't have the document to prove it. And I'm not saying DACA recipients are U.S. citizens, but because we don't want to say a false claim. But I'm just saying culturally and educated and things. But yeah, there's always the concerns. But I think that they're not the ones that are the most prone to the issues that we would need to be as concerned about.
Right. I mean, also they don't know any other way, right? Because they have been there since the time they have been on this planet. So, well, there are still so many controversies and so many things surrounding DACA, but hopefully it's going to be better for the DACA, recipients. But also with that, and for the dreamers, of course. But Ruby, I would also like to know from you that people are really waiting until the court gives its decision, right? And it's going to happen in 2025. And now that the new administration has taken power or has come into power, not many people are, people are a lot more stressed about what's actually going to happen now, right? Because though they say that they are favoring that, but nobody actually knows what might happen. So I would also like to know from you that what role does the public opinion play in shaping the chances of, things coming in favor or things going against it?
I think it's huge, and I think that's where we need to consolidate our power in that. I'll give you an example: family separation, the zero tolerance policy of like the summer of 2018, when it was happening even a couple of months before, but it really wasn't. People weren't piecing it together. People didn't know what was going on, and it wasn't until about mid-June when the reports were starting to get to the reporters, and they were piecing together what was happening. I went down to the border Port Isabel detention facility, and there weren't a lot of attorneys that were there initially because they didn't know the pro bono attorneys. It took a little while to get there, but they were there soon after. I did like 5 or 6 interviews. I don't know, it was a ton of media, and that day, after meeting with all those parents who had been separated and had no idea where their kids were, completely traumatized. And within like a day or two, Trump reversed the zero tolerance policy, and ACLU had the lawsuits that forced the government to put the kids and the parents back together again. And they had a deadline to get them all together within a couple of weeks. But for the public outcry, that wouldn't have happened. And that's really what taught me the importance of maybe you don't have the House, and maybe you don't have the Senate, maybe you don't have the White House, but you do have public opinion. And that's where we need to rally together if something is completely egregious. And I mean, we've even just seen recently, I think the last day or two, like tech companies are trying to rally Elon Musk and Trump to have more help in the H-1B or the skilled worker visas, because they know that there's such a shortage and they need help to fill those needs. So they're using media, they're using their connections to try to get that attention. So, those are just a couple of examples. And I think we need to band together. And that's really, as an immigrant advocate, having to use media is to get out there, the stories out there is so critical.
Right. And it's only because of the public opinion and public views why the new administration came in power, right? I mean, very well put. Thank you so much, Ruby, for your answer. And now also because, nobody's really sure that what might happen in the next year, what decision might come. So if it is negative, do you think that the DACA recipients should consider like alternate visa options or pathways to permanent residency?
Yeah, so that's the reason why I put that in and I see a couple of really good questions. I think we're sort of on topic right with what we're seeing right now. That's the reason why I put the alternatives there, is because, like I mentioned, there used to be about 1 million, now there's about 500,000, but a lot of them it's because they got the advanced parole, they were married to U.S. citizens, or they got the provisional waiver and they're going that route, something along those lines. So I think the best scenario, or some of them have perm cases pending, and are trying to do the D3 waiver. And so what I would just say is that, yes, try to have a backup plan, be working towards that if possible for legal permanent residency. One of the questions was, how quickly could, when the new administration takes office, which is January 20th, how quickly could DACA protections be reversed or strengthened? Yeah. Should we expect immediate changes? Well, again, Fifth Circuit still hasn't made a decision. Then we've got the Supreme Court may or may not take up the question at all. They might just not even take it up. Supreme Court also sort of has their own schedule. So usually their decisions come out in mid-June, depending on what happens with the timing there, but what we have heard is that Trump is planning to have hundreds, I don't know how many, like a lot of executive actions and orders on day one. So I think that goes back to what I said, where does the power lie of the thing that we care about? Is it in a rule? Is it executive action? Is it order? I mean, we really can look to the prior Supreme Court decision as well and what was done since then. There's also talk about would there be, if they were to get rid of DACA at some point, and again, we're still waiting for the circuit, potentially Supreme Court, right? So you can't just completely get rid of it. They still have to go through the process. But what would there in the future, let's say it does go away, would there be like everything goes away this day, like the day your card expires, or would it be like a generous, phase out period of, I don't know, a year or something like that? All of those questions have been sort of circulated amongst the, immigration attorney community, and we're not sure what the answer is going to be. So, but I think it helps at least to think about those possibilities. But bottom line, if you have DACA, be thinking about what your backup plan could be if you could move to something else. And we also don't know what new things will come up. But what I will say is that Trump 1.0 got rid of about 50% of the legal options for immigrants. And so what I think what will happen is that a lot of the paroles that came out, a lot of the discretion that came out under Biden, I think a lot of that's going to go away. And I wouldn't be surprised if advanced parole were to go away for DACA as well. So there's another question, like, I want to travel to see my family, but I'm scared it could affect my DACA.
Yeah.
I think that you should, if you want to apply for it, if you have your enough DACA time, enough passport time, enough, and get that advanced parole out, see what happens. I know it's like, I'm telling you, see what happens, but I mean, the thing is you don't know until you try. And I know it does take resources, filing fees and money and things like that. But who knows, maybe you could get it really quickly. Maybe there's no harm to it in the future. There was, I think Cornell University sent out, this was like about a month or so ago, a note to all their students, and they said, if you're going to travel, come back by January 20th.
Yeah.
And so I think when we heard that, we're like, oh, okay, we should tell everybody the same thing. I mean, honestly, remember when Trump went into office, there was the Muslim ban like that first week. And I remember trying to calls from friends and clients saying, my husband's mid-flight, what do I do? So that's why we're saying try to get your travel done by January 20th, because then we'll all sort of like hold down and figure out what's going to happen after that. I don't know. There's what we know and what we don't know. I can just tell you from experience and having gone through Trump 1.0, and then you have to make a decision for yourself.
Right. I mean, everybody's really stressed out and people are really worried what might happen, because the 1.0, everybody saw what all happened in the 1.0, and now they're really scared because he and his administration has gone out there and said each and everything what they're going to do. So now people are really worried. So, but we'll have to see what might actually happen, what might actually take place. And but I don't think so. But Ruby, before I take our other viewers' question, I would also like to know from you that people are really into this chaos mode and have gone very chaotic. So to help them, understand things, what would you like to tell them, that how should they ease it? And I mean, and be like not go into that chaotic mode and like be a little calm down.
Well, I think the best thing would be to, because see, fear is a paralysis. And that's what I really became so evident when I was at the detention facilities during the family separation era. And that was what it was done intentionally. It was done to cause chaos and fear to the parents as a weapon of emotional and distress. And unfortunately, that's a lot of Trump's modus operandi. He says a lot of different things, and then you don't know which one is he going to do and which ones he's not going to do. So I think there's a little solace in the fact that we've gone through one administration, so we have a little bit of an idea of his playbook. But I think he's had 4 years to get more organized, and he has got Stephen Miller in a higher position. And I think we're going to see a little bit more laser focus on whatever their intentions are. So I guess what I would say is know that they're not going to do everything. Some of it is hot air and a fear tactic. Having a consultation, second opinion, having your documents in order, trying to find good self-care coping mechanisms where you don't let this consume you. Yeah. And know that in theory, this should only be about a 4-year situation. Again, the judges he puts in place, the policies he put in place can last longer than 4 years. But when there's still a room for litigation. And in some cases, that litigation can stall for years as well on different fronts. So I think that's another thing to give you a little bit more pause and to know. It's just that the uncertainty. I mean, I've had a lot of clients tell me, I can't eat, I can't sleep, I'm losing weight, I'm doing this, I'm doing that. And I'm like, I'm trying to just give them as much positive. Let's look at whatever positives, and that, listing off what you're grateful for, the gratitude, I think exercise, I think that's really a lot of what we have to do in this right. Next administration. Yeah.
Thank you for that positive answer, Ruby. And let me quickly take Girish's question. Okay, Rahul is here. He says, thank you, Ruby, for your answer. And then Girish wants to know that any changes expected to U visa under Trump administration, any chance of removal of bona fide determination review process? What do you have to say?
I think, I don't know if I should say this out loud, but I think, okay, if you were just to think, how can you make lives worse for immigrants? And that would be one. It would be get rid of the bona fide determination. I don't know. Will you do it? Will you not? I mean, that was a great program that came out a few years ago, letting people have that work authorization while they're waiting that 10 or 15 years. I hope he doesn't get rid of it. I don't know what he's going to do. But if he were to say, how I want to make things worse for immigrants who are especially U visa applicants, that would be something that would probably be under his playbook. The other one I mentioned before is, saying that just because you have a U pending doesn't keep you safe from deportation. I think that is an easy thing he can tell judges, and then they would have to not use it as as a form of relief that could keep them here. So I don't know. I hope he doesn't get rid of that, but it's probably fair game as a possibility.
Okay. Well, Girish, I hope you've got your answer. Thank you for your question. If you have a follow-up, please continue posting the question. Meanwhile, let me take this other question. This is not related to DACA, but still I would like to take this. This is actually about H-1B. So ZQ says, is there a possibility that the H-1B visa program will be scrapped? I think I saw something about it here in another show.
Well, I don't think so, but I think he might make it more stringent. So let's go back a little bit. One thing that Trump did for H-1B, I mean, he did a lot of stuff with H-1B and employment based, but one thing he did was he created that registration process where the company just puts like a little form, it's not that difficult, and says, hey, I want to put my hat in the ring for this applicant. And so then, then it was like a lottery, right? Chosen. And then only if you were chosen, then you would put the whole packet together. In reality, that made it a lot more cost effective for the companies, I guess applicants, and it was a lot less work for attorneys, because before we had to submit it for every single person, and then they would take the lottery from all the packets. So actually that was one thing that was more efficient. And then there was a lot more streamlining over the last couple of years as well. I don't think he'll get rid of the whole program. I think, and actually just like 2 days ago, there was DHS was strengthening the H-1B program. That's announced a final rule that'll go into effect January 17th, conveniently, 3 days before the new administration goes into effect. I don't think he'll get rid of the entire program. I think he'll get a lot of pushback from business. But I think he could make changes that make it a little bit more difficult to try to, I don't know, in his mind, protect certain U.S. workers. But I think there's a way to have a win-win where you're protecting U.S. workers, you're protecting the U.S. economy by allowing us to bring in skilled labor, and you're still allowing the H-1B program to flourish. So that's my answer.
Well, ZQ, I hope, I think that's a great answer. And ZQ, I hope you have got your answer. In case you have a follow-up, please continue posting it. Meanwhile, let me take the question from Vikas. We already have taken Anusha. So Anusha says the Biden administration announced new rules in 2024 that affect DACA recipients. Eligible DACA recipients can get healthcare insurance through the Affordable Care Act starting November 2024. A new policy on D3 waivers will help DACA recipients who have earned a degree in the US and have a job offer in the field of study to get work visas faster. What, according to you, will change in these rules?
So the have a job offer. I don't know. Some of these rules. I mean, there's a lot of new things. I think right now Biden is trying to get some things out like right now because we're like a month away. But what I've also seen is that a new administration can come in and find ways to try to reverse some of that activity. So I think it goes back to where's the source of power or where's this and how quickly could something be reversed. And so I think that's more of that's probably my answer. So we're just going to have to do a little bit of a wait and see right now. But one thing I will say is that when you do get a new administration, a lot of times it takes some things can be almost immediate. And then for the most part, it took almost 3 to 9 months to change a lot, for Biden to change a lot of the Trump policies. It's almost like turning around a cruise ship or something. Like you've got a lot of bureaucracy, you've got a lot of operations, you've got a lot of training, and you've got to like move things around if you are going to do that, like about face. And so and it's also about prioritization. What is really his priority? You hear a lot of talk about mass deportation. That seems to be a thing that was in the news a lot. I think now that we're getting closer to H-1B season, we're getting some of these rules from the Biden administration, where I think, and also the tech market is trying to advocate for more H-1B, skilled labor visas. I think that we're starting to hear that, but we don't really know what to believe that he's going to prioritize and what he isn't going to.
Yeah, only time will tell. But still, thank you so much for your question, Anusha. I hope you've got the answer. If you have follow-ups, continue posting them. Even after the show is over, we'll still try to give you an answer. We'll share the questions with Ruby, and we'll try to get an answer from her so that we can, reply to the comment. And now RK is also here. RK says, could we see more regulation to restrict immigration, such as removing H4 EAD, removing DACA, wage-based H-1B, remove the CBP1 app, etc.?
Yeah, I think a lot of that's fair game. I don't want to cause, fear, but the H4 EAD was a huge win, right? It was huge. But it took forever to get that. And I think that would be a way, if you were in the playbook of how can I make immigrants' lives worse, that would be one. Getting rid of DACA, that would be another. So a lot of, it's like a death by 1,000 cuts. Like, how can I find a whole bunch of ways to mess it up? I think that's fair game. I think there's like a list. I'm sure they have. Steve Miller, somebody has a list. And they're like, okay, which ones can we do day one? Which ones are going to take a little more effort? Which ones should we focus on? So I believe that as we get closer to January 20th, we've got to sort of filter through the media and the news of what their Homan and Steve Miller or Trump are saying, as to sort of try to get in the mind of what they're going to do. But that's sort of the way I'm approaching it. And then in the way, like if you anticipate, it's just like trying to mitigate risk. If you say, like for example, there's hurricanes in Houston. What do? What's your hurricane plan? What's your flooding plan? Or there's a freeze. If you think about how are you going to mitigate the risk or minimize the amount of damage, then that's the best way to look at it. It's almost like we're in defensive mode, right? Like I think under Biden, we were really, proactive, offensive mode. We could do stuff. There was more options. And now we're going to get back to defensive mode. And we need to be ready to think through what would we do if that were to happen. And then if you think through what the worst case scenario, then it gives you that power because you've had time to think through and you can start visualizing how you can try to find a backup plan for that.
Right. But Ruby, I mean, is there a possibility or are there any steps that Biden administration can take to mitigate the impact of an unfavorable favorable ruling?
On which thing? On the
Let's
DACA
say
or which thing?
Yeah, the DACA. Yeah.
Well, like we mentioned, Trump's been very inconsistent, and just recently he sounds like he's a little more pro DACA this last week or two. I mean, I've literally been shocked. Even I've talked to non-attorneys about it, non-immigrants about it, and they were shocked too. I think in the wild scenarios that could happen, what if they were to actually pass a DREAM Act? It might not look like the DREAM Acts that the Democrats were proposing. But I mean, if they have the House, the Senate, and the White House, I mean, what's to keep them from doing that? I mean, it might be more restrictive, might be more limited. But I think you got on one hand, Fifth Circuit says no, Supreme Court says either no or doesn't listen to it, and Trump says let's get rid of this. Depending on the arguments, though, is there any more room for litigation? I think that's the other question: would there still be room for litigation? That could tell you whether or not there's room for more delay or not. The other scenario could be, maybe it's wishful thinking, but let's go there, is they pass a DREAM Act, and then woohoo. But it could be more limited so that it doesn't encompass all the DACA people. And that's one thing that we have to remember, because under the Democratic DREAM Act, it encompassed more than just the DACA recipients. And that was what was nice, because it was a bigger pool, because there's so many dreamers who haven't been able to take advantage of DACA.
Right. This takes me to this question from the viewer, Nidhi Sinha. She says, I have been a DACA recipient for years now, and I keep hearing about challenges and potential reforms. Should I be worried about losing my status in 2024? Or is there any hope for permanent protections this year?
Well, I think it's related to a lot of what we've mentioned already. Find a backup plan. We don't know what's going to happen to the Circuit Supreme Court. And there could be a hard stop, or there could be a phase out period. Could be stalled with litigation. And, like we said, Trump seems to be more pro DACA right now, but we don't know if that's going to be the long haul. So, and I think one thing to ZQ's question up here about is new government going to be very unpredictable. I think we got to know that there's checks and balances, right? There's the House, the Senate, the White House. There's a lot of lifelong bureaucrats who've been doing a lot of work, government workers in this space, and there's in the Supreme Court, and public opinion and voters, and just because a president's in for 4 years at a time, there's the House, which is in 2 years, and so that's where people really voice their opinion as well. And so I think the government is stable. It's just the unpredictable part, I think, is really on on Trump's policies, is more of some of the quasi unpredictability. But we do have a little bit more of a good playbook because of how we've seen him be the president before. So.
Right. I mean, well, talking about Trump, he has always been unpredictable. And so we can't, ZQ, to answer your question, I mean, Ruby has already answered it, but thank you so much for your question. Let me quickly take Nidhi's question because we don't have much time. Nidhi says, moreover, what can DACA recipients do if they believe they have suffered discrimination in the workplace due to their immigration status? What do you have to say?
Well, I think this is a employment law matter that's not in my purview. I would say have a consultation with an employment lawyer and explain and go from there and see what happens. There was a deferred action for labor violations under Biden that came out a couple years ago, but I think you're better off exploring the employment lawyer first and then seeing if that other option is still going to be available. But that one is to help give people a status if they don't have one while they're waiting for possible investigation and litigation. So, yeah, so I guess what we have maybe one or two questions, or we're almost at the top of the hour. I don't know if we
Right.
missed something.
But yeah, I would also like to know from you, Ruby, that are there any, because, I'm sure a lot of people, and especially the DACA recipients, they want to know what legal resources are available for them. So if you can please mention, are there any specific legal resources or organization that DACA recipients should connect with for support?
Well, I think let's see. There's I'd say you can always look to the American Immigration Lawyers Association, AILA, for information, reliable resources. They also have a directory for attorneys. There's a lot of different groups that support dreamers. I don't have like one specifically. Sometimes some of them are more regional as well. I would say that it is good to frequent the ACLU website and for like know your rights and seeing what they're up to in terms of like litigation, the American Civil Liberties Union. And then one thing I think is going to happen under Trump 2.0 is that the advocacy groups are going to do more of a divide and conquer approach for litigation, like federal litigation. So that we're not spread thin all over, but we're more of like a targeted. So different groups are going to take different litigation and to be able to divide and conquer. So AILA is a great resource, ACLU is a great resource, and then having having a good consultation with an experienced immigration attorney and a second opinion, I think are all really good advice.
Okay, thank you so much for answering that question. Ruby, one last question before I let you go. So, because I know we have already talked about it, but any last suggestion or advice for the DACA recipients? What strategies should they consider to protect their legal status, given the ongoing litigation?
For all statuses, I think, or for DACA,
particularly for DACA.
Renew early if you can, probably. That would be smart. I've already gotten your advanced parole, hopefully, if you didn't enter legally, and have a consultation to evaluate what your backup plans could be, whether it's through if you're if you're married to a U.S. citizen, if you have a 21-year-old American child, if maybe your company wants to sponsor you. Could you maybe switch to some other visa? It's really important to know how much unlawful presence you've had and your entries and exits. So it's all connected. I would just say consultation, find a backup plan, evaluate, know what your rights are, and continue to monitor the news. But I think of all the communities, DACA recipients and dreamers really do have a place in a lot of Americans' hearts, and I think that they will. I'm hoping that it will continue to prevail in some respect, and that if not, maybe in this administration, in the future. But I mean, it does give me hope that probably 500,000 of the DACA recipients found another way. I think many of them did to a pathway, and so I think by having had this status, being able to have the advanced parole, more time here in the U.S., I think it's allowed them to have more options. And so I think that's just that having backup plans, knowing your rights, and continuing to stay abreast of the news and reliable sources, and making sure that you're not getting into that, that sensationalism that sometimes
Yeah.
can happen. So making sure you're level-headed, trustworthy resources. And I mean, I'll just say, like, we do have a TikTok, Facebook, Instagram. Like, we're putting out a lot of content out there all the time of just I don't know if I could show that screen real fast, but like we want to be a resource for the community, even if you don't become a client, because we know that the information is power.
Right. Thank you so much again, Ruby, for all that information. It was so great having you. And guys, if you want to get in touch with, I think Ruby wants to share her screen, and also show you the platforms they share the content in. So Facebook, Twitter, and then Instagram, TikTok. So make sure that you follow all these platforms, Blue Sky. So make sure that you follow all these platforms, and yes, get yourself updated with everything that is going on in the immigration world. And with that, you can also, of course, subscribe to Immigration and Jobs Talk Show, because we come up with these shows and we make sure that you are updated with everything that goes around in the world in the immigration field. So thank you so much, Ruby, for being here. And guys, if you want to get in touch with Ruby Powers, you can dial the number 713-589-2085. I repeat the number 713-589-2085. You can also email her. Her email ID is contact@rubypowerslaw.com. And you can also visit her website, which is www.rubypowerslaw.com. So make sure to get in touch with Ruby for anything related to DACA or any immigration related cases of yours. But thank you so much, Ruby, for being here. It was so great having you. I mean, it was your first episode, but I really enjoyed this doing with you. I hope you can be back soon. Thank you so much for being here.
No, I appreciate it, and I'm glad to get all these questions. I want to be a resource for the community out there. Really great questions. Really had made me thinking on my toes. Rajni, thank you so much for having me and the team. And yeah, let's do it again. Love to be a resource.
Thank you so much. Thank you so much for your kind words. And we are hopefully will be having you back, I think, now in 2025 next year. So until we meet again, happy holidays, happy new year, and Merry Christmas, Ruby.
You too. Thank you.
Thank you so much. Guys, thank you so much for joining us on this amazing webinar. We are going to be back with Ruby with another great webinar. So make sure that you subscribe to our channel for all the updates, everything related to immigration and all, so that you receive all the updates regarding the shows with Ruby that we are going to do. So make sure that you subscribe to our channel. And for now, I'll have to take your leave. Wishing you all happy holidays, Merry Christmas. And also, I'm going to be back before that too, but still wishing you that. But for now, I'll have to take your leave. Bye for now. Take care. And always keep watching and keep subscribing to Immigration and Jobs Talk Show. Immigration and Jobs Talk Show. I am Rajni Bharara, your host. And before I move ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right. Welcome back, everyone, to Immigration and Jobs Talk Show. We are thrilled to have you join us for another insightful episode. Today, we are tackling a topic that's set to redefine global talent mobility. How important will the O1 visa be in the next 4 years? Well, insights from an experienced immigration attorney. Returning to the show is someone who truly embodies expertise and resilience, the remarkable Ralph Antonioli. In his first appearance, Ralph captivated us with his incredible journey and unparalleled knowledge of immigration law. If you missed it, let me remind you why he is a leader in his field. Ralph is an immigration attorney with nearly 30 years of experience specializing in business immigration, sports law, and creative visa solutions. As the founder of Antonioli and Associates, based in Washington, D.C., Ralph has guided countless extraordinary individuals through the complexities of the O1 visa process, boasting an impressive 99.9% approval rate. But Ralph's story goes beyond his profession success. As an immigrant himself, he understands the challenges his clients face on a deeply personal level. His journey is one of resilience and inspiration, overcoming life-threatening medical challenges to rebuild his career and dedicate himself to advocacy for both immigrants and disabled professionals. So, in this episode, Ralph returns to share his expert insights on the future of the O1 visa, the extraordinary ability visa. As industries worldwide compete for top talent, this visa is becoming a cornerstone for innovators, artists, athletes, and visionaries seeking opportunities in the US. What role will the O1 visa play in the next 4 years? How can individuals and employers adapt to this evolving importance? And Ralph will also provide answers, predictions, and actionable strategies. So, whether you're a returning viewer or tuning in for the first time, get ready for engaging discussion with valuable insights. So, without any further ado, let's welcome Ralph back. So, welcome back, Ralph, to Immigration and Jobs Talk Show. We are again delighted to have you with us, to explore on this very important topic.
Thank you, Rashid, for having me. I'm happy to be here and hopefully I can provide some insightful information and at the same time put people at ease because there is a lot of noise out there and sometimes people need a little bit of reassurance that despite the challenges that we may face, they're not alone and immigration lawyers are you know ready for whatever is going to come. What the next 4 years are going to be
Mhm.
challenging, but we're ready. So I'm really helpful and grateful for to be in a position where I can help my fellow immigrants to
Mhm.
secure their dreams to come to the United States, work here, and find a way to
Mhm.
um, find a better future.
Uh, right, Ralph. Before we get into the topic, I actually would like to know because you have been an immigrant yourself, and then you decided to become an attorney. Maybe because of the challenges you saw being an immigrant, is that why you decided to become an attorney yourself so that you can help the immigrants, or or there was any other reason behind that? I mean, before we get into the topic, I would like to know this from you.
Yeah, absolutely. Yeah, this is a great question and interesting because I came to the United States in 2004.
Hmm.
My background, I was already a lawyer in my country, Paraguay. So my background was in criminal law. I was working as an assistant prosecutor.
Hmm.
So I came to the United States in 2004, with your typical immigrant story. I came with nothing. I didn't even have a resume. So um I was struggling to find a job, and because I speak 5 languages, somebody said, "Why don't you try immigration?" And I thought, okay, I will do immigration law
Hmm.
um, for a little bit, and so then I got involved, and then I really loved idea of helping people out. And then at the same time, I was like, if I do my own papers, nobody's gonna, it's gonna be easier for me. So here I
Mhm.
am, 20 years later, I'm still doing it, and just just launched my own firm. And
Yeah.
yes, that's why I became an immigration lawyer, because I like to help people, especially people who are in my shoes. Like I always say, when I take a case,
Mhm.
I know what's at stake. So, and I treat that case as if it's my own case. So, because I never had that. Well, when
Yeah.
when I came here. So, I mean, everybody can say they're an attorney, but unless you actually been, I think that makes a difference. Like if you have been through the process. I mean, I came in, I was in H-1B, then I did a, I went through the permit process, then I became a permanent resident, and then about 10 years ago, I became a US citizen. So, it was, um, it wasn't, it wasn't an easy road, but it was a worthwhile journey, if you will. So, yeah, that's sort of how I got involved in immigration law.
I mean, that's a beautiful, inspiring story, Ralph. But I would also like to know from you that, I mean, was it difficult back then, or has it become more difficult now to, get into the country and to, live your life as an immigrant?
Well, they're not going, I mean, a lot of the audience is not going to believe what I'm going to say, but when I came here, there was no H-1B lottery. I mean, there were so many unused H-1B visas,
Hmm.
that I remember I applied in August.
Oh.
Back then, and I still got my H-1B. Then, a few years later, the lottery started, and it was April 1st. Um, I mean, for those who don't know, now the visa process has changed, but back then it was, between April 1st and I guess September 30th. So usually by the first week of April, all the visa numbers will be gone. But when I came, I didn't apply until August. So I mean, um, so I mean, in response to your question, I would say, yeah, it was probably easier in a way, but
Hmm.
I think the challenges are still there. Even though there's the United States loves to say that it's a country of immigrants, the immigration system is far from perfect. I mean,
Yeah. It has its loopholes. I mean,
yeah.
which not needs to be discussed, and which of course needs to be talked about, and that is what we are doing in the show today. And today we are covering, everyone. We are covering about O1 visa and how and what O1 visa is going to be for the upcoming 4 years. So stay tuned with us. We are going to ask a lot of questions from Ralph, and he will be definitely helping us with really great, insightful answers. So stay with us. And I can see already that a lot of people are here with their questions. Harsha is here, and then Purnima is here on LinkedIn. And Purnima has a question, Ralph, about her nephew. So, Purnima, please stay tuned with us. We have a lot of questions that we would like to ask from Ralph. And after those questions, we definitely are going to dive into the viewer's question. So please stay here, keep on listening to Ralph's answers, and yes, we will take your questions, but in a bit. So, Ralph, my very first question to you. I mean, I know everybody, I mean, people already know what O1 visa is, but for the ones who are joining us for the first time, or for the ones who are a little confused about what exactly O1 visa stands for, could you please tell them again what O1 visa is?
Yes, absolutely. The O1 visa is a category for what the law says extraordinary ability people. What does this mean? Um, this is what I like to call a statutory dance, meaning the regulations are, basically describe how someone qualifies as a O1 beneficiary, if you will. Um, so the O1 visa is divided into two: the O1A, which is a visa for those individuals with extraordinary abilities in the sciences,
Mhm.
education, business, and athletics. The O1B, on the other hand, is for people in the arts, motion pictures, and television. So, depending on what the field of expertise is, then you decide whether you go on O1A or O1B. Now, um, there are, depending on the field of expertise that a person has, um, that's when you decide to, that's when you, in the first that you decide what your field is. Then, as I explained in the first episode, the critical part is to narrow down the person's field as much as possible. So the narrower you can make the field, the higher the chances are to get an O1 visa. So, for example, if you say I'm an expert in AI, that's not narrow enough. I mean, you can have potentially millions of people who qualify for that. But if you say I'm an expert in developing this type of language or this type of, there may only be like 5 or 10 people. That's the goal, and this applies to both O1As and O1B. So in short, the O1 category is for people who possess extraordinary abilities, but at the same time, extraordinary ability does not mean this unattainable level of expertise. It's just um, it's a way. I mean, it's a way to show how a person, based on a number of criteria, depending on whether the person decides to go with an O1, O1A or O1B, does. So again, this is why I want to emphasize that no matter which route you decide to take, working with competent and experienced counsel is critical, because the person may be extremely experienced in its field, but at the end of the day, it comes to an immigration lawyer to put together a great petition. So I hope that answers the question. We can go into more detail if you want, but basically is for people who meet the definition of extraordinary ability. And if you want me to expand on what that means, I'm happy to do that.
Thank you so much for answering the question, Ralph. You have very well explained what O1 visa is. So, please, because sometimes with extraordinary ability, people do tend to get confused with what exactly comes under extraordinary ability. I mean, there are artists, there are athletes, there are sports people. I mean, so many people are there, and then some people do fall under extraordinary ability. But then there are people who also get confused with what can be termed as this extraordinary ability. So, for them, if you can please clear the confusion.
Yes, absolutely. So extraordinary abilities, again, you have to look at whether you're talking about an O1A or an O1B. Again, the O1A will be for individuals in the field of sciences, education, business, or athletics. For um, extraordinary ability in those for O1A, that means that the person is among a small percentage of people who have reached a level that is not generally available. Meaning, this is why I said that narrowing down the field of expertise is critical. So, if you, for example, if you have an expertise and there's the ideal for an O1A will be, and even for an O1B too, but the idea here is say, okay, define your field of expertise in such a narrow way that when you present your petition to USCIS, you are arguing that there are literally like 5 people in the whole world that do this. That is the goal. And when it comes to O1Bs, it's similar, not identical, but it's similar because you're looking at the arts and the motion picture and television. What the regulation require is a level of success that is not typically um, found in the field. So um, again, I want to emphasize that if you have one, for example, going back to the O1A scenario, if you have one, for example, a like an Oscar or uh, this is O1B, sorry. So if you go to the O1A, for example, if you won a Nobel Prize, or
Mhm.
if you have won the World Cup, or something that has to do with the sciences, like a major recognized award, that's all that you need. Then, if you haven't, then you have for the O1A, you have 8 criteria that you may meet, and you only need to meet 3. Um, when it comes to O1B, it's the same idea. With I said earlier, for example, if you want an Oscar, that's all you need for an O1. If you don't have an Oscar or a Grammy or one of those internationally recognized awards, then in that case you have 6 criteria that you can choose from, and again you only have to meet 3.
Mhm.
My in my experience, I've done, I would say, over 100 O1s, and my approach is always, okay, let's meet at least 4 out of the 8 or 6. That
Mhm.
way, if the immigration service doesn't count one of them, you at least have another one, at least one more to fall on. So that's, I mean, you don't necessarily have to be a superstar, if you will. Maybe that's where your question was headed. All
Mhm.
you need to do is work with competent counsel and put together a pretty reasonable and strong application. And again, if you don't have like a internationally recognized award, or um, there are still other criteria you can meet. That doesn't mean
Mhm.
so basically that's I hope that's the answer you were looking for, because
Yeah.
I mean it's a little more convoluted, but again, what I want to emphasize is the fact that it's a statutory dance. And what do I mean by that? It means you basically have to check boxes. Of course, unless you have a major award or um, recognition, but at the end of the day, it comes down to how many boxes you can check out of the criteria.
Right, right. Thank you so much for that detailed answer, Ralph. It very well explained what extraordinary ability and also the differences between the different O1 visas. So thank you so much
Mhm.
for that. And with that comes my next question, Ralph. And I would also like to know from you that what is the typical processing time for an O1 visa petition, and how can premium processing expedite this process?
Yes. So right now, and again, these are just estimates based on what USCIS information provides. Um, O1 petitions, um, unlike, for example, and I want to start with this as a foundation. O1 petitions, unlike an H1B case or an H1B petition, can be filed at any time. There is no, for example, the H1Bs, at least under the current system, there you have to apply in March. If you get selected, then you have 90 days to apply. So there is a time limit there. When it comes to O1s, you can do it at any time. And when it comes to processing times, based on you have regular processing and premium processing. So let's tackle regular processing. Means you send your application, um, paying the regular fees. Um, and right now, the processing time is approximately between 4 and 6 months. Again, this is just a rough estimation based on current processing time. Uh, Once the new administration comes in, this time is this 4 or 6 months is very likely to increase, because there will probably be a lot more scrutiny.
Mhm.
Um, but the option to expedite this is to file with premium processing requests, meaning by paying right now an extra fee of $2,500, um, you are USCIS, which is the immigration agency that grants O1 petitions. guarantees that within 15 business days, they will adjudicate the petition. What does adjudication mean? Adjudication means either approving the case or requesting additional evidence, which often referred to as an RFE. Um, some people like to say that the third option is a straight denial, but to be honest, a straight denial, unless you present a really weak case that has no basis in law, uh, will be the case. But I mean, honestly, in my experience, out of the every case that I've filed, I've never seen a straight denial. I mean, RFEs, yes, but denials, no. So that's basically the difference. It really depends on how quickly you need to be in the United States.
Mhm.
Um, so that's basically what your options are. Um, if you do processing time, again, please be mindful that this is going to take, under the new administration, at least 6 months. So, um, and again, I want to also say that in my experience, I would say 99, if not 100% of the O1s that I filed were filed under the premium processing because there was a timeline with the employer and so those are the two options right now. And it all comes down to how quickly the person needs to be here. Um, what project the person is going to be involved in, and so things like that. So those are the two options right now.
Right. Thank you so much again, Ralph, for answering the question. And I see ARD here. He says, hello, sir. Hello, ARD. Please let us know what your question is. Please feel free to post it in the comments below. And yes, we'll be taking your questions. Um, Okay, so he has posted his question. We'll be taking out that in a bit. But before we take that, Ralph, I would like to come to you and ask you that while you are answering the question, you were saying that until and unless a case is weak, only then, it's difficult uh, to get it approved. So when you say a weak case, what exactly makes a case to be weak, especially, if it's an O1 visa case?
Yes, happy to explain. So like I've been indicating since the beginning, it is very important that you work with competent counsel and that your counsel have experience in O1s because O1s, although can be intimidating, if you work with someone who has done it before, it's easier. Easier, and again, you got to take the word easy with 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 white gloves because they're um, so in my experience, what I've seen when it comes to weak cases will be, for example, where the case is disorganized. There is no, I mean, that there is really no correlation between what you're saying in your letter of support and the evidence you're providing. So this is why it's critical that you work with someone who is experienced in O1s and who knows how to prepare strong applications. Another thing that may make a case extremely weak is sending reference letters that are just too general. For example, if you're going to show that that you have influenced the field, typically you show that by providing letters of recommendation for people from experts in the field. And sometimes if the letter is too general and it doesn't really go into the nitty-gritty of what you do and why you are an extraordinarily person, then the then your message gets lost in translation, if you will. Excuse me. Um, the other thing is um, not sending um, proper consultation letters. Uh, if you're not familiar with what a consultation letter is this is a requirement that the O1 visas have for if you want to come in and work in expertise X, you will want the the organization that represents professionals in that field in the United States to provide you with a letter of consultation letter. So, for example, if you're an NBA player, you will need a letter from the NBA Players Association. Or if you're an engineer, you may need a letter from the engineering union in the United States that they um, that they are okay with you coming to the United States. That's basically what it is. Um, so sometimes the person gets a letter uh, from the wrong agency, so that really hurts the case. For example, if you present on a word that it's really not, um, you say it's something that it's too local, um, and it's not really. So, for example, what I'm trying to say here is, if you, like I said, you got to go criteria by criteria. So, at the end of the day, it's it's how you present your case. You have to be as meticulous as you can. Make sure you go step by step, and just present a case that um, the person who's looking at it will say, "Okay, we have a case here," and ideally, you will want an approval or, worst case scenario, an RFE. So, I mean, I hope that answers the question. At the end of the day, it's all about being meticulous
Right.
and working with competent counsel and making sure that you're crossing your T's and dotting your I's. So that's what it comes down to. So
Right. Thank you so much for answering again
yes.
question, Ralph. And guys, I see a lot of questions from you. And if you would like to ask a question, you can also to Ralph. You can also dial this number 425 I would like to repeat it 425 and you can put the access code 988888. Yes, 9 5 times 8, and you'll be joined us through call, and we'll be able to put you through, and you can ask your question directly to Ralph on call. So yes, make sure to give us a call on this number if you would like, if you won't like to comment, or if you would directly like to ask a question, by calling. So yes, dial this number and give us a call. Okay, now without any further ado, let me directly delve into the viewers' questions, because they are also eagerly waiting for it. And maybe Ralph, after this, I'll take my own questions. So let me quickly take ARD's question first, and then I'll take Purnima's question. So ARD here says, "Hello, sir. Do you anticipate changes to EB to NIW? I have an approved NIW. I mean, this is not related to O1, but if you would like to take this, would you like to take this, Ralph?
Yes,
I
absolutely.
can read the whole question.
Absolutely. Yeah, I can see the question. The answer is yes and no. So, um,
Okay.
so yes, the change will be probably a lot more scrutiny. Um,
Yeah.
so your national interest waivers, as you can imagine, a new administration has different priorities. So again, it all comes down to um, how you present your case and if you work with. And to give you a real life example, for example, I recently worked on a national interest waiver, the NIW, for someone from Russia, and
Okay.
and one of my arguments was that, and this was before the election, um, that this person was working in democracy building. Okay, and we tied that to the Ukraine-Russia war and how Russia is using misinformation to influence the United States electorate. As you can imagine, after the election, uh, these priorities changed. So, I mean, my case is not going to be as tough now because, so than if it was before. I don't know how much in the national interest. Um, Personally, I think it still is, but again, it's just how you frame it. Um,
Mhm.
and the no portion of my answer is because the law is there. They can't magically, as much as they want you to believe, they cannot just, magically with a wand change the rules, and that's not how it works.
Mhm.
So, on that, in that aspect, I don't think national interest waivers are going to change at all. Again, at the end of the day, work with competent counsel, um, follow his advice, and you know. Um, be prepared to respond to RFEs because I know the RFEs are going to increase. But
Yeah.
other than that, I don't think you at the end of the day, if you have what the law requires, you have it. There is nothing one administration or another can do. The law is the law, and that's it.
Yeah. But he also goes on to say that do you anticipate changes to EB2 NIW? I have an approved NIW. And will Trump government prioritize EB2 NIW towards getting green cards faster? I am from India. I have 10 years of experience, did my master from a US university, and been on H1B for 7 years.
Okay, so is that the same person or
Yeah, that he's ARD. Yeah.
okay? Well, so as you know, the visa bulletin changes every month. Um,
Yeah.
Unfortunately, we don't know what, or despite what you hear out there, we really don't know what the Trump administration is going to do. And again, unfortunately, they can't just use a magic wand and make every date uh, current. So I don't think that's going to change dramatically. Um, although I've heard that they're trying to restrict family-based immigration. For example, they only want to keep it. And again, this is what's just out there. Please don't take this as the law. I'm just sharing with your audience what I've heard from my
Mhm.
colleagues that because right now, for example, you can apply if you're a U.S. citizen, you can apply for your child, for your spouse, even for your siblings. So they're trying to get rid of some of those categories, like for siblings and adult children. So my thinking will be, okay, if they get rid of those visas, maybe they're going to get, use those numbers for employment based. But again,
Mhm.
this is these are just suppositions, if you will. These are just, I don't know what they're going to do. Unfortunately, um, nobody really does. So at this point, it's just predictions. People say we're going to experience the same thing that we did in Trump 1.0. I don't. I think this time is going to be different. I'm not going to say it's going to be harder or it's going to be. It's just going to be different. I mean, yeah, not only when I work, but in my personal life, I take a day by day approach. So I think that's probably the best way to tread carefully and see what. Um, and I think, like I said in our first webinar together, I said, the before you believe anything that's out there, please call your immigration lawyer first.
Yeah.
um,
Every time.
and because sometimes, you know, uh, you can tell by the way someone writes that they don't really understand how visas work, and that's just the reality. So that's why
Yeah.
I urge your viewers to not believe everything that's out there, but reach out. My information is here. So if you have any questions at all, if you're not sure about something, feel free to shoot me an email and I'll be happy to guide you. So,
Absolutely. So, guys, especially now on, there is going to be a lot of clickbait news. So, make sure to not believe in everything that you see over the internet. And if you have any confusion regarding anything and you're not confirmed about that news being true or not, make sure you can also you can reach out to Ralph, of course. And if you have any case, whether you're looking for an attorney regarding your O1 visa case, if you have that, so for that also you can reach out to Ralph for a consultation. His contact number is 240-898-2288. I would like to repeat it: 240-898-2288. His email is ralph@antonioli.com. Yes, Ralph at antoniolilawfirm.com. And you can also visit his website, which is www.antoniolilawfirm.com. So make sure to get in touch with him regarding any question or confusion that you have regarding your case or a news over internet. So get your confusion cleared.
Yeah.
Now, after ARD's question, I can see Shiva Prasad here. Shiva says, "What is O1 visa?" So, Shiva, I think this question is already taken by Ralph, and he has already answered this in a lot of detail. So, in the beginning of the episode, so you can rewatch that, and you will be getting a beautiful answer explained in detail by Ralph about what O1 visa
Yeah,
is. And
if Shiva wants to
mhm,
shoot me an email, I'm happy to provide him with an overview of what it works, and we can even schedule a call to talk and see how if he will qualify. What I want him to know is that O1 visas is not just for the superstars or the people who are. This is for people who have a strong background that can meet what the requirements of the law says. So at the end of the day, it's a checking the box exercise. So
right.
yeah, so feel free to reach out to me, and we can discuss that in further detail.
Right. So, Shiva, make sure to write an email to Ralph about the question that you have regarding O1 visa. Yes, like you said, he'll be more than happy to connect with you and to give you a detailed answer. With that, let me take my next question. My next question is from Purnima. So, Purnima says, my nephews have completed MS in US and completing as well. Um, is it easy for them to change their student visa to work visa? As I'm not aware of updates, I'm trying to help them with updates. Thank you.
Yes, this is
Ralph, what do you have
yeah,
to say?
this is a pretty it's we have to take this by in pieces. So um
Okay. Please go ahead.
the first question will be um again, this is probably best answered if she sends me an email and we go through the specific. But the first case will be like, what is their major in? Are they in a STEM? Are they in a STEM field? The reason I ask that is because they may qualify for an work permit based on first the CPT and then even OPT, and then you got your STEM extension. Um, Assuming they're in F1 status. Um, then um, to change to a work visa, then I think that's a bigger question, because it really depends on what their field is and whether they have, because the typical route is usually you're an F1 visa, then you secure a sponsor, you move to H1B, then the H1B turns into a perm, and then you get your green card. That's typically the route people who are an F1
Right.
visa status, student status, do take. So I will recommend her that she reaches out to me too, and we speak specifics, because the question is unfortunately too general for me to answer. But I mean, I can throw out general concepts, but again, that's probably not very helpful because I don't have the full story.
Right. Okay, so Purnima, maybe if you can provide more details regarding the case, about what their subjects are, and yes, and other details too, so Ralph can help you with an answer. And if you want, you can also get in touch with him by directly sharing an email. So his details are already scrolling below: phone number, email, and website. So yes, write an email to him or give him a call. Make sure to get in touch with him.
Yeah, I also
Um,
want to emphasize that the immigration process itself is very subjective. So you have to look at every case in isolation, if you will. So meaning, every case is going to be different. Even if you know someone who says who's got his H-1B or whatever it may be, your case is not going to be the same because every case is different.
right.
Every case presents different challenges, different, and I want,
Absolutely.
just because someone got an O1 doesn't mean that, you're going to get it the same way. It's just every case is, well, it's a new story, if you will. So if people understand that from the
Yeah.
get-go, that's helpful.
Right, absolutely. Now, Ralph, I would also like to know from you that are there, because Purnima was talking about switching to a work visa. So I wanted to ask you about that. Are there any emerging industries which are more likely to see benefits from the O1 visa in the next 4 years?
Uh, yes, I think there is a major competition now between the
Okay.
United States and Europe when it comes to AI. Um, and
Mm-hmm.
I think that's going to be major. Um, Again, the United States economy, it's probably one of the strongest in the world right now. Um,
Mm-hmm.
and hopefully the United States will make it easier for people to get their work visas and stay competitive. Otherwise, people are just going to go somewhere else. So I think, always and now that you have Elon Musk being the pseudo president of the United States, um, I think just the IT world is going to continue to, just explode, it for lack of a better word. I mean,
Yeah.
um, the US depends heavily on immigrant work, and again, despite what you may hear out there, you know, uh, IT will continue to play a major role. So that's and when it comes to an O1, um, like I said at the beginning, narrowing down the field is critical. So I
Mm-hmm.
mean, like I said, if you just say I'm an expert in AI, well, there's millions of people who are experts in AI. But if you're expert in
Yeah.
AI because A, B, and C, then that's a different story. Um, I think,
Mm-hmm.
and that also plays with um, what what uh, they asked. One of the audience asked about the national interest waiver. You can say that if you have an AI and the O1 doesn't work, you can always try the national interest waiver because technology is definitely in the
Mm-hmm.
interest of the United States. So, you
Right.
have two options there, at least.
Right. 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 And also, I would like to know from you, Ralph, that can O1 visa holder work for multiple employers simultaneously?
Yes, they can. This is also one of the advantages between O1 H1B, whereas the H1B, you typically are just required to work for one employer only. Um,
Mm-hmm.
excuse me. The O1 visas holders can work for more than one, as long as each employer files a petition.
Mm-hmm.
Um, there's also uh, the option for multiple employers to work with an agent in the United States. So this agent would file O1 petitions on behalf of both. Uh, so, you know, so yes. So the short answer is yes, they can, as long as they each file their own petition or an agent files on behalf of both or three employees, whatever it may be.
Okay. So, I mean, can this also happen that it might get approved from one and disapproved from another?
Of course.
Scenarios like that, this can also happen?
Yes, of course. Because it's
Then,
because
then,
if
then
it,
what should the person do?
well, well then if the person does that, then he will probably have to um and this goes back to like how many hours it's going to work for one, how many hours for the other.
Yeah.
Um so if you only have one approval, then you can only do that. You know what I mean? You can't um because what I said, you know, let's say company A files, company B files, A gets approved, B gets denied. You can only work for A.
Right.
Okay, if you're ever going to work for B, either B has to refile or you just can't. That's I mean, because you need an approval from both companies to work for both. Otherwise, you can only work for the company that has the approval.
Okay. Okay. Thank you for answering the question, Ralph. And also, Harsha says many startups are now led by talented founders from abroad. If I'm an entrepreneur seeking an O1 visa, do my achievements as a business owner qualify? Or does it only apply to more traditional definitions of extraordinary ability?
That's an excellent question. No, if she has been a successful startup, um, you can again. I'm not sure if she was here when we started talking about the different criteria to meet the extraordinary ability definition. But if the person was extremely successful in its startup, then you can meet two criteria. One of them being that the person was employed in an essential capacity. They can show that. That would be one criteria. The other one will be that the person's startup has provided was influential in the field. So then you would have you could potentially meet two criteria. Then you will just need to meet one more out of the eight. So yes, absolutely. If the person is an entrepreneur and has obtained some level of success with this um, startup, that is definitely something that can be used to meet at least two of the criteria of O1A in business.
Okay. Well, Harsha, I hope you have got your answer. Thank you for your question. If you have a follow up, please continue posting it. Let me take Sanjay's question too. So, Sanjay here says considering the increasing scrutiny of high skilled visa categories, how can O1 visa applicants and petitioners proactively prepare for potential changes to the visa requirements? And what strategies can be employed to strengthen O1 petitions and demonstrate extraordinary ability required for approval, especially in cases where the applicant's achievements may not fit neatly into traditional notions of extraordinary?
Great question. Yes. So, the like I said at the beginning, the best way to prepare is to be as meticulous as possible. So, for example, if um, if you don't have an, for example, if let's talk O1As, which is probably the most common route that people take. For example, in the sciences, where IT, for example, will fall. Um, you need to show 3 out of 8 criteria, unless, of course, you have like a Nobel Prize or something like that. So, for example, um, membership in associations that requires outstanding achievement. Um, Proactively, you can start looking at fellowships in your field. Um, Look at what is required to become a fellow at one of your at one of the organizations that it relates to your field. For example, employment in a critical or essential capacity for organizations with a distinguished reputation. This is another criterion for the EB1A. Sorry, O1A. There you can, work and make sure that your work is pretty much essential to or critical to the organization you're working with. Um, you also have, you can also participate as a judge working, um, to for basically, yeah, you kind of give your opinion and other people's in your field. That's another criterion that you can meet. Like I said, this is a case by case analysis. Um, like I said, you have 8 criteria. You only have to meet 3 to qualify for an O1. Um, so whether there will be, and the other portion of the question is whether there will be changes to the O1. I'm not sure. Because to be honest, we not anyone, nobody really knows how they're going to change. But I suspect that O1s is probably going to be left untouched. I mean, there will be more scrutiny, which is why it's critical to prepare and put together strong application. But I don't think they're going to, for lack of a better word, I don't think they're going to mess around with the requirements.
Okay. Well, Sanjay, I hope you've got your answer. Thank you for your question. Continue posting your follow ups if you have any. And Purnima is back and she says, yes, I will check with my nephews and update based on their interests. They are in technology for MS. Okay, let me quickly take Anjali's question here also. But meanwhile, Ralph, would you like to add anything to this?
Yes. If the next question will be whether they have already secured their work permit. I mean, looks like if they're in technology, that's definitely a STEM field. So they probably, if they're an F1, they'll probably qualify not only for their OPT, but for their STEM OPT, which is a 2-year work permit. Usually that's the gateway to an H1B. You work for a company that's in your field, and then they kind of, you kind of make your presence known there, and then that transitions to an H1B. So again, I I suggest that she reaches out to me via email, and we can take it from there. Because
Right.
it's there are some information that we would need to determine whether, like, what is their current status, like exactly, do they have work permit now? I mean, see, you know what I mean? That may change the conversation. So
Right. So, Purnima, make sure you get in touch with Ralph because he also needs a lot of details from your side, which is not possible to cover in the show right now. So, get in touch with him, write an email to him, and he'll be able to help you. And let me take Anjali's question next. She says, "What are the potential consequences for an O1 visa holder who, after entering the United States, undergoes a significant change in their career or field of expertise, such that their work no longer aligns with the original basis of their O1 petition? And how might this impact their ability to maintain and extend their O1 status or transition to a different visa category?"
yeah,
What
this
would you like
yeah
to say, Ralph?
yeah this is an excellent question. And I want to start by saying that one of the advantages of the O1 is that there is no limit. For example, no limit as to how long you can stay in the United States. For example, the H1B is typically for 6 years. The
Yeah.
O1, it's initially for 3 years, and then um, you can extend indefinitely for 1 year increments. But here's the question. Here's the most important part. In order for you to continue to extend your O1, um, you need to continue working in the field that got you your O1. If what you do materially changed, then you may no longer be eligible for an O1 and would either be required to change your status to like an H1B or leave the United States. I mean, those are the options. If you are no longer doing O1 work, that's kind of tricky because um, then you have to consider what are your long-term options. Um, 'cause I sort of want to pivot here a little bit and say, if you have a strong O1, the idea will be for you to strengthen your external ability so that you can eventually get an EB1, which is
Mhm.
um, sort of like an O1, but the EB1 is to get your green card. So yeah, I mean that's the easiest question, the easiest way to answer it. If your extraordinary ability duties, let's say, change dramatically, then you should probably consider changing your status right away, or worst case scenario, you may even have to leave the United States to avoid any issues later on.
Okay. Anjali, thank you for your question. I hope you have got your answer. If you have follow ups, continue posting them in the comments below. And yes, we'll be taking them. Maybe in the next episode, if we don't have enough time for today, in our today's episode, we'll be taking them in the next episode, or we will be replying to them after getting an answer from Ralph in the comment section. So continue posting your follow ups if you have any. Ralph, with that, I would also like to share my screen and ask some of the Facebook questions, because there were a couple of questions which are asked by viewers on Facebook groups related to O1. So if you are okay, I would like to share my screen and take those questions from the viewers.
Absolutely.
Thank you so much. Okay, so here are the questions asked by people. Can you see my screen?
Yes.
Okay, so this anonymous member says, hello, lawyer. Said my hello, my lawyer said my O1 approved almost 3 weeks ago, but still have not received my approval notice. Also, the USCIS case status check hasn't been updated since they received my RFE. Should I be concerned? This feels awfully long. What do you have to say?
Well, first of all, I would, I will not feel concerned because keep in mind that we're in the holiday season and there is administration transition coming, so things are much slower than they were before. I will give it another week, and if your lawyer doesn't give you an update, I will probably just follow up and make sure he gives you some type of evidence that that the case was approved. For example, if your case was premium processing, your lawyer maybe have gotten an email from USCIS, the premium office, premium processing service, saying that your case was approved. So if he hasn't shared that email, again, if that email exists, I will ask your lawyer, can you please share that with me? That will give you some peace of mind.
Okay. Okay. Thank you so much for answering the question,
Mhm.
Ralph. Next question is from this person, I think. This question is this is about DACA to O1B. So he says DACA to O1B for a Michelin star chef. Initially entered the US with a tourist visa, overstayed, then applied for DACA. What do you have to say?
Well, I have to be in full transparency. DACA is not really um my what's the word I'm looking for here? It's not really my cup of tea, but
Expertise?
but I will so I believe the question is, can I change from DACA to O1B?
To O1B, yeah.
So I will have to do a little research on that because I'm not sure if DACA gives you an actual status. I mean, the fact that you
Mhm.
overstay your tourist visa may be a ban to you changing to O1. But again,
Yeah.
this
In
will
itself is a red flag, right?
this it will based on what I know about DACA, and again, this is really not my number one source of expertise, but I would think the trying to change to an O1B from DACA will be kind of tricky because um, DACA is sort of it's a parole, not a status. But again, I could be wrong. This may require for me to do a little bit of extra research because, like I said, I don't do many DACAs, if any at all. So
Mm-hmm.
this will require a little bit of extra research on my part.
Okay, okay. But still, thank you so much for taking that up,
Yeah.
Ralph. Let's move on to the third one, which is a pretty long question. Okay, but still, I would like to read it. This anonymous member says, "Hello, everyone. I'm currently an F1 student and I'm planning to apply for an O1B visa. I recently participated in a pageant competition where I received around 15 awards, including modeling related recognitions. Additionally, I have collaborated on TFP, Time for Print projects with several photographers to build my portfolio. Next year, I plan to apply to modeling agencies and work towards advancing my career in the United States. I would greatly appreciate any guidance or advice on how to strengthen my profile and prepare for the O1B visa application process. Thank you in advance for your support and suggestions. What do you have to say for this?
Yes. So based on what I see here, she is in the modeling business. So we're going to have to go with, yes, O1B in the arts. We're going to argue that, modeling is within the arts. Um, Again, what I've been saying throughout this program today is that the O1 category is sort of a statutory dance. So I'm going to, um, you have to gaining those 15 awards will be great, but they will, that's going to be one criteria. You still need to meet,
Okay.
you need to meet at least three out of the, um, unless, for example, what we will need a little bit more information as opposed to like say what type of pageant was it? You know what I mean? If it's
Mhm.
like a Miss America or something like that it's internationally recognized, then that's probably all she would need. Um, we could argue that that's an um, internationally recognized event that would, that would allow her to get the O1 just based on that. Otherwise, she will have to work on meeting as many criteria out of the six available for O1Bs to get her a O1A. For example, she would need letters from her modeling agency saying why she is different from all the others. And so, like I said, it's a case by case scenario. We will have to, again, if for example the pageant she participated in is notorious enough, if you will, then that may be sufficient. But again, it's a matter of sitting down and going through what what her skills are and what she has and what else she can work on to continue to strengthen her O1 portfolio if that's the route we're going to take.
Okay. All right. Thank you so much, Ralph, again for answering this question. I think that's it for today. And because, we are almost done with the time too, and I'm sure you must also be busy. But thank you so much, Ralph, for taking all these questions. I still have a lot of questions pending, not just from my side, but also from these groups, from people. So, how about if we do a part two of this episode and discuss the pending questions in the part two?
Absolutely. If you don't mind, I see a question here that caught my attention. It's like a 10-second question, so I will
Of course, of
I, will-
course.
I will
If you have time, we have. I mean, we definitely would like to extend it
yes, I have
if
time.
you
I
are
mean,
okay.
it's up to you. Yeah, I see a question here from Adabi. It says, what is the O1 grace period before leaving the country? Um,
Is this the one?
I believe it's the same person, right?
Right.
Yeah.
It has two parts. So let me read it from the first part.
Hmm.
The first part says, currently on an O1 visa, ending employment May 1st, 2025 voluntarily. My question is, come May 2nd, 2025, I'm no longer employed. Hence, O1 is redundant. How long can I stay in the US? What is the O1A grace period before leaving the country?
Yes. So the first question is, when did the employment end officially? Um,
Yeah.
let's say the employment ended December 1st. Okay.
She says ending employment May 1st, 2025 voluntarily.
Well, she says I'm no longer employed. So does that mean, well, I'm a little confused because she said my question is come. So if you are employed, if your last day of employment will be May 2nd, 2025, then you have 60 days from that date to either change your status or leave the United
Okay.
States. If your employment ended before then you have to count the 60 days from the day of your last employment. So if it was December 1st, um,
Mhm.
then it will have to be probably February 1st. So it's 60 days from the day the employment ended. Based on how this um, ended, this question
Mhm.
is written, I think she's saying, yes. See, now I'm rereading the question. So starting on May 2nd will be the first day over 60 days. So, yes.
Okay.
I actually, I would have a follow-up question saying, are you now, since you said you're going to voluntarily leave, are you now
Mm.
doing O1 work? Because if you're not, then that could be an issue. I mean, this goes back to a question that someone else asked before, saying, what if I stop doing O1 work or something along those lines? How do I?
Mhm.
Well, you have to continue doing O1 or then your O1 will not work anymore.
Valid. Right. Right. Okay. I think this answers the question. I think perfectly. So thank you so much for taking that up for Madhabi, Saha, Ralph. Thank you so
Of
much for answering
course.
the question. And yes, with that, like I was saying before, that we still have questions, um, but because but we would like to do a part two, so that because there are a lot of pending questions also, talking about uh, the permanent path to residency, and how will the O1 visa serve as a permanent path to residency, and then effective strategies for transitioning from an O1 visa to a green card. So I still have, and I'm sure it won't be possible to cover this in 5 or 10 minutes. I'm sure it's going to take a lot more than that. So how
Yes.
about if we do a part two, so that we can take these questions and discuss it in detail in the next episode?
Absolutely. I think we should also, probably, give about a month or so in the new administration. That way we have an idea
Mhm.
of where things are going um
Um,
or something.
sure.
I
Oh,
mean, I'm just
absolutely. We
because
can do
because
that.
because I mean, I would think in the next month is going to be there's going to be a lot of noise. So
Yeah. Yeah. After I think January 20th, if we will have some clarity, if not everything, but we still have some clarity, where are things going, or where will things head towards.
yes,
So yes, we can definitely do a show after the 20th of Jan. I'm going to write back to you, and you can let me know whenever you are available after that, and we'll be scheduling the show. How about that?
absolutely. I also want to encourage your viewers to email me if we weren't able to cover the questions today. Um, I want them to keep in mind that the O1 visa has no cap. and you can file at any time, which is a great advantage. Um,
Mhm.
so keep that in mind. I mean, I'm open to answer any questions you have. I've been doing this for 20 years, so you know,
Absolutely.
sometimes when you think your case is going to go one way, it's not as bad as you think. So please feel free to rely on me to, I'm going to untangle this for you. So thank you for your time.
Right,
And,
right.
I'm looking forward to working with as many of your audiences as possible. So,
Absolutely. Thank you so much for that.
all right.
Thank you so much for seeing that, Ralph. And guys, if you want to get in touch with Ralph, make sure to give him a call on the number 240-898-2288. I would like to repeat the number 240-898-2288. You can also email him. His email ID is ralph at antoniolilawfirm.com. And you can also visit his website, which is www.antoniolilawfirm.com. So make sure to get in touch with him, write an email to him, or visit his website and get your confusion cleared. And also, if you are looking forward to get a consultation, so you can also, connect with him for a detailed consultation. So thank you so much again, Ralph, for being here. It was great having you. Really looking forward to what's going to happen on the January 20th and after that. So excited to, excited for our next show. We are going to cover O1 in our next show, episode 2. But yes, we'll be doing that after the January 20th. So yes, looking forward to that. Thank you so
All
much.
right. Thank you and happy holidays to everyone. So,
Thank you so much. Merry Christmas, Happy New Year, and happy holidays to you too, Ralph. And we'll be meeting you in the next year. So thank you so
yes,
much.
thank you. Take care.
You too. Thank you so much, everyone, for being here. And for now, I'll have to take your leave. We have another show coming up, Daily Immigration Doors at 4 p.m. So make sure that you are streamed and you're tuned with us at that time. And you're also joined with us through call or maybe on the stream, discussing the topic that we have for today. So, yes, I'll have to take your leave for now, but I'll be meeting you very soon. But until then, take care. Keep on watching and keep on subscribing to Immigration and Jobs Talk Show. I'm Rajni Bharara. Bye for now.
Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm your host, Sam, and before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. All right, once again, friends, welcome back to Immigration and Jobs Talk Show. I'm your host, Sam. And today we are going to talk about a very critical topic. That is what legal protections are available to immigrants in the US who suffer from mental or physical abuse. So I think we all understand this thing that many immigrants face unimaginable challenges. And I think it's very important to understand their rights and also the protections under the law. It's very essential. And whether it's domestic violence, workplace abuse, or other forms of mistreatment, there are also laws and rules and resources, to protect these vulnerable individuals. So in this session, It's going to be incredibly important because today we have a very special guest with us who will be shedding light on the legal pathways that are available for those who might not know where to turn. So, without any further ado, let me welcome our today's very special guest, who will be joining us for the very first time, Attorney Obot, a skilled Nigerian corporate attorney with a strong background in business law. She has also worked at one of Nigeria's top law firms, handling important corporate cases, drafting business agreements, and ensuring clients follow legal rules. And currently, she is a legal intern at the Right to Immigration Institute in the US, where she focuses on policy and regulatory issues, adding valuable insights from both corporate and immigration law. So, Emma, welcome to Immigration and Jobs Talk Show for the very first time. It's truly an honor, to have a show with you, and thank you so much for joining us today.
Thank you so much, Sam. Thank you. Thank you. Like you introduced, the introduction was perfect. Thank you so much. I'm so honored to be part of the show, and I hope everyone that joins the show is able to learn one or two things that could help them. But like you rightly said, our the expert advice is not like
Mhm.
legal advice. It's just we're just sharing general knowledge. So I'm so excited to be on the show. Thank you so much, Sam. Thank you.
Absolutely. It's our pleasure. And thank you so much again, MM, for joining us, especially during this holiday season. And we know how much busy you might be this time, but it's still you are here. So I think it's like we are really grateful to have you with us today. And also, MM, I would like to know that before delving into our today's topic and making people aware about the legal protections, uh, as we are know, that it's like wrap up the of this year, and 2025 is just 4 days to go. So I would also like to hear your thoughts that how you're expecting 2025 to be under Trump's administration.
um, for immigration law, because I work at an immigration law firm, Boss Legal Group currently, um, we believe that the policies might change. We're just projecting, like, well, we are optimistic that things like go well. I guess we can only be optimistic,
Mhm.
but we know how his tenure was the last time, and we just hope that immigrants are able to get like policies that can help them to do better, and but we can only be optimistic and hopeful. That's that's
Absolutely. I think being optimistic is very important. And I'm also hoping, that US have a wonderful and prosperous year in 2025. And I think that's all, we can expect and we hope. Yeah.
yes. That's all we can expect and hope. But I think the most important thing is like as an immigrant, I think it's very important for you to seek legal counsel before doing some things. We've had clients at the law firm that maybe took some steps on their own, and then later on they realized there was mistakes in the application.
Mhm.
So that's what attorneys are here for, like to try to help you and look for the best defenses to your claim or your issues. So it's so important you meet an attorney before taking some like legal steps, because sometimes even the forms, I know you see them online, you feel they're just so easy to fill, but like immigration law is one like very dicey
Right.
area of law that needs to be done. Like there has to be attention to details. You have to be very detailed in filling the forms, because any statement you make, like it will be used against you later on. So you just have to be careful, and it's very important to seek the guidance of an attorney that is very detailed. Yes. So thank
Right.
you.
I think that's
That's
beautifully
that's what I
explained. And
expect.
I think, thank you so much, MM, for letting us know about it. And I think it's very important to understand the how much responsible you have to be. But I think, yeah, that's a great start. And with that, I would also like to jump right into our today's topic. And as we are talking about legal protections that are available for immigrants in US, so my first question would be about domestic abuse. So, what can you say on this? That what specific documentation is typically required to demonstrate that someone has been a victim of domestic abuse as an immigrant?
Okay. For would be like, what are the legal protections for for immigrants in the United States? And we know there's VAWA, which is the Violence Against Women's Act that was reenacted in 1994 by the Act of Congress, the U.S. Act of Congress. And then we have also the U visas, which like you have to, that is like the act of Congress trying to be able to punish people that are committing crimes of violence, people that are committing sexual assaults. So the for the U visa, the criteria is you have to be like, you have to cooperate with the legal agencies, you have to cooperate with the police, you have to cooperate with the government of the United States. Sam, are you here?
Yeah, yeah, of
Okay,
course.
sorry guys. Oh, yeah, yeah, yeah. So you have to. Okay, I thought
No,
you
actually,
disappeared on me.
we
That's
have, yeah, we have
yeah.
maximized your screen, so that at that
Oh,
time you are visible to
okay,
our viewers. Yeah.
okay, okay.
Mm.
So the Violence Against Women's Act specifically covers women that are going through domestic abuse, sexual assault, rape from their maybe U.S. citizen partners or um green card holders, legal permanent resident partners. So, and it applies, it has three categories. It has the ones for spouses of United States citizens or spouses of legal permanent residents. That's the first category. And then the second category is children of United States citizens or legal permanent residents. And then the third category is parents of US citizens or legal permanent residents. Yes. So that's how you qualify for the VAWA. And you have to, and then um, for the VAWA, you need to fulfill like four prongs. There are four prongs to fulfilling the VAWA criteria. First of all, there has to be like a qualifying relationship. Like I said, for spouse, you have to have like a documentation of maybe your marriage certificate. So there has to be a qualifying relationship. Secondly, the petitioner has to be living with the abuser. There has to be proof that you've lived together, maybe lease agreement, rent agreement, or pictures of you guys at the house, affidavits from friends and family, you know. And
Mhm.
then um, there has the petitioner will also have to show in some way that there has been some extreme cruelty and hardship on them emotionally and physically. So this is so important because most times people think VAWA is just for physical abuse. It's so interesting to know that emotional abuse, if proven well, would qualify for this category. And then lastly, you have to show that the petitioner is of good moral character, like good moral character, meaning you've not gotten into like some issues that like um maybe murder cases, because if you have a case already and it's been reported and you've been convicted and sentenced in a court for maybe murder. I'm just using murder as an example, or something really grievous or aggravated felony. Then obviously, like that wouldn't show that you have good moral character. So there are four prongs. So I've explained for VAR. These are the prongs. And then coming back to your question, you said what specific documentation is typically required to demonstrate that someone has been a victim of domestic abuse as an immigrant. So we have, because you're claiming that you've been abused emotionally or physically for the VAWA or for the U visa, because the U visa also like is almost the same. The difference between the U visa and the VAWA is for spouses or maybe US citizens or legal permanent residents, but the U visa is like generally whoever, like you just have to show that you're a victim of crime.
Mm.
Maybe you're a victim of crime of rape, you're a victim of crime of sexual assault, domestic violence. So you just have to like be a victim of crime, whoever it is. And like I said earlier on, the from why the Act of Congress enacted the brought the U visa is to try to help curb the rate of domestic violence going on, just to get the bad guys. So you have to cooperate with the police. So to prove both VAWA and the U visa, we have police reports or restraining orders. Like you have to, you should. I believe that if you're claiming that someone is hurting you physically or mentally or emotionally, you should be able to go. Like if you're so scared, then you should. The first thing you should do is to go to the police and report that
Mm.
I'm going through this. So it's important for you to have that at the back of your mind, like if you're going through some stuff. So I know immigrants, like I think I've seen some questions, even though we're not answering questions now, but these are questions that we occur every time. Like the people being scared of reporting to the authorities. But these are laws. There are laws that are guiding all of this. The VAWA, the U visa. These are acts of Congress because they've seen that this is an issue. So I know it's scary, but do not be scared. Just reach out to the authorities near your jurisdiction. And it's also very important, like I said earlier on, like it's very important to seek legal counsel from attorneys that will pay attention to detail or non-profit organizations. In Boston, Massachusetts, there are lots of non-profit organizations that are handling this. So police reports or restraining orders, you need medical records showing injuries, consistent with the abuse. That would be very good. You need affidavits, so affidavits from you as the victim and maybe from your family members, friends, neighbors that maybe witnessed the abuse, that know you're going through those kind of abuse. You also need photographs of injuries. So for that kind of situation, you have to like be very, very particular because the VAWA is a self petition that is independent of the abuser. So it's very important for you to take pictures. If you're laying claims for an abuse, take pictures because that is all you need to put in your application. Counseling or therapy records. There have been some clients that come to the law firm that are working as a paralegal, and they come in with um, therapeutic testimonies like what their therapist said. Therapist said, "Oh, this woman is going through a lot. She's going through abuse, and we're trying to help her." So those kind of reports help too. Text messages, emails, social media messages, Child Protective Service records. All of this, you can also find them on the USCIS VAWA evidence guidelines.
Mhm.
Yes, so like these are things that would really help your case to demonstrate that you are truly going through physical or mental abuse. Thank you for Thank I'm all set for this question.
No, I think you explained really very well, and thank you so much, for that detailed answer. I'm sure our viewers are actually getting to know, about the documentations or about the evidence also, how they can move ahead and take a step in this, because it's very important for, especially for women to come up and take initiative for this. And I think to our viewers also, I would like to say that Folks, if you or someone you know is suffering from domestic violence, then please remember that help and support are available, and it's you who needs to take up the initiative and ask for help. You can also contact a foreign licensed attorney, Abbott, on the given contact details that is just visible on the screen. You can email her on obot.e@northeastern.edu. And you can also call her on the number that is 857 9198 991. So this is her number and this is her email ID. So I think it would be great, to contact her and to learn everything about how you can have this legal preparation, if you are suffering from any problem. So yeah, I think that would be great. Okay, so as you already answered about the VAWA, and my upcoming question was about that only, but you already answered what is VAWA, so I think that's great. And now I would like to know about the process. That how does the WAWA self petition process work, and what are the key eligibility criteria for the applicants?
Okay, okay. Thank you. So for the vow petition, being I think I said it earlier on, like it's a self petition independent of the abuser. So I want our audience to know that it is independent. You do not need the abuser doesn't even need to like be to consent or prove like your ability to file, so it's independent of the abuser. And usually, like when you speak to an attorney about it, obviously when you seek legal counsel, the first thing that we usually do is to file the I-360. It's a form I-360 is on the USCIS website. And like I said earlier on, do not do this process on your own, because most times we've had clients at the law firm that come and they've made mistakes that cannot be altered. Like you can't go back on those mistakes. So you have to seek legal counsel. That's why you have attorneys. Attorneys where they went through law school, they went through all of this to be able to help you with legal defenses to your case. So it's good to not assume that you can do it on your own, because sometimes you make some mistakes. So it's very important to meet attorneys that you feel are like there's so many professional attorneys, there's so many non-profit organizations. You can just at the end of the session, I'm going to also like give out non-profit organizations that are good that you can reach out to. But please, like it's very important to reach out to them. And so you fill the form I-360 first, and you also asked what are the key eligibility criteria for applicants. So like I said earlier, there are 4 prongs that the applicants must prove. And the first one is you must prove that there is a qualifying relationship between you and the abuser, you, the petitioner, and the abuser. So if you're saying your husband or your wife is um, sexually abusing you or hitting you or emotionally abusing you, like it does not cover for dating, boyfriend, girlfriend. It has to be a qualifying relationship that is recognized by the law. You have to have like a marriage certificate if it's for a spouse. If you're claiming that your children are emotionally or physically abusing you, you have to show that they're actually your children, maybe a birth certificate. And then if you're also claiming that maybe your parents are abusing you, you have to show also maybe through a birth certificate that you're being abused. So that is the first prong. And for the VAWA, it's for US citizens and legal permanent residents. So, yes. And then the second, like if your abuser is a US citizen or legal permanent resident, like I said, the U visa covers all other categories. But for the VAWA specifically, it's for the spouses or parents or children that are US citizens or legal permanent residents. The second prong is the petitioner resided with the abuser. So you have to have maybe evidence of maybe living together, pictures together, affidavits from friends that you guys stayed together for a couple of for maybe years, months, or like that's also number two, like evidence that you've lived together, maybe pictures, leases, rent, like maybe the landlord saying an affidavit that you were living together, which is great. So the third one is the petitioner has been subjected to battery or extreme cruelty. So, and like I said earlier on, for VAWA, it can be emotional abuse. Some emotional abuse cases are worse than even a physical abuse because of what the abuser is saying to the victim. Or so it's very important for us to note here that it covers both mental and physical, mental and physical abuse. So you have to show that there was extreme cruelty. And that is why it's very important to meet an attorney for you to be able to buttress the point that, yes, there was extreme cruelty and there's so much hardship and it's affecting your mental health, it's affecting your life, and you need to opt out. So that is why it's a self petition that is independent of the abuser. And then lastly, the petitioner is of good moral character. I think I mentioned this earlier. Like you have to show that maybe if you've been staying in the United States, you've been of good moral character. You maybe pay your bills, you pay your taxes, or you can even get affidavits from your church members that you've been of good moral character. It's also very, very important that you do not have like maybe past cases of like that are really like maybe murder or rape. That doesn't even show that you have good moral character. Some attorneys can help you walk your way through getting waivers for that, but good moral character is one of those. So we have four. So I've said the four prongs. You have to have a qualifying relationship. Secondly, you reside with the abuser. Thirdly, subjected to battery or extreme cruelty. And lastly, you have to be of good moral character. So thank you. That's it.
I think,
Thank you.
yeah, you have explained it wonderfully and everything in detail. But I have some questions in my mind that I would like to know. That you said about that it has to be physically and mentally, the complaint will be taken. But for the physically one, I think it's easy to show the evidence, right? Because you have marks, you have scars, and that's easy to show. You can at least record a video, you can show that to anyone. But what about the physically, what about the mentally one? The one who is torturing, the one who is abusing, because that's hard to collect the evidence for the mental one. So, what can be the evidence for the one who has
Yes.
been, being a victim for the mental abuse?
Yes. So thank you. That's a very good question. So for the mental abuse, like text messages, like because some of these abusers they could we've had cases where an abuser is like sending messages to the petitioner and saying you are a prostitute, fuck you, like using bad words, like
Mm-hmm.
just so if you have like messages like that, like you can show. And then if you have like sometimes that's what I'm saying, like if you're in this kind of relationship now, it would be good to start gathering evidence. Like maybe if the person is saying some bad things to you, you can record. Like you don't have to like maybe video the person, maybe like a voice recording, having the context, what the person is saying. And then obviously you can also like therapeutic, like when you go for therapy, like your therapist can see the effects of the emotional abuse on you and can also like give a testimony of what's going on. So obviously like the physical abuse is easier to prove, but the emotional abuse is also okay to prove. So like that's why sessions like this should be able to tell you if you're in that kind of situation. It can just educate you and tell you what you can start doing, recording, like keeping your text messages of what the abuser is saying to you, or of voice recording what the person is saying. That could help. So yes, and then reports from the therapist that
Mhm.
you're actually going through depression.
Yeah.
Those help too. Thank you.
Absolutely. So, thank you so much, MM, for that.
Okay.
And also, you also mentioned that there should be appropriate relationship. This legal protection will be considered for the appropriate relationship. But is it something that what if a boyfriend or a girlfriend or even the minor, those who came into a relationship, and if some on the other partner is facing any physical abuse, so is it that the legal protection will be considered to those as well, the minors or the one who are not married?
Okay. Okay. So that is where, like, if you've checked and you've seen that you don't have like the criteria for the VAWA, that's where the U visa comes in, because the U
All
visa
right.
is a form of immigration benefits for survivors of certain.
Mm-hmm.
So there've been lots of like crimes of rape, domestic abuse, mental abuse, physical abuse, sexual assault. So like this one covers anyone. If you have a boyfriend, if you have a girlfriend, like, and maybe the person is not a US citizen, or the person is not an LPR, like legal permanent resident. So for those, for if you're in this category, what is very, so now it has taken us to the U visa. Is it possible to obtain a U visa without reporting an abuser to law? Okay, I'll answer that. So if you don't qualify for the VAWA, you can qualify for the U visa, because the U visa is more open, like, to even the ones that don't have qualifying relationships, because the main essence of the U visa is to save people that are victims of crimes. And the government is very particular about getting those abusers and putting, like, making them serve maybe terms or punish them according to the law. So for the U visa, you have to cooperate with the law enforcement agents by giving them evidence. You have to, like, once you report to the police, they'll need you to give them more evidence so that they can get that person and put the person where they belong, because abuse is obviously something that
Mm-hmm.
is draining both physically
Amazing.
and mentally. So
Yeah,
yes,
I think
so I've answered that question.
yeah, absolutely. And I completely agree. Abusing anyone is very draining and it's very terrifying as well. But I think that's great. You are at least letting our viewers know about what the legal protections they can take in US, and especially with immigrants, because we have seen so much, abuse from past few years, especially for immigrants in US. They have been suffering from, and it's very important to let them know about their rights, about their legal rights, what they can act, and because most of them don't know. So I think you're doing a great job, and all the answers are very good. And moving ahead, also, I would like to know about what legal protections are in place for individuals whose abusers threaten them with deportation.
Okay.
Yeah.
Okay, so we've actually discussed that, but so the VAWA
Hmm.
and the U visa. So like I said, it doesn't have to be physical abuse. It can be emotional abuse. So like someone threatening you that they're going to deport you and take you out of, like, there's, like, we've had so many cases like that at the
Yeah.
law firm. So like it's so if you have a United States citizen spouse or father or child, or legal permanent resident spouse, father or child or mother, like parents, I mean, then that would be VAWA. But for U visa, like, I think I would also like to go through the eligibility criteria for U visas,
Oh, sure.
because I think we skipped that.
Yeah, please go ahead.
The last question. Yeah, okay. So for the U visa, because I know I explained the VAWA, and I said the U visa was made for people to cooperate with the government to be able to get people, like, get people that are committing crimes. So crimes of maybe abduction, rape, incest, domestic violence, sexual assault, prostitution, murder, female genital mutilation, blackmail, stalking, trafficking. So the U visa encompasses a lot of, unlike VAWA that is like abuse, mental or physical. But the U visa is like crimes of violence. Like so um so the eligibility criteria for people for U visas, you're a victim of criminal activity. That's the first prong. We have for VAWA we had 4 prongs. For this one we have 6 prongs. First of all, you're a victim of criminal activity. Number two, you have suffered substantial physical or mental abuse as a result of having been a victim of any of those criminal activities. The USCIS website even lists out like so many criminal activities, like the ones I mentioned, rape, there are a lot of criminal activities. So it's very wide. So like even if maybe you checked and then the one that you're going through is not on the USCIS, the USCIS has said that if it has the same elements of a criminal activity like the ones they've stated, then it would qualify. So if it's a crime, it's a crime. So then the second prong, the third prong is you have information about the criminal activity for the U visa because you're going to be cooperating with the federal government to find criminals. Then you have to have evidence. So if you're currently in a domestic violence issue or matter, it's very, very important to start saving evidence. You have to fight for yourself. You have to fight for yourself. No one will fight for you like you. You should. Like you have to fight for yourself. You have to start getting evidence. I know it's a very daunting and emotional draining experience, but you have to stay strong and fight just to be able to get protection. So you have information about the criminal activity. You have to start gathering evidence, start gathering things, like I said, police reports, medical stuff, pictures, anything, testimonies from friends, family, community. You were helpful. The fourth point is you were helpful to the law enforcement officers in the investigation or prosecution of crime. You have to be helpful to them. That's the other one. The crime occurred in the United States and it violated US laws. You are admissible. Like you are admissible, and if you're not admissible, you can apply for a waiver on a form I-192, application for advance permission to enter as a non-immigrant. So let me explain what it means by admissible and inadmissible. There's a difference between admissible and inadmissibility. So when you're admissible, it means you are in legal status currently. Like maybe you're on F1 or maybe you're on B1 or B2 or maybe you're on any, maybe you're on H1B. Probably you're just on any of this, like maybe any of the non-immigrant categories. So and then it means you also got into the United States through the legal means. Obviously, if you have an F1, so it means you were admitted into the United States by the consular, like by the officers, by the customs officers. So the CBP officers. So it means you got in. So it means you are admissible. But inadmissibility could mean that maybe you got into the United States, maybe through the border, like maybe some people, I don't know. It's yeah, we've had clients that came through illegal means, maybe through the sea, water, like just any way. And then for one reason or the other, you do not have a legal status. Then that means you're inadmissible. And if you're inadmissible, you have to apply for a waiver. And the waiver is at the discretion of the court. So the court or the USCIS. So, but it's good to like, so one of the eligibilities, you have to be admissible. But if you're not admissible, Then applying for a waiver, maybe you give an excuse that, oh, I was this, like, so, but the waiver is discretionary, but it's possible. It's possible. And then that's it for the e-visa. So thank you.
Yeah, I think that,
That's it for that question.
yeah, thank you so much, MM. It was really detailed and it was very specific also. So I think it was great and also inspiring because you said that women has to take a stand for themselves, and it's high time, that it's they only who are going to take a stand and take the initiative. So they have to fight for themselves. And I hope that, someone who is suffering from this situation, or someone people know is suffering, I hope that, the session might be helpful for them and would definitely let them know about the legalities, the legal protection, the, the rules, the laws that they can have. So I think, yeah, that's very important for our viewers. And meanwhile also, we have our viewers who has joined us today in this session, and I would like to greet them like, hi Sahil, hi Shita, and hi Kajal. It's lovely to have you. And why don't we take some questions from our viewers too?
Okay.
All right, so let's take up Sahil's question. And Sahil is asking that I have been experiencing physical and emotional abuse, but I'm afraid of reporting it because I'm an immigrant. Are there any protections or legal options for someone like me who is in the US but does not have full citizenship yet?
Okay. Yes, yes. So like we've been saying before that there 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 are various kinds of legal protections for people victims of domestic violence, physical and mental abuse. So I'm sure, okay, I'm sure you've been listening to us. So, yes, yes, the answer is yes. But the right approach is seeking legal help, like maybe reaching out to an attorney or reaching out to a nonprofit organization. You can also like reach out to me. I can send maybe resources that you can reach out to, or the law firm that we have various attorneys because I'm a paralegal. We have various attorneys that have worked on cases like that in the past. And if you're open, or you could also check attorneys within your jurisdiction. If you're yeah, because it's very important this kind of cases you work with an attorney because it's it's more, some people you can do it on your own, but it's better to do it with an attorney because there are just so many issues that an attorney would save you from. People have gotten into big immigration issues. They've destroyed their cases with their own hands because they didn't seek legal advice. So it's very, very important for you to reach out to an attorney because that's why you have attorney. That's why they went to law school
Right.
because they identify all of this things, can get you legal defenses that can help you. But so for Sahil, your question, yes, there are legal protections. We have the VAWA, the Violence Against Women's Act. We have the U visa. So yes, there are legal protections. Thank you.
All right. I hope, Sahil, you got your answer. And, in case if you still have any follow-up question or would like to know anything else about today's topic, then please feel free to post them on the comment section. And we will definitely take them up and we will try our best to solve all your queries. And let's move ahead with Ishita's question. So Ishita is asking that, can I apply for legal protection under VAWA even if I'm not married or don't have legal status?
Okay, nice. Ishita, yeah, nice. So I'm sure maybe you had the answer before, but I'm going to say it again. So for the VAWA, you have to have a qualifying relationship with either your spouse or relationship with maybe the child or relationship with the parents, because you're saying that maybe the US or citizen or the LPR spouse is abusing you, or you're saying the US citizen parent or LPR parent is abusing you, or you're saying the US citizen or LPR child is abusing you. So you have to have a qualifying relationship, like marriage certificate or birth certificate to prove that. So for if you're not that, you can go through the route of U visa. The difference between the VAWA and the U visa is the VAWA, you qualify for a green card once you're approved immediately. But the U visa, which you don't have to have any qualifying relationship, it just has to be someone that is doing grave injustice like violence or a criminal activity, abduction, rape, whatever, crimes of like hitting you or whatever it is, emotional abuse. So for the U visa, when you apply, it takes for the U visa, you will get when it is approved, you will get 4 years U visa. And then it also can be extended if the 4 years elapses. And then later on you could try to apply for a green card through the after the 4 years has lapsed. So that's the major difference. But if you don't have a qualifying relationship, you don't qualify for VAWA. So if you don't have, but you can qualify for the U visa. Yes, thank you.
Yeah, I
Thank
I would say
you.
thank you so much, Emma, for answering this question, and Ishita too, for commenting us. And I think it's great. It's not only about the qualified relationship, but it's also about because the U visa helps in being getting punishment for those also who are not in a qualified relationship. So I think these were some very important and very essential things that we didn't know, and now we are getting to know. So I think it's a very insightful session that I'm having right now. And moving ahead with Kajal, here's the another question that Kajal is asking for. If I'm experiencing abuse from my employer, does the law offer any protection for immigrants? I'm scared of losing my job or being retaliated against if I speak up. What do you have to say?
Oh, yes. Okay. This is a good question. However, it's not immigration related, but a good resource because I believe this is labor law related. This is labor law, and my specialty is not in labor law. However, you could check the USCIS. I believe there are so many I've heard, but right now I can't even give any advice as to this because I've not practiced in this area. I've just been in since I've been in the US. It's been the immigration law. So for the labor law, you can check USCIS or reach out to me, and I can try to check for some resources. Maybe some labor law organizations that can help. Yeah, I could do that. Or if you're in Boston, the Greater Boston Legal Services is a nonprofit organization that handles all kinds of cases. So they have their immigration, they have their labor law department. So that could also be a good resource.
Absolutely.
Thank you.
All right. So, Kajal, if you have any follow-up question or would like to know any other answer related to today's topic, then please go ahead and post them on the comment section. And also let us know from where you are watching this session, as we are live on YouTube, LinkedIn, Facebook, and Twitter as well. So let us know where you are watching this session. And moving ahead, I have this another question that you have been mentioning about WAWA self petition process. So, on an average, I would like to know that how long does the WAWA self petition process take from start to finish?
Okay. So on average, it takes about 6 to 12 months for the VAWA cases. It takes like from 6 to 12 months. It will come earlier. Some people are very like fortunate. Just put in your application and then it comes early. It just depends.
Mhm.
And then while others, sometimes it takes 2 years, sometimes it takes long.
No.
So, but on an average, 6 to 12 months, sometimes it could exceed 2 years. But the good part about applying for those kind of applications like the VAWA is when you're applying for it, you can also apply for an EAD. That's a form I-765, which can help you the the victim or the survivor of the abuse to work, like, which is good. So meaning you can work independent of the petitioner. And like I said, it's really, really hard when you're going through daunting moments to think about working or to think about fighting. But it's just good to pick up like yourself, maybe with some you need a very good support system too. You need friends that are trying to help you get out of the whatever issue or dilemma it is. So it's very, very important that you seek help when it's time. So it takes 6 to 12 months, and sometimes 2 years, and it comes with an EAD, which helps for you to walk. So thank you.
All right. Also, MM, I would like to know about the US visa application. You mentioned everything about it, the eligibility, the process. But what if a U visa application is denied? What options or next steps are available to the applicant?
Hmm. Okay, that's a good question. Um, so it depends on the specificity of the case, because for immigration law, like clients' cases are specific based, because sometimes you can use what you did for one other client to do for another client because the circumstances are different, and this is human life, like here sometimes people are in a life and death situation. So however, maybe asylum, depending on if you went through some kind of government action, maybe in your home country. So this one, you have to seek legal counsel. You have to meet an attorney to be able to listen to your case,
Right.
hear what you have to say. And a good attorney that pays attention to details will be able to give you various options that you are eligible.
True.
So it depends on the specificity of your case. So if you're going through violence, it has to be U visas or the VAWA. But if you're going through any other thing, then you have to speak to an attorney for them to break it down for you and give you alternatives that you should follow. Yeah,
Absolutely.
thank you.
No, absolutely. I think that it's so good of you that you are letting us know about these most important things that each one of us should be aware of. And yeah, I think contacting attorney and having an expert advice is one of the best option that anyone can have it right now, because it's not so easy to just go and have a complaint, but it's also very important to follow each legal steps very carefully and correctly. And with that, again, I would like to read, attorney MM about the contact details. And here's the contact details that's visible on the screen. That is 857 You can also email her on obot.e@northeastern.edu. So I think it would be great, and to take help and directly personally ask from MM is one of the best thing that you can do in your case. And yeah, I think moving ahead, MM, we have another viewer also who is Amtul. So I would like to take up his comment, and he is asking that how do immigration policies and practices impact the mental health and well being of immigrant survivors of trauma, including those who have experienced abuse, torture, or violence in their countries of origin or during their migration journey? What role can mental health professionals play in supporting immigrant survivors? And what are the implications of immigration enforcement actions, such as detention and deportations, on the mental health of these individuals? Yeah.
Okay, okay,
Mhm.
okay. That's a good question. So, for this session, because I hope I got the question correctly. But for this session, it's covering the VAWA and the U visa. And so for mental health, I think I mentioned that some clients go through therapy. So I believe therapy would be the best option for you, speaking to your family and friends, have different ways of going through depression or domestic violence. So some people, a good option is like walk out of it. You have to walk out of it if it's gonna, like,
Yeah.
some people have died to domestic violence. So I'm sure you don't want to lose your life. So if it's something that you've seen that it can take your life, then I think you should get out of it. Get out of it. It's hard, but it's good to get out and seek legal protections like the VAWA or the U visa. And then for the mental health, I think you just have to go seek therapy. And okay, I think also some nonprofit organizations, I think I wrote here, like in Boston, Massachusetts. I don't
Mm-hmm.
know if you're in maybe other parts of the US. Like, you could just type um, domestic violence nonprofit organizations, and then it will come out. And then you can reach out to them. Sometimes some of those nonprofit organizations, they have resources that can help. Yes, they have resources that can help. Sometimes some of them do it for free. It depends. So it's very important that you do the hard work because, like I said earlier, when you have to fight for yourself. No one is going to come and fight for you. You have to fight for yourself. You have to reach out. You have to reach out. You have to reach out. So, for if you're in Boston, Massachusetts, the GBLS, Greater Boston Legal Services, is a non-profit. And then the Refugee and Immigrant Assistance Center is an excellent resource also for immigrant survivors. Yes, so and then there's so many law firms like at the law firm I'm working in. Like I said, I'm a paralegal, so I can't like work on your case independently. But we have
Mm-hmm.
attorneys that have been doing this for years and can help your case. So it's just for you to reach out. Always reach out. Always reach out. Thank you.
All right, that's great. And moving ahead, I have some questions that I would like to know it from you. That can individuals work legally in the US while their immigration case related to abuse is being processed?
Okay. Yes, for the VAWA, like I mentioned earlier, the Violence Against Women's Act, which is for you, which is for abusers that are U.S. citizens or legal permanent residents, or children that are U.S. citizens or legal permanent residents, or parents that are U.S. citizens or legal permanent residents. So, if you file for VAWA, which is a Form I-360, then you can file for a work permit. And it comes even before the case is adjudicated, which is good. Yes, like you can have the work permit, work, help yourself independently from the abuser. That works. However, the U visa, the one we spoke of, the one that you have to cooperate with the authorities to gather evidence against the abuser, the one that covers tons of crimes of violence, rape, all other crimes. That one, the U visa has to be approved first before you get the work permit. So for the VAWA, yes, you can work legally by getting the work permit, applying for the work permit while you're applying for the VAWA. But the U visa, it has to be approved first before you get the work permit. So if you're going through the U visa route, the best way is for you to ensure you have lots and tons of evidence to show that yes, you're going through this abuse. So if you're going through it now, please be smart. Please be smart if you're a man or a woman. Be smart. You have to fight for yourself, like I said. Take pictures, record voice messages, text messages, gather all of this, take it to the police, tell them this person is this, that. This person has been doing this to several women. If you have evidence, take it to them, cooperate with the authorities, and then you can get a U visa. And it's for 4 years. And once you get it, you can work legally. So please, yeah, please reach out. Thank you. Thank you.
Absolutely. And moving ahead, we have some other questions also from Facebook group as well. So I would like to ask those questions as well, because it's also very important, to consider those questions too. So yeah,
Okay.
I think we can ask the other question, control, if you could. Yeah, this one, correct. So here's a question that we received from one of our viewer, and it has been asked that while going through a divorce 2 years ago, I found out that my ex-wife ran up around $10,000 in credit card bills under my social. She also had a $5,000 IRS debt. We both signed an agreement to split the credit cards, and she would pay the IRS debt. Once the divorce was final, she stopped paying anything. She destroyed my credit, and the IRS took my refunds. Can I take her to small claims court in Pennsylvania or just take the hit?
Um. Okay. I believe you can, but you have to first of all reach out to a very good attorney in family law
Mhm.
affairs. Yes, that can help you do this. You can. Yes, you can. I believe so. You can. But like I said earlier on, it's always good to work with attorneys, like just to be able to save you tons of many more emotional
Mhm.
or financial pain. Yes. So it's good to reach out to a good attorney. And like I said, like you can check for maybe nonprofit organizations in Pennsylvania, or look for law firms in Pennsylvania. Um, the law firm I work in, we do family law issues too. And yeah, but we're not licensed in Pennsylvania, so we can't even help. But please try to reach out to a good attorney. Yes, but this, I believe it's something that
Mhm.
can be worked on in maybe a small claims court. Thank you.
All right. Okay, so let's move ahead with our next comment that we received on Facebook. And we have another comment that is, "Hi, I filed WAWA 11 months ago, but I still didn't get prima facie letter. I am very depressed. Anyone here having same thing, please share." Yeah.
Okay. Hello. Yes. Okay, anonymous participant.
Yeah.
Yes. So, like I said earlier on, the timeline for the VAWA is about 6 to 12 months. So, if you haven't gotten back response, that is usual, because this is how, like, the USCIS has like a backlog of so many cases. Like, you can't imagine how many cases get to the USCIS per year. So they take, yeah, sometimes they take longer than even the 12 months.
Mhm.
But most times I've not seen something exceed more than 2 years. And if you have an attorney working with you on the case, you can even like send a letter to the courts, like asking, like making inquiries, like what's going on. I applied for this. So yeah. So you do not worry, like just keep hoping and being optimistic that soon enough, like your petition will be out. Yes. Thank you.
All right. I think let's move ahead with another question, and this is that I entered in US illegal and then filed asylum. Later filed WAWA and closed asylum. Now I got combo card. Can I travel to Canada? Is it safe to come back? Yeah.
This is such a dicey question, because I believe personally, because I'm speaking from my general knowledge and personal experience, I believe
Mhm.
that most times when you don't have like your legal status, I feel like it's really dicey, like having to travel. So most times, all immigration attorneys will be like, just stay back until you regularize your process. Like, so yeah, it's really dicey. Like I said, it's really dicey, because it is at the discretion of the CBP officer. The CBP officer can just like not just want to give it to you. I don't know, maybe the color of your face, or what you're putting on, or maybe the CBP officer is in a bad mood and they're doing their job. So it's completely discretionary. Some people might get lucky and then travel and then they come back.
Mhm.
But most attorneys, immigration attorneys, from my experience as a paralegal, they would advise in those kind of situations for you to stay back until you regularize your process. Then you can travel, you can tour the world, you know. But for now, you just stay back, just to get like not to get deported or something. Thank you.
Absolutely. And I think that's wonderfully explained. And, we didn't even realize, but it's been an hour. And I think it's almost time to wrap up. We were so much indulged into the conversation. And I would like to know that it was your
Yeah.
first experience with us. So I would like to know how was it? Did you enjoy or how was it? Yeah, please go ahead.
I enjoyed it. I really enjoyed it, and I'm glad I was able to like just share like what I've experienced as a paralegal to people. I hope it can help anyone out there. And like I said, no matter what you're going through, the pain you're going through, first of all, you need a good support system, and good friends and family, and then maybe therapy. But the most important thing that people don't do is to voice out and to reach out. And that is the only way you can get help. You have to reach out. If you're going through any like crime or violence right now, do not be scared because there are actually legal protections to help. You just have to try to gather evidence and then reach out to the authorities. Reach out to non-profit organizations. They help because they've seen that lots of immigrant women and some men are going through so much. So you just have to reach out. If you don't reach out, you'll stay locked up in that mess. So
Right.
thank you. Yes.
Absolutely. I think very well said, MM. And I hope, this session might be very helpful and insightful for our viewers because today they get to know so much about it. And I think, it's very important to understand all the legal protections that, especially for immigrants, those who are in US, what they can do, what the rights they have, and what are the legal, perspective they can also have. So I think it's very important. And thank you so much, MM, for sharing these insightful information with us and being a part of Immigration and Jobs Talk Show. I think, especially as I also mentioned, this holiday season, we know how much busy you were, but still, your presence truly means a lot, and we are so grateful to have you with us today. And I think a big thank you I would like to say to you. It was lovely having you, and yeah, I think it was so great to have you. And I hope, that we can have more exciting discussions and have more sessions together in the future. What do you say about it?
Perfect. I'm in. I'm in.
Wow,
Thank you. Thank
I'm
you.
sure our viewers are also looking forward to this session, and they might be waiting for your expertise as well. So again, now it's almost time, and I think it's time to wrap up. So thank you so much, MM, for having us and for sharing this session, with us. It was so lovely to have you, and it was wonderful having you. Thank you so much.
Thank you too. Have a good one. Thank you so much. Have a good one.
Absolutely.
Bye. Bye, guys.
Same.
Thanks for joining in, guys. Thank you. Please reach out if you have any questions. Thank you. Thank you.
Absolutely. So, yeah, friends, we have seen this session and we have gone into so much details on today's topic. So, big thank you to all our lovely viewers also who participated in today's webinar. And big thank you to Attorney Abbott for sharing such a valuable expert advice. And yeah, I think to our viewers, friends, if you're navigating any immigration journey or have any doubt regarding today's session or topic, then please go ahead and post them on the comment section. Meanwhile, not now, but for sure, we are going to take those questions up. And after this session, also, when it will be over, we will let you know all the answers to your questions. And yeah, I think thank you so much to all the wonderful viewers, and Merry Christmas too, and Happy New Year also. We hope you have a joyous holiday season filled with love, laughter, and cherished moments, with your loved ones. So don't forget to join our upcoming shows as well. And like, share, and subscribe to Immigration and Jobs Talk Show. Thank you so much for joining us, and I'm Sam signing off for now. Bye bye and take care. Hello and welcome to today's episode of Immigration and Jobs Talk Show. I'm your host Sam and I'm back again with a very exciting episode that is lined up for you today. So before diving into the topic, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So use of information is at your own risk. All right, so folks, once again, welcome back to Immigration and Jobs Talk Show. I'm Sam, your host. And today we have got again a very timely and crucial topic. That is the new H1B rule. What employers and workers need to know and why it's a game changer. Well, it's actually a game changer because the new H1B rule has modernized the visa process. But how, what are the key changes, then how does it impact both workers and employers, and what you need to do to stay ahead? To answer all these questions in detail, we have a very special guest with us who has joined us for the fourth time. That is Attorney Poonam Gupta. And she has over 25 years of experience in immigration law, plus a solid background in intellectual property and litigation. So, welcome, Poonam. It's always a pleasure and lovely having you with us on our immigration show. And it feels so great to have a show with you and so much to learn from you as well. So, thank you so much for joining us.
My pleasure, Sam. It's great to be back, and I'm excited to bring the key topics and key learnings from this new H-1B rule that's finally come to fruition. It was first proposed in October of 2023, and it has now just been released and will become effective January of 2025. So super excited to delve in, and I hope people have lots of questions. If not, I have lots of things to share because a lot is there to pack and unpack.
Absolutely, that is, and but before diving into our today's topic, Poonam, I would like to know it's just 5 days to go Christmas. So, how is your Christmas preparation going on? Are you excited?
I am super excited because I'm going to take some time off and unwind and relax with family and friends. And so, super excited about that. And I hope everyone else does the same.
Absolutely. I think all our viewers are also very much excited because it's Christmas time, right? It's super exciting time, and holiday days also are just coming after a few days. So,
Sure.
yeah, I think with that also, folks out there, let me tell you that we are also live on YouTube, LinkedIn, Facebook, and on X as well. So, watch this session and put all your questions, your queries, whatsoever you would like to know from Attorney Poonam Gupta, and we would be more than happy to have them. All right, so let's begin with this very first question of mine. That is, Poonam, what is, or can you please explain the main changes that has been introduced by the new H1B final rule?
Sure. So there are lots of changes in this new rule. As I mentioned previously, the first iteration of this rule was proposed back in October of 2023. Partial implementation of the rule happened last December, and those rules went into effect in January of 2024. The remaining portion from that 2023 rulemaking proposed rule has now been issued this week, and this will go in effect on January 17th, 2025, just days before the new president takes office. What is the purpose of this rule? The purpose of this rule is to codify USCIS practices and introduce some new provisions. So, some of the new provisions that were introduced include an expanded and more robust definition of specialty occupation, which is the hallmark of H-1B. And to qualify for H-1B, the second is the elimination of the itinerary requirement, which is if someone is placed at any at a location, then previously employers were required to identify when they will be working and where, for how long, and so on, and that requirement has now been removed. And one of the most exciting pieces of the rule is the expansion of the definition of not for profit and what it means to be uh, cap exempt and how to secure cap exempt H-1B. The expanded definition makes it a lot easier for organizations to qualify as cap exempt and thus hire more workers. And it actually requires people to not directly work at those organizations, but even if they're working with that organization and working towards that essential function of that organization, they could still qualify for this cap exemption. The next exciting part that's been introduced in this, which was much awaited by entrepreneurs across US for a long time, is the option for startup owners to sponsor themselves for H-1B as long as they have an entity, a company set up. And even if they own the majority stake and they have the majority ownership, they're still able to sponsor themselves. In addition, there is the codification for that there has to be a bona fide job offer, um, amended petitions, that when an amended petition is required, deference policy was codified, as well as the evidence of maintenance of status that is required for each petition for change or extension of status. The one key piece that has been in USCIS practice, but has now been codified, is USCIS has expanded its authority to conduct site visits to ensure compliance with H-1B requirements, including for third-party placements, and non-cooperation with the site visits could result in a denial or revocation of the H-1B. So, in short, I know it's a lot that I packed in, but in short, that is what is a quick summary of what's happened in this new H-1B rule.
All right, all right. Thank you so much, Poonam, for letting us know about what are the main changes that has been introduced by the new H-1B final rule. Also, Poonam, do you think that the new H-1B rule is going to benefit workers and employers? And if yes, then how?
So there is definitely benefit that will come through for everyone. The biggest benefit will be the clarity that comes through. There is clarity on what is specialty occupation, what is required, the government clarifies in their proposed rule, in their rulemaking document, the notice in the Federal Register, and address the various scenarios, and they go in great depth on what is it that is required for each. When is it considered specialty occupation? When is it not? When is a general degree okay? When is it require a specialized degree? In most instances, a general degree may not work and may not qualify someone for an H-1B because it will not be considered specialty occupation and so on. So there's definitely clarity around that, and removal of the itinerary requirement is a huge benefit, especially for IT staffing companies. That really helps. That should help. What may not be as beneficial may be the increased site visits, the increased access, or sorry, the streamline. I mean, there is streamlined processes, but there's also additional requirements on what is an employer required to present when it comes to qualifying for an H-1B. The government has the authority to request contracts, whether it is with end clients or third-party clients, or they may be intervening agencies before the H-1B employees placed at an end-party client, and the government has expanded its authority to request any contracts or master services agreements or the like. So that may add more burden on the employers, but by and large, I think all in all, this rule is a positive, is a good thing. There are a lot of good things about this.
All right, that's great. Also, Poonam, there's some mentioning about a specialty occupation. So I would like to know that how does the new rule change the definition of a specialty occupation for H-1B visa, and what does directly related mean for the required degree too?
So USCIS has gone and spent considerable time in explaining that they are not actually changing the definition drastically. All they are doing is codifying what USCIS practice currently is with regards to specialty occupation. So the current practice is that the government requires a nexus between the degree that the individual, the beneficiary, or the employee has and the position. So there has to be a direct connection, a direct nexus between the two. If a company cannot show that there is a connection between what the degree required for the position is and what the person has, then there may be problems. But to the extent that a company can show that there is a nexus and there is a connection, then then there should not be any problem. It's more clear compared to before, if that makes sense. I can give an example. So one of the examples that the government lists in the rulemaking is an engineering degree for a software developer role. And they say not any engineering degree can surely qualify unless the government shows that there are specific courses within any engineering degree that would help in that software developer role. So, for instance, a chemical engineer or a mechanical engineer, by definition, at least on the title, and the government has spent considerable time explaining that just the title of the degree is not material. It is what the substance and what courses are taught in that degree. And because titles vary from university to university, program to program, the titles are not dispositive. It is what is the actual coursework and how that relates to the role that matters. So that is what directly related means, that there has to be a direct nexus, direct connection between the coursework and the position.
All right. But also, Poonam, I have this question in my mind that now we can see another way of specialty occupation definition. So now it shouldn't be much specific about the work that the workers are going to opt for. So do you think it's going to be beneficial for the company? Because if specifically not that employer is looking for that specific degree, that overall degree can be applicable. So do you think it's going to benefit, or that employer or that worker needs to be highly qualified in that specific work, then only it's going to beneficial for the company?
So there are several pieces to this, Sam, right? One piece is when the person has So the position can require one degree or it can require multiple degrees, right? And the government has always held this position. And what they've done with this new rule is codified that position, is that if an employer requires multiple degrees, it has to show how each degree is relevant to the role. So,
Yeah.
for instance, if a position requires finance, economics, statistics, all related, then it has to show what part of the finance degree is directly related to the role, what part of the economics degree is directly related to the role, what part of the statistics degree is directly related to the role, and so on. So that is the directly related part. In terms of, does it exclude individuals that have experience? No. The government is still going to look at, as it currently does. It's not a change, nothing's changed in that perspective. It's only clarified and codified what USCIS currently does. That if someone has an Indian degree, an Indian bachelor's degree, which is a 3-year degree, and a few years experience, then there is a possibility that the combining the degree and the experience, the person could qualify for a US H1, an H1B role based on a degree equivalency, which is based on just the the 3-year degree plus a few years experience, which would equate to a US bachelor's degree, which, as you may know, is required for an H1B. So the government looks at the totality of what the situation is, and not just the title of the degree, not just
Right.
the experience or whatever. So it's everything combined together.
Absolutely. And also, Poonam, we have one of our viewer here, and here's Chetali here, and she's watching us from LinkedIn. So Chetali has another question that does codifying help H1B holders? Will it protect them from the next administration from, I think,
Making any drastic changes to the H1B. So,
yeah.
yes, thanks, Chetali, for joining us. The question is a good question. Codifying helps both the employers and the employees, because it provides clarity to the to everyone. What is the standard? What is required? In terms of, will it protect someone from drastic change? There is codification of the deference, as in the deference policy, which means that if an employee continues to work for the same employer and applies for an extension of the H1B status, then unless there is a drastic deviation from the previous application, the government will give deference to that same application, that extension application. So, to that extent, there is a limited protection. Under the previous Trump administration. We saw individuals who had held H-1B status for an extended period, in 10, 12, 14 years. Their H's were denied on extensions because the Trump administration revoked the deference policy, as in every case would be reviewed afresh as if it was a brand new filing. By codifying the deference within this new rule, the government is providing a limited amount of protection, not a blanket protection. They've refrained from expanding the deference, but there is some limited deference.
All right. And thank you so much, Adali, for your question. As this was my about to question because I was about to ask this question only. But that's okay. I think, Poonam, you have explained it. And Chitali, if you still have any follow up question or would like to know any other topic or any other question that you have in your mind, then please feel free to post them in the comment section. And for an hour, we are here. So please go ahead and utilize this opportunity. We will definitely take your question now. And here's another question from Anisha. And Anisha is asking that does the rule address dependent visa like H4 or their work authorization?
No, Anisha, thank you again for joining us. Unfortunately or fortunately, we don't know, we'll see. But the rule is focused purely on H-1B and does not address any dependents or the H-4 work authorization. There were some comments in the rulemaking about immigrant visas, and the government said that is the outside the scope of this rulemaking. But there were no comments about, or at least I didn't see any comments about dependents. But there are definitely no rules or no impact or changes to the dependents or their work authorization in this new rule.
All right. So thank you so much, Poonam, and thank you so much, Anisha, also for your question. And Chitali is saying thank you. This was really helpful. Thank you so much, Chitali, also. And let's move ahead with another question, Poonam, that I have for you. That is, how does this rule impact the eligibility of workers with degrees in business administration or other fields that were previously considered general?
Right. So this is where this may be slightly problematic, right? Individuals that had a general business degree, and the government clarifies that it is only the bachelor's of business administration that may be problematic without a specific major or a minor. When there is a major in that, even in that business administration degree, it is considered specialized. It is when there is no major that that is a problematic issue. If there is a major, no issue. If it is a master's in business administration, again, no issue. They are considered specialized by virtue of being master's degree. But it's only the bachelor's in business administration, which did not have a specialization, that may run into trouble under this new codification. Everyone else should be okay.
All right. Okay. So here we have also Anisha, and who says, "Okay, thank you so much, Anisha." And to you also, if you have any question or follow up, then please go ahead and post them on the comment section. We will take them up. And thank you so much, Poonam, for detailing that up and answering all the questions very patiently. Here's another question that I would like to know from you about the site visits. So, what role do site visits play in the new rule, and what should employers be prepared for?
So previously, site visits were always part of USCIS Arsenal, the FDNS arm of USCIS, which is the fraud detection unit, always was involved in investigating any situations where they thought there was fraud in the USCIS, in the H-1B applications. But with this new rule, they've codified their authority and said we can conduct site visits to see what is happening and to request information from the employer as well as the employee. And these site visits are unannounced, but if there are attorneys that are representing those employers, they can ask the site visit to be rescheduled so that the attorney can be present. The attorney can join by phone as well, but it is possible that they can reschedule it uh, to allow the attorney to be present. But they are very, very clear that if the employer or the employee do not cooperate or provide the requested information, it can result in the denial or revocation of the H-1B. So it is absolutely critical that employers are prepared for any site visits. They are prepared with having all their documentation absolutely in order so that they are well ahead of the curve. In addition to the site visits, I anticipate that under the Trump administration, the site visits will definitely increase given the focus on enforcement. In addition, I imagine the I-9 audits will increase under the Trump administration as well. So those two, while separate, are all part of the immigration compliance, which every employer, if they are not thinking about, should think very, very seriously about. These are not things to take lightly. There are severe consequences
Yeah.
of not being prepared, including revocation of petitions, including fines and criminal penalties in some situations in an I-9 situation. So there's a lot to be prepared. And I urge all employers to talk to their immigration counsel, talk to their attorneys, and get ahead and be prepared for what's coming very soon.
Absolutely. I think everyone should be very much aware about this, and they shouldn't be taking this thing lightly because some or the other it's going to harm them. But also, Poonam, as you said, that we can see in Trump's administration the site visits going to be more stricter. But
Correct.
till now, we have heard this from most of the people that most of the people are against site visit. They don't like this concept, and Trump is completely in favor of this. So, what's your take on this? Do you think that site visits can be beneficiary, or is it going to some on the other? There are some other challenges that people they might not know about it.
So, site visits are a double-edged sword, right?
Mm-hmm.
Um, for employers that are fully compliant,
Mm-hmm.
site visits help establish their credibility with the government. They help cement um, the perception that the government may have
Mm-hmm.
for how a company and the amount of scrutiny that the company may receive from the government going forward after a site visit. But for employers that are playing fast and loose with the rules or, you know, on the edge of compliance and not really focused on compliance,
Mm-hmm.
this may be problematic. So it is important to focus on the compliance piece more than ever under the upcoming administration.
Right. I think very well explained. And meanwhile, we also have another viewer, Zishan. So, Zishan is here with another question that can you please talk about opening up the company or startup?
Sure. So, Zishan, welcome and great question. A lot of students, a lot of individuals want to start their own companies as a student on OPT or so on. And up until now, being you could start a business on OPT, but when it came to STEM OPT, you couldn't, or you could, but they could. I mean, there were ways around it, and there still are ways around opening your own and working on your startup while you're on OPT or STEM OPT. But then what about after you're done with OPT and STEM OPT? What was the path forward? Up until these regulations, there was no path forward. Now there is a path forward. Individuals who or have a majority ownership in their companies, not them individually. So the government has made this distinction. It is not individuals, not entrepreneurs who are looking to sponsor themselves that will be able to benefit from this rule. It will be individuals who set up a formal entity, a company, of which they may own the majority share, majority ownership, but that company is able to sponsor the owner for H1B as long as the individual is working in a role or performing duties that are majority specialized in nature, that are aligned with their degrees, that have a direct connection to their degrees, and for the majority of the time, they're performing that role. The government does not expect 100% of the time to be on those specialized duties, but only a majority. They've given and acknowledged that a company owner needs to do other things, uh, whether it's making copies or making calls or seeking investors or pitching to business or pitching for funding or anything else, as long as that running of the business does not overtake the individual's role, they can qualify for H-1B. One of the guardrails that they have put in place to prevent fraud and abuse of the system is that the petition will be only valid, that H-1B initial petition by an entrepreneur for their sponsored by their own company for themselves will only be valid for 18 months, and then it can be extended for another 18 months, during which time they will have to show the government what percentage of time they've been spending on what duty. And once, if the government is satisfied, they will extend that initial H-1B for an entrepreneur by another 18 months. And then after that, they can get a full 3 years. So they will be able to get a full 6 years with their own company without relying on any other employer, which is groundbreaking by any stretch, which is monumental and a welcome relief for entrepreneurs.
Wow, that's so good. Okay, so Zishan, I hope you got your answer. And still, if you have any follow up question, then please go ahead and post them on the comment section. And we have another question from Chetali as well. But here's a request, Chetali, please wait for some time. We have another questions also. So let me take from YouTube user also. That's Kunal. So, I own a small tech consulting firm and rely on H-1B workers for critical projects. With this new rule prioritizing higher wages, does it mean I'll be forced to pay top tier salaries just to stay competitive? What options do small businesses like mine have?
Kunal, welcome and thank you for that question. I want to clarify one thing. There is no requirement under this new rule that forces employers to pay higher salaries. The employers are required to comply with the LCA requirements. An LCA is a labor condition application, which is a prerequisite for an H-1B.
Mhm.
An LCA mandates that an employer pay an H-1B employee a prevailing wage. That is mandatory. That does not change. And nothing about that LCA or the prevailing wage is changing under this new rule. So if you were competitive under the previous version of the H-1B rule, you will remain competitive under this new rule as well. Nothing's changing from that perspective. The only thing I would urge you to do is to make sure that you're following, um, taking steps to ensure all your immigration compliance pieces are aligned. For LCAs, your public access files are available because there will be more and more Department of Labor audits that I anticipate under the new administration. There could be site visits for smaller employers. If you're placing employees at third-party sites, then what is the difference between whether those employees being placed are the employees being placed on a small project, which is a discrete short-term project, or is it a long-term assignment where that employee becomes a part of that company's hierarchy and organizational structure, and you are providing additional talent to that company. So the requirements have changed in those two scenarios, but by and large, from a wage perspective, nothing has changed. So I don't think you have anything to worry from a wage perspective, but there are other things that you need to be mindful of.
Absolutely. Thank you so much, Poonam, for your answer. And Kunal, also, I hope you got your answer. But still, if you have any other question or still you're navigating any tricky legal issue or want to have guidance, then you can also contact Attorney Poonam Gupta. And you can email her on info@summit-legal.com. And you can also visit her website, that is www.summit-legal.com. So this is for all our lovely viewers who all are watching us right now. You can also contact Attorney Poonam Gupta, and I'm sure she is going to give you a brilliant advice and definitely going to navigate all your legal issues smoothly. All right, so let's move ahead with Chetali's comment. That is, What about employees working remote? Is there a requirement for the employer and employee to be present at the company site?
Great question, Chetali. There is, the government has refrained from imposing limitations on remote or in person or any of that. All they've said in this new rule about this requirement is whatever the employer's preference is, the only thing they need to be mindful of is that they're complying with the LCA requirements. If an employee is going to work 100% remote, and there are plenty of companies that are fully remote that don't have any employees on site, then as long as they are mindful of where their employees are and that the employees are only working from the location for which they have an approved LCA, they should be fine. If the employees move to a different location, please note it is now codified. It was always, has been required for a few years since the decision in matter of Simeo, but now it's codified under these new regulations as well in this new H-1B rule, is that anytime a new LCA is required, an amended petition needs to be filed. The employee can start working as soon as the petition is filed, but there is no grace period for that amended petition to be filed. If there is a change, the petition must be filed before the change takes effect. It is absolutely critical to note that there is no grace period from any changes, material changes to the H-1B. And that includes change in location, outside of the certified LCA. If person moves to a new area, then a new LCA is required and a new H-1B petition, an amended petition is required. And for that, as long as the employers are complying with that and mindful that the employees are following those rules and staying put, then there should not be an issue. There's no requirement that that USCIS is not micromanaging where an employer and employee need to be. All they're saying is that employers should comply with the DOL and regulations pertaining to LCA.
All right. So, Poonam, we have another questions too from our Facebook people as well. But I would like to ask one more question from you: that how will the new rule is going to impact the companies that place H-1B workers at third-party client locations?
So third party, I believe I talked about this when in response to Kunal's question, but third party placement, the one benefit is that there is no requirement to include an itinerary with the petition. But what is required, and the government will inquire, is they can ask for contracts. They've codified that. They said we will ask for contracts, any relevant information that helps us understand what the relationship is. And then the nature of inquiry that they have is twofold. One, what is the nature of that placement? Is that placement a short-term discrete project placement? And the employee, the staffing company, for instance, are they placing them for a project that is discrete and not adding to the headcount or supplementing the company's headcount? Or is it an additional talent that the staffing company or the company is providing to the end client such that that placement becomes part of that headcount or that organizational structure and a critical piece of that function within that company? In the latter situation, where the employee is placed as part of a bigger team within the end client, then the big change now is under these new rules is that the requirements, the education and degree requirements for the role that is being filled at the end client control. It is not the H-1B employers, that requirements that control. It is the end client's requirements that control. So if the end client requires X number of years and degree in a specific area, then the employee has to be able to meet those requirements, and the government will ask for those specific requirements. So please be prepared to ask for those requirements from your end clients and be very clear that that is something that may be required. So that may be something you will employers will be asked to share their MSAs and contracts and statements of work and so on. But please be mindful that the government can also come back and ask for requirements, the degree and the position requirements for the position that's being filled at the end client.
Absolutely. They have to be very mindful with this. And thank you so much, Poonam, for taking these questions up and explaining all them in detail. And we also have a few questions that I would like to take, that is of Roshni's. Wait, this one. Yeah. So Roshni is saying that I work in a non-tech field, specifically healthcare. It seems like this rule is designed around tech jobs with high salaries. So do you think that workers in fields like mine will be at disadvantage under the new system?
Roshni, thank you for joining, and a great question. So while there is a lot of discussion around IT companies and staffing agencies and so on, there's actually a huge advantage to companies, potentially in the healthcare industry, if they are affiliated with a hospital or a university that is a nonprofit. There is, as I mentioned very briefly in the beginning, there is an expansion of the definition of cap exempt. Currently, hospitals and universities are allowed and do benefit from not being subject to the H-1B cap. And with the expansion of this cap exemption, um, my sense is that the healthcare field will benefit even more and not less. So there is actually a bigger advantage to the healthcare industry, in my view.
All right. So thank you so much, Roshni, for your answer, and sorry, for your comment. And let's take one more, that is of LinkedIn user that we got right now. And it's saying that does the end client, in case of third party, need to provide a job description?
Correct. And thank you for joining. Yes, the end client, again, USCIS could ask not only for a job description, but also for the position requirements in terms of education and experience that is required for that role, to determine whether or not whether that individual who's being filled in that role qualifies for that role. So yes, job description can definitely be required in addition to the requirements.
Okay. So I think from control, we got to know the user is Jigarji. So welcome, Jigarji, and thank you so much for your question. And it would be lovely if you could also ask another question that you would like to know, and we will definitely take them up. Meanwhile, I would also like to take Ashwarya's question. And she's saying that if my employer decides to sponsor me for an H1B but can't afford to pay the top wage levels, will I still have a fair chance in the lottery, or is it now all about money?
Ishwarya, thank you for joining, and that's a great question. So the one thing is very clear and has always been clear, that the H-1B program is designed to protect not only US workers, but also foreign workers. Every employer is required to pay a prevailing wage as they attest to on the labor condition application included with the H-1B. An employer cannot bench an H-1B employee without paying them. There is no benching time that's permitted under H-1B. So if an employer cannot pay the prevailing wage, then there is a problem. But it doesn't have to be top wage levels. the wage level is determined by the job description and the requirements for the role, and as well as the location for the role. So if your role, like some of the situations, and a legal way to get around the wage level issue in some situations is to move away from areas where the wage levels may be higher and move to locations where the same role can be performed for a lower wage. So if the role, for instance, is a remote role, then it is perfectly legal for the company to mandate that the employee work out of a certain area that is not as high in their salary. And if the employees do not conform to being restricted in that area, then the employees are exposing the employers to compliance issues and violation of H-1B. So it's in both the employer and employee's interest to manage and make sure that they comply with the LCA requirements. And as I said, it is not about paying the top wage levels, it is about whether or not it complies with the law. And in terms of fair chance in the lottery is not determined by what wage level you're at, where you're located. It is simply now, since 2024, the H-1B lottery is beneficiary centric, as in each individual gets a fair chance in the lottery, regardless of how many employers may sponsor them, or regardless of which country or which occupation or what level they're coming in at. H1B lottery is agnostic to all these factors. The only information the lottery requires is the individual's name, the individual's date of birth, and their passport information, purely for identification purposes and to prevent fraud. It has nothing to do with money, it has nothing to do with anything else. The lottery is completely separate. And then, if you're selected in the lottery, then the employer is required to comply with the H-1B requirements, including the LCA. I hope that helps you, and good luck.
Well, that wonderfully explained, Poonam. And this was also a very eye-catching comment that I also wanted to take that out. And I have some other questions from Facebook group as well, but we have lots of viewers that has been worried on today's topic. So I think firstly I'll take their questions. So let's take Aman's question. That is, hi, this is Aman. I heard that the new H-1B rules have eased restrictions, allowing entrepreneurs to establish their own companies. I'm wondering, can I continue working for my current employer while simultaneously filing for an H-1B through a company I create? Is that possible?
Welcome, Aman, and thank you for joining. And a great question. While I did address the piece about employer and entrepreneurs being able to sponsor themselves, this is a nuance. The question that you raised is a nuance that is also addressed in these new rules, and that is an individual, in addition to an individual setting up their own company and being sponsored by their own company, they're also able to file for a concurrent H-1B where they can work for multiple H-1B employers as long as they have a valid H-1B approved for each employer, whether it is one employer or multiple employers. And in the scenario that you list out, you could work for if I'm understanding you correctly, you're planning to work for two employers. One is your current employer, and the second would be your company where you are the owner, and your company would be your employer. And yes, that is possible. Concurrent employment is possible. And one of the nuances that may benefit someone else, if not you, Aman, would be that the individual, if they are able to find or they're working at a cap exempt H-1B employment, they could work for their own company simultaneously without going through the lottery ever, as long as they continue to work for that cap exempt H-1B. I hope that helps, and good luck.
All right. So I think, Amin, you had a great question, and we would like you to ask more questions. It would be so great to answer your comments and your questions. And next, we also have another question from Jigger, I guess. And he's asking that my LCA is filed for another state at client side. Client has allowed me initial 2 months to work remote to prepare for relocation. Do I need to change anything in the petition?
So if your LCA is filed for a state another than where you are currently, the client does not have. I'm not sure I fully understand what you say. The client has allowed you 2 months to prepare for relocation. Does that mean that your LCA has your current location as well as the client site, or only the client site? If the LCA only has the client site, then you are not permitted to work from any location other than the client site. If the LCA lists your current location as well as the client site, then that flexibility makes sense where the client is saying you can work where you are for 2 months, and then once in 2 months you need to relocate to where the client site is. So this is the only piece that I would request that you check. If it is both locations, then you're fine. Nothing needs to change. Yes, thank you for confirming that it has both, because that is critical. So if it has both, you're fine. The client has given you the flexibility and the comfort of taking 2 months to relocate, but you need to move to the client side within the 2 months as they have requested.
All right. So I think, Jigger, you got your answer. And still, if you have any questions, then please feel free to comment them. And right now, I think, Poonam, I would also like to take some of the questions, that we got from our last episode. So, Control, I would like to share the screen, and also want to know, Poonam, that, from our last episode, we got some questions. So, I would like to take them up as well.
Sure.
So,
Um,
yeah.
and
Mhm.
also, I believe there is a question from Sudhir in the chat that we should address as well that we didn't get to. But happy to answer this J1 while we look up that Sudhir's question. Could you please put up the J1 question from
Okay,
last?
okay. Okay, Poonam, so let's take the Sudhir's question first.
Oh, sure.
I
Whatever.
think I think now we are getting confused, but that's okay. Let's take Sudhir's question first. So, yeah. So here's a question that Sudhir is asking, that I have heard there's more scrutiny on the employer-employee relationship under this rule. I frequently place H-1B workers at client sites. So what does this mean for my business, and how can I prove compliance to avoid trouble?
Great. Thanks, Sudhir, for joining, and thank you for that question. As I have been harping on incessantly on this topic today, immigration compliance is critical. You need to have documentation to prove that, to prove the employer-employee relationship per se. All you need to do is to show that you control the employee's work and you are managing their work at the client site. In terms of how to avoid scrutiny, as long as you are compliant and have all the paperwork that shows the agreement that you have with the end client, what work the H-1B employee will do at the end client, what are the requirements for the end client, and the distinctions that I made between whether it is a discrete project for an end client versus whether it is a headcount increase for the end client. As long as you have clarity on that, if it is the latter, you should get the job description and the requirements for the role and ensure that the employees that you place at before you place the employees at their role, so that you can confirm that those employees will qualify for H1B. Um, as long as you have all your documents, I don't anticipate that you need to do anything extra on top of it, but you do need to maintain your corporate documentation and your contracts fairly carefully and more diligently and much more organized, so that if you're ever questioned about it, you have them handy. And it may be worth discussing this change with your end clients to say, so that they are prepared for providing that information. There are plenty of clients that we've heard where the end clients are hesitant and reluctant, and sometimes outright deny any request for cooperation for H-1B for employees placed on their side, on client side. And it's worth proactively bringing this up with your end clients, so that you can avoid any compliance issues or any scrutiny down the road. But if you are compliant and if your end clients are cooperative, then it should not be an issue whatsoever.
All right. So here we have another question from Amit too, and Amit is saying that I run a staffing agency and place H-1B workers at different client locations. So does this rule mean I'll have to provide more paperwork or evidence of work relationships? If so, then what kind of documents are we talking about?
Great. Thanks, Amit, for joining, and thank you for that question. You are correct. There is a possibility that you may need to provide more paperwork and more evidence of the relationships. Um, it's up to the government what information they want, but proactively, when you're filing these H-1Bs going forward, I would suggest, at least for the petitions that you file after January 17th, to include proof of any end party placement. If you are placing them at a third party, then proactively provide your contract with that third party, the statement of work, the scope of work. And again, if it is a discrete project, then you don't need to provide anything else. But if it is a headcount increase, or where the employee will become part of the organizational structure of the end client, then you should proactively ask for the job description and the job requirements for that role, and provide them with the H-1B filing and prove that the employee has the necessary skills and the specialized knowledge to qualify for that H-1B. So yes, there are more documents, but they are common sense documents. But agreed, it is more burdensome. There is a higher burden in that sense on the employers, but the goal is to ultimately prevent fraud and abuse, which ultimately benefits everyone. So in short term, yes, it is problematic and more burdensome, but long term, I think it only helps all of us if we proactively provide all the information upfront without the government asking for it.
Absolutely. Wonderfully explained, Poonam. And I think, our viewers are also loving your insightful conversation that you are sharing with us today. And also, we have RK. So let's take RK's comments as well. So RK is saying that why so must employers concern about site visits? With more site visits, it can help with the improving the views that there is a lot of fraud in the H-1B program.
Right. So why should the employers be concerned about site visits? Up until now, the site visits it was optional to cooperate with the site visit, if you will, but now it's mandatory. Under this new rule, employers and employees are mandated and required to cooperate with the government. If they do not, then the H-1B petition could be revoked or denied, depending on where they are in that state. If the H-1B petition is pending and then the site visit happens, then if the employer does not allow the FDNS officer, access to the site, to whatever documents they want and confirm whatever information they want, then there is the potential for denial of that H-1B. If the site visit is after the H-1B is approved, then, and if the company does not cooperate or does not provide all the documents, then there is the potential for revocation and more site visits. So it is in the best interest of the employers to comply with the site visit requests and help um, address any concerns for abuse. And I have to tell you, these site visits are random and common. We've had situations where employers, like the same employer, had 3, 4 site visits in a span of 1 month. And it all worked out. The questions were not crazy, intrusive, or in any way something that were not anticipated. And there were no questions that we did not have easy access to. I would also highly recommend, whenever you get notified of a site visit, or if an officer just shows up at the door, which most of the time they will, then you should call up your attorney. And if the attorney cannot join by phone, or if the attorney wants to join in person at the time of the site visit, to request the officer to reschedule the site visit at a time when your attorney can be present. I would not recommend any employer to go through the site visit without their attorney, just because it gives the attorneys able to address those questions and address anything that the officer may be asking that they should not be asking right at that point, and push back if needed. But most of the time, in my experience, it's a fairly straightforward request, and just providing that information helps not only that employer but everyone else.
Absolutely. And I think, Poonam, site visit are being a very hot topic nowadays. People are very much concerned about it. And I think we have another follow up question or follow up comment from RK, that is, with more sites, this will allow the government to publish data to show X amount of companies and compliant. This concern about this provision may wrongfully imply that there is a lot of fraud.
Thanks, RK, for that. I'm not sure exactly what you're trying to say, but what I can discern is that the government occasionally does publish the site visit data, or other data, not necessarily how many site visits they've conducted, but they do provide some data about the workings of the FDNS. And there is a there is some fraud in the H-1B program. There are some unscrupulous employers that want to take advantage of the H-1B program,
Yeah.
that exploit workers and do not pay them as they should, or do not comply with the LCA requirements. And that is the goal of the site visit, to identify such unscrupulous players, such unscrupulous employers, and take them out and shut down their programs so that it doesn't impact the integrity of the broader H-1B program and everyone can stay compliant.
Absolutely, and I think that's how, anyone. I mean, I don't think that there should be anything that people should be scared of site visit, because if you have proper documents and if you are fully aware with all the updates, then I think it will be safe and there's nothing to be worried about. And sooner or later, it's very important, friends, to stay updated. So yeah, that's what I would like to share. And here's another question, that is, does the new rules regarding end client documents also apply for assignments started and petition approved before 17 January as well, or only for new petitions?
Thank you for asking that question. It's a great question. And yes, these new rules go into effect on January 17th and will only apply to any petitions that are filed on or after this date. So if anything is initiated or approved before this date, these new rules will not apply. But to be very clear, these are just codifications, and some of this USCIS is already doing and already requesting proactively. And all the new rules do is codify and request that an employer is mandated to provide these. Up until now, the government would issue a request for evidence asking for this information if they felt that the employer did not provide sufficient information.
All right. Also, Poonam, as we have crossed 1 hour, so I would just like to know it from you. Is it okay if we could extend for 5 more minutes our session?
Sure,
Oh,
we can stay
that's
on. I know there's a lot of questions, and there will be a lot of questions if people become aware of this. And
absolutely.
happy to answer as many questions. So please keep those questions coming. We have posts on LinkedIn and all the other platforms. Please continue commenting. We will continue to address those questions even after this event is over, and if needed, maybe come back another time. But for now, please continue to comment and post your questions.
Absolutely. That's so sweet of you, Poonam. And also to our viewers, as Poonam said, that please go on commenting and posting your questions. And even after the show, even after the event ends, we will definitely take them up in our upcoming shows as well. So here's another, here's a comment that we received. Thanks a lot, team. This is really insightful to be prepared proactively. Thank you so much, Jigger. I hope I'm pronouncing your name correct. If not, then please write your name properly so that I can greet you well with your name. But also, Poonam, I would like to ask another question regarding the topic. That are there any potential challenges or drawbacks, that employers and workers might face under this new H-1B rule, despite its pro-immigration and tech-friendly aspects?
Um, the challenges, the biggest challenge may be the compliance piece, and for as you've seen, the questions that have been coming from staffing agencies and companies that face employees and clients, the biggest concern is the additional documentation. That I think will be the biggest burden under these new rules. Other than that, it's just codification. The benefit will be far more than the drawback. I think the only drawback will be additional documentation.
All right. Okay, so I think we can see very less challenges here and more pro-immigration and tech-friendly aspects in this new rule, and that's absolutely perfect, and that's lovely to know about it. Also, I would like to now come back to the comments that we received from our last episode because that is also very important to cover. So, Control, I would like to let us know about the comments that we got to know from our last episode. That is, I am currently on J1 visa and my visa expires in 2025. My spouse, who is a J2, his company is offering him L1 from India to the company here in US. I am not on government funded program as I am directly working for public school. Will he be able to transfer from J2 to L1 with recent changes to the skill list?
I'm assuming this person is from India, Sam. Assuming this person is from India,
Right.
then yes, they will be able to transfer because India was removed from the skills list and there is no 2-year home residency requirement applicable for this individual. To be 100% sure, my recommendation would be that they request an advisory opinion from the Department of State to avoid any surprises because while the J1 skills list has been updated, the officer's knowledge and comprehension of those rules may take some time to catch up. So, to that end, I would urge everyone that is in a situation where they think they will not be subject to the 2-year home residency requirement to please request an advisory opinion from the Department of State to benefit and to get clarity, have something to show when you go for that counselor appointment or when you apply to USCIS to support your not being subject to the 2-year home residency.
Absolutely. And here we have another comment too. That is, hello, I'm an Indian citizen. I was in J1 visa during the year 2021 as an exchange student. Our program was self-funded and I was subjected to 212E clause. I'm currently in US in my F1 visa. I didn't complete my 2 year in India. I'm in the process of preparing for applying to get my waiver. Based on the new updates, do I still need to apply for the waiver?
Great. Thanks, Sam, for bringing that up. So, 212E clause, to clarify, is the regulation or that requires the 2-year home residency requirement. So when this person says, I was subjected to the 212E clause, it means that they were subject to the 2-year home residency requirement. And that's what they say, that they haven't completed it and were applying for a waiver. As an Indian, they are no longer required to apply for a waiver. They say their program was self-funded, so I think it is fairly clear that they do not need to apply for a waiver. They are not subject to that. Again, if they have any doubt and to avoid any confusion on any agency's part, it may be worth requesting an advisory opinion to have a government document that confirms your understanding. So that is the best way to confirm and to avoid any doubt for anyone at any point.
All right. So yeah, I think these two comments were from that we received from our last episode, and I think Poonam, we have covered all the comments, all the viewers' question that we have received regarding our today's episode. So I think yeah, that's lovely, and we also have come across 1 hour, and we didn't even realize, and it's been more than an hour because it's obviously a very new topic. And thanks to you, Poonam, for letting us know, for suggesting this topic. It's really amazing, and it was so insightful. I enjoyed a lot this session, and I hope you too. But meanwhile, also, Poonam, any last tip or any last message that you would like to share with our so many viewers today?
Sure. One of the things that everyone is concerned about, that we didn't get to talk about, is whether this new rule can be um, turned upside down or retracted when the Trump administration comes into office. The new rule goes into effect January 17th. The new administration comes into play on January 20th. What can they do to retract this new rule? So there are a few ways that things can change. One is obviously they can go to court and prevent something from going into effect or any of that. If that happens, obviously we will keep you posted. But barring that, all the other pieces, all the other actions that they could take are not immediate. If they want to modify the rule or change the rule drastically, they have to go through the notice and comment period that this rule went through. So as I mentioned, this proposed rule was first issued in October of 2023. Comments were open until December of 2023, or November, 60 days. And then after that, the government issued a limited portion of that rule to implement the changes to the H-1B lottery. And again, it's taken them almost a year to address all the other comments that were raised with regards to this new rule, and they've issued this rule to go into effect. So any changes to this rule will have to go through the whole notice and comment period again, which will require some time. And even the best case scenario, it is at least a few months, potentially longer, before any changes can be implemented on a regulatory side. The Congress can always enact a new law, which, knowing what we know, I mean, with the government, I don't know, I haven't looked at the news this morning, but as of late last night, the government was going to shut down because the Congress couldn't come to an agreement on the budget. So how well and how quickly that will pass is anyone's guess. So to the extent that gives anyone any comfort, this rule is here to stay, at least in the near term. There are plenty of enforcement provisions within this that align with the incoming administration. So I'm hoping that, given the enforcement bent of this new rule will be left alone, and the new incoming administration also has different priorities, and this may not be as high on their priority list to tackle as other things, and mass deportation seem to be the top matter, and this is far from it. So I think we may be okay, but only time will tell.
Absolutely. And with Trump's administration, it's so unpredictable. We can't even predict what's going to happen. But
But we'll deal
let's,
with it.
yeah, absolutely. Let's see and what happens. And I would say with that, Poonam, we have successfully done with our today's episode. And friends, we talk about the new H-1B rule, where we covered everything about like how is it a game changer, what are the key changes, and how is it impacting both the workers and the employers, and also what you need to do to stay ahead. So I think these were some of the very important topics that we talked about. And also, I would like to say, Poonam, that your expertise and your clarity on this topic, made everything so much easier to understand. And I'm sure, that our audience learned a lot from you. They loved your insights, and it's been a really pleasure having you on the show. And we are super excited to have more shows with you.
Likewise. Thank you, Sam, for having me. And it's great to be able to address the questions and, calm some of the people. The immigrants get riled and get upset and anxious very quickly for good reason. And I'm happy to do my part to help whatever I can to help the immigrants in their journey. So good luck to everyone and happy to be here.
Wow. That's lovely and that's amazing. And thanks to our viewers also for joining us and participating in today's episode. I hope you found this session helpful. In case if you have any doubt, then go ahead and post them in the comment section. And also, if anyone is navigating the intricacies of visa applications or facing legal challenges or simply need guidance on immigration policies, then please feel free to contact Attorney Poonam Gupta on the given contact details. You can email her on info@summit-legal.com, and you can also visit her website, that is www.summit-legal.com. So this is the contact detail that has been displayed on the screen. You can go ahead and mail her, or you can also visit her website. All right. So thank you so much to everyone, to our attorney, to our viewers for joining us and making this session a great one. As always, stay informed, friends, by liking, sharing, and subscribing to the Immigration and Jobs Talk Show for more updates. I'm Sam, signing off for now. Bye bye and take care.
Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm very happy to have you join us. And before we start off with today's show, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Thank you so much, folks out there, for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and on X. So please feel free to join us, by commenting, especially with regard to our topic of today. And before I tell you who's going to join us, you can also join us on call by dialing this number 425-436-6335, and the access code is 988-888. And once you're in, you just say hello, we will be able to hear you. So, folks, today's topic of discussion is Trump 2025. Who's on his new team and what does it mean for America? I know there has been a lot of discussions and news on this. Every day you hear something about Trump's team, and we are all excited to know what's going to happen once Trump returns to office. And I'm very, very excited because today we have a truly distinguished guest joining us, someone whose name resonates in the field of business and immigration worldwide, by the way. And so, ladies and gentlemen, it is an absolute honor to introduce Charles Cook. Thank you so much, Charles, for joining us. And
Natasha,
Charles,
thank you very much for having me.
thank you so much, Charles. This is probably our second time, and I'm very excited that we're going to have this discussion today.
Well, I'm looking forward to it because nothing gets the blood going more than talking about Donald Trump.
I know, passion comes running in, right? Both ways. So, Charles, folks out there, Charles is a globally recognized business and investor immigration attorney and a fierce advocate for sensible immigration reform. So, I'm sure it's going to be awesome if you could join us, especially with your questions. You can comment or call us. And, Charles, maybe tell us what's going on with you these days.
Well, with me, we're in the United States, we're getting ready for Christmas, hence your Christmas theme. And it's of course a great time to be alive. And I'm looking forward to my grandchildren coming to my farm this weekend and having just a wonderful and joyous time.
Absolutely. I'm sure. Will you be playing Santa?
No, I'm not big enough to play Santa. I don't want to ever get big enough to play Santa. But if my checkbook counts, yes, then I'm playing Santa. It just depends on how you approach it.
It works. I'm sure it's going to be very exciting. And here's wishing you and your lovely family a happy Christmas season, happy holidays, a good time in your farm. And I'm sure it's going to be awesome with you.
Thank you. It's going to be a good time. But we have to get back to the topic at hand, don't we?
Yes. So
you probably
what can folks out there expect?
You're probably not aware that even though Trump doesn't become president until January 20th, I believe, he's already basically acting like the president. And we literally are in our very first, right now as we speak, the very first Trump crisis of his second term, in that he's basically telling Congress to shut the government down today at midnight. There's literally 2 votes that have failed. President Musk has put his imprimatur on some items here. So as co-president, Donald Trump and him are deciding, even before he's president, what's going to happen to America. And if this little taste of chaos isn't enough for you, we can jump right into the immigration stuff, because chaos will rule supreme for the next 4 years.
So yes, this shutting down of the government, is it true? What's going to happen? So it's like the transition period, or?
No, well, it's really interesting. The reason it's shutting down is because the government doesn't have a budget. So no budget has passed, and there's no budget. The government just stops working. Now, the interesting thing, part of that, Nepal, is that the Immigration Service, USCIS, is actually not funded by the budget. So USCIS keeps operating. But ICE is funded by the budget, which is the immigration enforcement side. The consulates are funded by the budget. They shut down. And at midnight tonight, the budget is over. So what I heard literally just before coming on the air, that they're trying to consider a plan C, since plan A and B have failed. Plan C will be a series of votes on a series of proposals that will ultimately lead to the government not shutting down. But Republicans who control the House, and in our system, the House controls the budget. All budget bills have to come out of the House. Republicans only have an 8-seat majority. And they have about 35 members who are basically insane. And they basically love shutting down the government's the greatest thing. They hate the government. Isn't that ironic? They became congressmen so they could hate the government and shut it down. So they need Democrats to support the bill. But if Democrats, look, if you want us to support the bill, you gotta give us some cheese. You gotta do something for us. And that was the very first bill that President Musk came down and said, no, this is terrible. This is terrible. We can't do this. And so Democrats are now sitting on the sidelines going, not really our problem. We don't have enough votes to pass our bill. What are you going to do? So it's literally a chaos show right now, Nipasa. If it wasn't so tragic, it would be funny.
It would. I know it's crazy. I think we can only keep guessing until it really happens. So let's see what's going to happen after midnight tonight.
I'm sure these things never happen in India. I'm sure it's nothing like this.
No, never heard of anything as such anywhere actually. All right, so let's go on. Let's go on to our topic, and I have a few questions. So let's dive right into our first one. So,
Okay.
given the Trump administration's historical stance of immigration, how do you foresee the key changes or continuations in immigration policy if he returns to power after January 20th?
Well, it's interesting. I've seen a lot of stuff on a lot of websites, particularly from India, about how Elon Musk is going to temper the hawkish nativist movement within the Trump administration. And to that, I say, you're delusional. President Trump said that his primary key advisor on immigration is a man named Stephen Miller. Stephen Miller is the grandson of Holocaust survivors, Jewish, and truly hates immigrants. The irony doesn't escape anybody. He was the principal architect of all of the anti-immigrant nativist movement in the first term, and his position has been elevated into the second term. And people will say, well, they're only going to go after illegals. It's just the undocumented people. That literally is not true. There are already laws allowing Trump to deport people. They just need money to do it. What was evident in the first term will become more evident in the second term. The lowest levels of legal immigration that we had since 1789 were during the Trump years. Why? Because they're going to do certain things to, one, slow down every process. Now, Biden has been no jewel. He's been no great immigration god to anybody. He's done a crappy job as far as I'm concerned. But Trump will intentionally destroy the system. So I'll give you a great example. One of the things that Biden did fix was the naturalization process. People had green cards, become citizens. Under Trump, those were taking about 2 to 3 years. The last couple of years under Biden, it's been taking 4 to 8 months, much quicker to become a citizen. Green cards. The Trump administration is the administration that did not use all of the available immigrant visas that I had to sue them on back in 2020. They also are the ones that proposed terrible H-1B regulations that I had to sue them on in 2018 and 2019. All of those things are coming back, except this time, the people that are in charge have learned their lesson. Everybody under Trump previously were newbies. They were new people. They really weren't ever in government. They didn't know how the mechanisms of government worked. They've now had 8 years to learn, and they now know. So starting with Stephen Miller, who is basically the number 3 or 4 guy in the White House, and then followed behind him on the enforcement side is a guy named Tom Homan. Tom Homan used to be the head of, well, he wasn't even head of ICE. He worked at ICE, but he's been a Fox News contributor on immigration for years now. And he portrays this kind of tough guy. Yeah, we're going to, you lawyers, we're going to arrest you for helping immigrants. Really a tough guy kind of thing. But actually, it's the people below them that are going to make a difference. So the key changes, one, we will see things like a slowdown in immigrant visas. I-140s, for example, slower processing. We will see slower appointment times at the consulates. We will see tougher adjudication standards on a lot of different applications. And we will see things like the H-1B visa. We anticipate that sometime in the first year or so, the Trump administration will propose a new H-1B regulation on wages and say that, yes, there's a lottery, but this lottery will be on the wages. Whoever is getting paid the most will get the H-1B visa, as opposed to just what we have this next year, just a sheer lottery, basically by individual, not by employer anymore. So all of those things, and that's kind of the 35,000 foot view, but we can go into a lot more detail as we talk about this today.
For sure. I mean, I hear about that. We had a few discussions, and I mean, if people who are going to be paid most wages are going to be preferred, then I'm sure a lot of small businesses, startup companies are going to suffer on that. You know,
Nonprofits, hospitals.
yes.
It would be disastrous, but Elon Musk would get all of his people that he wants to hire. The irony here is that Musk is an immigrant, right? That's the ultimate irony here. And in fact, he appears to have been undocumented for a period of time after he was from a student visa before he got an H-1B. And when he was getting his H-1B back in the 90s, it was much easier to get an H. There was a lot more H-1Bs available. So the irony doesn't escape anybody, but here's a guy that's kind of a nativist that started out as an immigrant. It's something we actually see quite often, which is kind of shocking. Close the door behind me kind of people. So go ahead, ask some more questions. We got some great questions here. I know you've got a lot more you want to ask me. We can even talk about the individuals that we know will be running things besides the guys in the White House.
Yes, absolutely. And you were talking about Stephen Miller. So I think I want to ask about him, when you talk about immigration reforms and, the executive actions, particularly concerning asylum policies and refugee camps. What would you like to say about that?
Well, I have just briefly about that. Biden this last month, this November, appears to have been the lowest number of people that came to our border illegally in about 10 years. So even lower than when Donald Trump was president. These are, of course, Biden policies. The thing that's helping is that Republicans are no longer saying, the border's open! The border is open! They go on Fox, the border is open! Well, if you've got Congressman or Trump yelling that, you know where that plays on the news? Guatemala, El Salvador, Nicaragua, Colombia, China. Oh, the border's open. They said it was open. I'm going to come to the border. Since they stopped talking about it, the numbers go down. How ironic is that? Biden had just enacted this last week some asylum reforms that will make getting asylum, the initial interview of asylum, much harder than it has been, and allow for asylum officers to reject people faster. That doesn't mean that they will. I mean, one thing you have to understand about asylum, people coming to the border, is that desperation drives a lot of people. There's a lot of desperation that goes on there. And you can't build walls high enough. You can't erect barriers big enough to stop desperate people. You just can't. What you could do is have a legal immigration system that paves way for them to come, which, of course, we don't have. So the reform, now Trump wants to put back into place something called MPP. MPP is called Remain in Mexico. Let's say somebody from India says, I'm going to, they're going to kill me in India. I'm going to come to the United States. I'll go to the border, go to Mexico, go to the border. What MPP says, you're going to wait in Mexico until we have time to talk to you. Well, you know who that was great for? The Mexican cartels. Mexican cartels would rape, kidnap, extort, charge people for that. Their cartels were in seventh heaven under MPP. But MPP didn't stop people from coming, because one of the weird things that MPP did was that if you came in and were tossed back, that did not count as an illegal entry. So the bars that are in our laws that then punish you for doing that were gone. It literally was the least effective program ever created for the border, besides the fact it's probably illegal and in fact was stopped one time by a judge. So these asylum things that you see at the border, that's probably history at this point. The numbers are now equalized. They're fine. More people come in by appointment to apply for asylum than come illegally. So, that, and I know, and it upset a lot of people that were legal here, justifiably. People that been here for 10 years, no papers, and people were coming in right now and applying for getting a work permit. Well, it doesn't sound fair, but that's what the law is, right? So if you do apply for asylum, you do get a work permit. It doesn't put you in front of the line, though. The line is still what the line is. And even if you get asylum, even if you get approved, which only 30% of people do, the reality is you have years before you're going to become a permanent resident. So unfortunately, there was a lot of misinformation. It caused a lot of bad feelings. Immigrant groups cannot afford to fight each other. They need to fight together to make the pie bigger rather than fight over one piece of pie. And hopefully we can come to that kind of understanding this year, because it's going to be really important under the Trump administration.
I hope so. I hope so. And talking about, border security, you were saying, do you think, that the Trump administration, in terms of border security and immigration enforcement, what do you think is going to look like, especially with
It's going to be
movement, coming into force, the border czar?
it's going to look really ugly. The image that people have of America, the shining city on the hill, as Reagan talked about, the Statue of Liberty, we might as well burn all that down because they're coming for people. Now, you have to ask, how are they going to identify bad guys, undocumented? How are they going to do that? Nipasa, there's really only one way to do that, and is to look at you. And they'll say, oh, Nipasa, show me your papers. Like we live in Germany in 1933 or something. Now, what they will do is they will actually begin with the easy stuff. So ICE, which is the enforcement part of immigration in the United States, Immigration Customs Enforcement, they're inherently lazy. All right. They're not, in order to go find people, they're not going to drive buses through trailer parks looking for Mexicans. They're going to go after first people with criminal convictions. Now, here's the thing that is truly ironic. If you ask an American, just an average American who voted for Trump, how many illegal aliens with criminal convictions do you think there are? They will tell you, and there's a poll that said this, like 4 million. There's 60,000. There's 60,000. Now, there's about 300,000 people that do have criminal convictions that actually have orders of deportation that are not in custody because they cannot be deported. Their country refused to take them. Now, one thing that Trump did that was good last term, that no other president really did, he basically threatened countries. If they didn't take the people that we wanted to deport back to them, he would start a trade war. He would just put sanctions on them. He would put tariffs on them. He would cut off aid. And miraculously, some of these countries actually took people back. China was one of them. China doesn't take anybody back. Cuba is another one. Israel doesn't take Palestinians back. There's all over the world that people don't go back. But what's the purpose of detaining them? You can't deport them. So the next group of people are those that are simply have removal orders. There are over 1.5 million people in the United States, as far as the government understands, that actually have deep final orders. They've had the due process. They got denied, but they don't know where they are. So they're going to have to put resources towards literally finding them. Now, are they findable? Of course. ICE is already using AI to do that. But ICE is only funded to deport at the most 400,000 people a year. It just was announced that last year, Biden deported more people in 2024, fiscal year 2024, than Trump ever did in any year. So Biden is right after Obama in deporting people. Trump wants to get up there and do that. And they talk about deporting 8 million, 9 million, 10. That's completely unrealistic. It's not going to happen. But what they will be doing is scaring people. They will drive undocumented further underground. And if you think that all undocumented are Mexicans, you're sadly mistaken. Do you know how many Indian nationals that I know that are undocumented? I probably have a couple thousand that are my clients that are undocumented Indians. There's probably close to 500,000 undocumented Indians in the United States. So it's not just a Latino problem or a Central American or Latin American problem. It's a worldwide problem that we have. So I see this very aggressive type of work. Now, on the flip side, so Holman's going to do that. That's kind of his bailiwick. ICE is going to also do worksite enforcement, and for H-1Bs, lots of what's called FDNS, or fraud detection national security visits to H-1B visa holders. They're asking for more money in the bill that will likely pass in April or May or March, something like that, to get more officers to do worksite visits for H-1Bs. ICE will also be doing they don't really do random audits. What ICE did last time, and they'll do again, they have a phone number. And they say, look, if you are an American and you think you see undocumented workers at a company, call us. And under Trump, they had lists they never even could get to. The Biden administration did no worksite enforcement, none. There was no new worksite enforcement. So we'll see that. But what's going to happen, a lot of these people that own these businesses that employ undocumented workers, typically working on fake documents, they voted for Trump. So when ICE starts going after these businesses who are Trump voters, you're going to start hearing weeping and wailing and gnashing of teeth, biblical level complaining. And what you will see is ICE will back off because Trump doesn't want to hurt his friends. I would love to see, though, an employer site visit to SpaceX. It would be kind of cool. Or Tesla plant. So this is undocumented workers going to be under pressure. This will be nothing like the Trump years, the Obama year. Obama's were worse, honestly. The first 4 years of Obama were terrible. We'll see. We'll approach it, but we won't get there. Mostly because it's a very different world we live in than even just 10 years ago, or 12 years ago, or 14 years ago when Obama was president. So it's gonna be crazy, and a lot of innocent people will get caught up, including a lot of Indian nationals.
So do you think because Biden, during Biden, it was not so strict with regard to in the borders, right? So many people could come in, and
well, that's
after
not
they
true.
came
See,
in-
that I'm going to cut you off because that's literally not true. There is a perception here that Biden let anybody in. You know what Biden did?
Of course not.
Biden followed the law. He followed the law. 8 USC 208. Anyone who comes to a port of entry is allowed to apply for asylum. Period. End of story. It's the law. The law was the problem, not Biden. It's Trump that was violating the law. So Biden did his best to follow the law and then change policy and regulation so he could still be within the law and try to stem the flow. But Biden didn't open the borders. They didn't say come in. In fact, it was, as I said, Republicans said the borders are open now. Biden's president, and that just didn't happen.
It didn't. Right. But yeah, thank you so much. I mean, that was very, very intense, but we have so much to cover. So let's go on to our next. No, it's cool.
You know, I need a
It's good to
vacation for Christmas.
Well, I do hope we end with good things and good notes so that people can enjoy their holidays at least.
I hope so. But you know, there's
I hope so.
a lot of people. Let's talk just briefly, if you don't mind, about the people that will be running immigration. So they've been identified now. There's two former Trump people that worked extensively in the immigration service in his last term. One guy's name is Joe Edlow. Joe was actually acting head of immigration at one point. And the other guy's name is John Zadrozny. Both of them are true believers in Trump. Now, this is USCIS. These are the affirmative visa people. So one immediate change, we'll see they have to be confirmed first, but some immediate changes within January, February, March that we'll see. We'll go back to interviewing everybody that's getting a green card. Everybody getting a green card will be interviewed. Trump started that. Biden kind of ended it. It'll go back. This includes every employment-based case. Everybody gets interviewed. Now, when you do that, Napasa, and you don't hire more people, what happens? It just gets longer and longer and longer and longer and longer and longer. That's what leads to 2 and 3 year adjustment of status. Because we've had a lot of clients get approved in the last couple of years on, let's say, an I-140 is approved, file an adjustment. Boom, it's approved in 30, 60, 90 days. Those days are over. They're gone. That's one policy. The other thing that we will see is some changes proposed to the H-1B. We talked about the fee rule, but Biden just changed the definition of specialty occupation, how to prove specialty occupation, and who doesn't qualify for an H-1B. So a BCom no longer is an H-1B. A degree, a bachelor's degree in business is now not a specialty occupation. You need something very much more specific for H-1Bs. Trump will take that to the next level as part of this application. So we're going to see a lot longer visa processing times within the USCIS, and we're going to see a lot more green card processing times. The other thing they're going to do, and this is truly sad, when Biden took over and Urchanu became USCIS director, she let us know that immigration was only staffed at 60% of what they needed to do the work that they had. They were 40% understaffed. So they literally last month finally got fully staffed. What these guys are going to do is shrink that workforce. Again, if you have fewer people adjudicating cases and you have the same number or more cases, it's going to take longer. And so we're going to see these really long visa processing times just to get an H-1B approved, which means a lot more people will pay, when available, premium processing. So immigration will make more money by being incompetent. It's a great deal if you can get it. So those are some of the big impacts we will see. We're also going to see, like on L visas, an even more tightening up of what a manager executive is. We're going to see a tightening up on O's and extraordinary ability. And I think Trump may end the Biden policy on national interest waivers and make those as hard as they were back in the day, because national interest waivers have become very easy in the last several years with the Biden policy. And that's a policy. That's literally a day one. I dismiss this order. I cancel it. It's gone. Boom. Overnight, you have a pending case that would have been approved, now gets denied. So if listeners have an NIW pending, they should be premium processing that, because you don't want that still pending when Trump's president.
Yes, and you still got exactly 1 month, you can say, for that. So as soon as possible, get things done. Yeah.
31 days and Trump is president.
Yes, yes. And about the H-1B new regulations also, we hear a lot of changes coming in. So do you think that is also going to affect, or it's going to be great during Trump's reign?
Well, the ironic part of these new regulations on H-1Bs is that some of them are proposals made by Trump, like the tightening up of specialty occupation. If anybody goes on Twitter, there's a lot of hate towards H-1Bs. I mean, a lot of hate towards H-1Bs. And as a result, Trump hears this, his minions see it, and they say, what can we do to limit? I mean, they can't eliminate H-1Bs. They can't do that, but they can make them a lot harder to get. And a lot of the complaint, of course, is that job shops use these. Now, if you go back and look at the biggest users of H-1Bs last year, there's only like one job shop on them. There's only one outsource. I mean, the rest are like Amazon's the number one user, Microsoft, Tesla is up there in the top 10. So it's not that there's a lot of outsourcing jobs here. And that's, of course, you would hear from is Americans who were laid off. So as an Indian H-1B engineer making $60,000 can do his job. Well, if you're doing a job that somebody else with a less education and experience can do, then you need a different job. I mean, then you're in the wrong job. So it's but there'll be going to be a lot of pushback on these H-1Bs. There's not going to be, I don't see any litigation possible on these new regulations. They're well within the authority of the Immigration Service to issue. None of them are truly outrageous. And there are a couple good things in there. For example, if you were previously approved for the same job with the same employer, they're basically going to approve the extension. There's going to be a deference policy. If anything changes, no deference, but deference is a really, really important thing. So that's how I see those H-1B rules shaking out. We have to modify how we do a couple things internally at the firm, but for the most part, it's going to be business as usual on H-1Bs that we do.
Okay. Now coming back to more questions, let's talk about Vivek Ramaswamy, advocating for merit-based system. So how do you anticipate his policies will reshape employment-based immigration categories or even family-sponsored visa programs?
Well, the good news is that Vivek Ramaswamy has no power over immigration. And there can be no merit-based system or point system unless Congress gets involved. Congress has to change our law. Vivek Ramaswamy can't change our laws. The irony is, of course, his parents were H-1B visa holders, right? And would his dad have come under the new regulations? That's a good question. I don't know. Maybe he would have, maybe he wouldn't have. If Ramaswamy and Musk are examples of close the door behind me, I'm here kind of immigrants. The kind I truly detest. People that don't want others to have the same opportunity that we did. America is a big country. It's a big country. I mean, it's not India. It's only a fifth the size of India, right? But physically, it's a big country. Economic power. There is room for hundreds of millions of more people. There is. And there's the opportunity. When we bring an H-1B immigrant in, on average, they create 4 to 5 jobs for Americans. On average, they create jobs. H-1B immigrants are job creators. They're not job takers. And that's true from the janitor or the guy picking your mushrooms or picking your melons in the field to the guy building rockets for SpaceX. We've got room for a lot more people. We're still living, however, under 1990 rules. All these rules we talk about for employment were created in 1990. We were a very different country. Heck, my cell phone in 1990 was in a bag that I carried around that only reached 3 miles. So we live in a very, very different country, and maybe Trump's the guy to fix it. More power to them if he can fix it. I just don't see the level of competence in the administration doing that. And of course, I see a real nativist streak in Stephen Miller and Tom Homan. They don't want more immigrants. They don't. So do Musk and Ramaswamy have the power against Miller and Toman? Well, Miller and Toman are sitting in the White House. Ramaswamy and Musk are too busy down at Mar-a-Lago. So I think the nativists are going to win the day here, and we're going to have to wait till 2029 to fix stuff again. That's my prediction.
Logical, very much. Thank you so much. Now let's go on. So do you anticipate any changes in approach to also family-sponsored immigration categories, F1, F3, F4 visa categories under Trump?
You left out F2. Again, we've had extra employment-based visas for several years because the consulates, who do most of these are under the consulates, were slow. So I suspect that there will be a slowdown in visa processing. Heck, the Muslim ban that he's going to put back in place, there will be a Muslim ban. It'll be broader than before. That will slow down massive family-based immigration, which means there'll be more employment-based visas in fiscal year 2026 is my guess. So yeah, it'll be a slowdown. He can't deny the visas. I mean, the visas are the visas. But I also see him bringing back a new, the what's called the affidavit of support rule, the public benefits rule, and making it much harder for people to come in who are poor, whose families aren't wealthy. I see them bringing that back. That's going to be quite a fight, as I can tell you.
Okay, thank you for that. I think we should quickly take up RK's question on YouTube before we head on with more questions from us.
There's a lot of great questions here.
Yeah. Do you think for H-1B wage base, it would be the highest wage per occupation? And that means if you're the highest paid for your occupation, you're eligible for the lottery regardless another occupation.
No, it will be the highest wage. So you're at Apple and you're getting paid $395,000 a year. You're getting an H-1B. You're working as a software engineer at Bob's muffler shop, and you're making $40,000. You're not getting it. This is not across teachers, software engineers, doctors. No, the highest wages. That's what is going to happen. That's what they want to see.
Okay,
it's a great question. I like it, but it's not going to happen.
There's another one that follows. Example, highest paid teacher. Okay, you've already explained. Okay, let's take up.
Ankit has a great question.
Who?
Ankit's got a great question there. 123505.
Hello,
and not
Charles,
because
sir.
he said our show was amazing.
Yes, he says. So glad, Ankit, you've been following. And he's saying, I also want to ask that the RFE ask for additional evidence to prove that my job qualities as a specialty occupation. What kind of documentation should I submit to demonstrate that position requires bachelor's degree or higher?
Well, you shouldn't be following it. Your lawyer should be following it. Basically, you're going to start with the Occupational Outlook Handbook, which describes every job in America and what the educational requirements are. You're next going to look at advertisements for that job from other employers. What do other employers say is required for that particular position? And remember, it's not that a bachelor's degree or higher is required. Under the new rules, it's a specific bachelor's degree is required. So they're saying that jobs like systems analyst no longer requires a degree, because I can teach somebody to do that in a week. I don't need anybody to do that. So a lot of H-1Bs are going to lose their H-1B when they renew because of this. So you're going to look at what is generally required in the industry. You're going to look at what the academics say the requirements are. You get letters from experts that say a bachelor's degree is required for this job, you get a very detailed letter from the employer explaining why a bachelor's degree, you have to take these classes in order to understand how this widget works. So all those things have to be part, and that's why H-1Bs are going to get a lot more expensive, because it's going to get a lot harder to do this.
Right. Thank you so
At
much,
least for
Ankit.
some
I hope
jobs.
this
At
brought
least for some jobs. I'm filing an H-1B for a lawyer. That's easy, right? Requires a JD. Thank you very much. Boom.
So I think he will need an evaluation as well, right? For
Well,
his.
the evaluations are done for the individual. Do they qualify for the job? You want to get an expert opinion that says this job at this company and in this industry, this requires a degree. And here's how I know, because I've been teaching this subject at Harvard for the last 30 years and blah, 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 blah. That's what you kind of need. And again, you're going to pay those guys. So H-1Bs are going to get more expensive.
Mhm. Okay, let's take up Rogers now. This is from LinkedIn. Feliz Navidad, guys. Well, Merry Christmas to you too, Roger, and to your family. And he says he has a question. I have a green card that got expired when I was 11 years old. Is it possible to renew it even though it passed 30 years since then?
Well, it's a question. Roger, are you in the United States? If you're in the United States, that green card's still valid. I assume it's a pink one. It should be a pink one, or maybe even it's probably not a green one, but it's probably a pink one with no expiration date. If you've been in the U.S. the whole time, the card is fine. If you've been out of the country, that card's expired, right? That card's done, because if you're out of the country for more than a year, you abandon your residence. But if you've been in the United States, you can just file a renewal. Just file a 990 and get a new card. Piece of cake.
Even though
Better
it was
question,
30 years
if you're in the United States, why haven't you naturalized?
Roger, tell us more about yourself. Which is the one you have? Which color is it? Pink or green? And yeah, why have you not naturalized if you're still in the US? All right. Cool. So let's take up Tamara's question now. I have sent my RFE response for STEM approval to USCIS. It is reflecting as received on portal. How long does it take to get an update? And in scenario where it gets denied, what options does Tamara have?
Generally, it takes 30 days or less on a STEM OPT extension. Gets denied, you will have 60 days to leave the United States. Or change status to a visitor or go back to school. Those will be your options.
Okay. Thank you. Thank you for taking that up for Tamara. And let's go on to one more. Let's take Chandra's question. My employer is a small business and doesn't have the same resource as large companies. How can we prove that they have the ability to pay my salary and fulfill the job requirements for the H-1B?
So we just had it. We just won an RFE on this issue that another lawyer had lost, and we actually did a motion to reopen and won it. You start with the employer's tax returns. So is the amount of money they claimed as taxable profit for the business, is that more than your salary? If so, you're fine. If you were already working there under OPT and you're getting paid the salary, you show your pay stubs as part of it. You also look at the person's tax return, company's tax returns. Do they have assets? Do they have carry forward profits? All those things are part of the consideration and are very case specific. So, if you've got that and you're an RFE and your lawyer is not handling it right, just give us a call. We're happy to help. I'm very proud of my partner, Danielle Claffey. She just won. There's a fellow who used to be an H-1B worker, a fellow from India at a state agency. And there was some weird stuff going on where he was blamed for something that wasn't his fault. And he went to a different employer and he ultimately got his I-140, became current, filed, and immigration denied it because they said he did something bad at his employer. And he came to us, and it's taken us a year, and we had to file litigation in federal court. But yesterday, he got his green card. They reopened the case and gave it to him. So fighting hard is worth it most times, because immigration makes mistakes and presumes the worst of immigrants all the time. They presume the worst.
All the time, yes. But yes, kudos to you, your team, and Danielle out there. A big shout out. And folks out there, you
He's a
can
rock star.
contact. Yes, you can contact Charles Cuck, have a one-on-one consultation, and you can call him up on his number. His number is 404 949 8154. Let me repeat that: 404 949 8154.
But don't
And his
don't
email
call
address
now. Don't call now. I'm on the show.
right after the show, maybe. But yes, you can even email Chuck, and his email address is chuck@immigration.net. And go visit www.immigration.net to get to know more about Charles Cuck. Thank you so much. And let's go on now, Charles, to my next question. I have this, and that is the Trump 2025 team really appears to blend restrictive and reformative voices. So, how might their combined influence impact DACA, and other programs supporting undocumented youth?
I'm glad you asked about DACA. DACA is kind of apart from what Trump has done and will do going forward. The DACA has a strange history. Started by Obama, Trump ended it in September 2017. At least he thought he did, but litigation was filed because Trump ended it wrong. He was required to follow the Administrative Procedures Act, and he didn't. And they're just obstinate. They just never did it. So litigation kept on going, and you couldn't file a new DACA, but you could keep extending your DACA. Biden comes along and says, "Oh, we're going to do it the right way." Biden extends DACA. And then a court says, "Yeah, you extended it the right way, but we don't think you have the power to do it." So the court ended it, but said, "Yeah, they can keep extending people with DACA." It's about 500,000 people. Now there's been argument on appeal of that decision at the Court of Appeals. They'll make a decision probably before Trump comes into office saying DACA is illegal, but then it will be appealed to the Supreme Court. And during this time, DACA will continue. In order for Trump to cancel it, he has to go through this same process that he didn't go through before, but which Biden did, and it takes a year. So DACA is not going away. DACA is going to be around for the next year and a half. Supreme Court won't even hear the case until 2026. What we're telling people, my advice, we have thousands of DACA clients, is if you have DACA and it expires in 2025, you should be filing your extension today. File your extension today to get that extra time, that extra year on the back end, year and a half, 18 months on that back end, because this way you're good till 2027, and you don't know what's going to happen in 2027. So that's kind of where we are with DACA, but Congress isn't going to touch it. Trump spoke approvingly of it in an interview on Meet the Press a couple weeks ago, but Stephen Miller runs immigration. He hates DACA. So it's not going to get approved. Congress isn't going to do anything. The best we can do is fight to keep it where we're at.
Okay. Thank you so much for, for the detailed explanation. And yes, I have one more. And that is, with Trump's renewed push to end birthright citizenship, through executive action, how feasible do you think it is going to be under constitutional law? And what challenges might arise if his administration attempts to implement such a policy?
I was talking to a friend of mine at the ACLU, which is the American Civil Liberties Union, about this, and they already have the litigation ready to go. Trump will issue an executive order on day one that says anybody born in the United States whose parents weren't citizens or permanent residents are not citizens. By the way, this includes children of H-1B visa holders, by the way, are not citizens. And he will order the Department of State not to issue passports. He will order immigration not to approve petitions. And it will be immediately challenged in federal court. It will be immediately struck down because it is contrary to the plain language of the 14th Amendment, which says that any person born in the United States, subject to the jurisdiction or thereof, which means not diplomats. Diplomats' kids are residents, they're not citizens. And that's been interpreted this way for 150 years. There's the seminal case on this is Kim Wong-Ark from 1898, Kim Wong-Ark was a Chinese-born person, a U.S.-born person whose parents were residents. That is, they were physically in the United States. We didn't have permanent resident back then. They said, look, he was here. Parents lived here. He's a citizen. Period. End of story. And this is a fringe legal theory that it shocks me that anybody with a soul would agree is a good idea. We fought a civil war over whether somebody born here was a citizen. And it is outrageous that in the 21st century, we're having to do it again. Shame on these people. Truly outrageous. But there will be a fight. There will be a fight. That's why I'm telling clients, if you've got a CLID and you're undocumented or you're having a visa and your kid was born here, get their U.S. passport right now. Get it now and avoid the heartache later or the headache later.
That's a good one. And it's a point to be noted, folks out there. And yes, I hope you have been noting good points throughout this whole show, by the way. And going on. So let's take up a few more from our audience before we leave. And I think RK is back with another one asking, will there be legitimation for H-1B about contract for bona fide job at the time of filing? And what is the difference from what is happening now?
Well, you will, under the new rules, if there's a third party site that they're working at, that third party site will be viewed as kind of a co-employer and will be required to comply with all the rules on H-1Bs, including posting, et cetera, and wage. It's going to make it a lot harder on these companies. It's designed to make it harder on these companies to do the H-1Bs. So yeah, it's going to be much harder. I'm glad I don't have any clients like that. All my clients are direct hires.
But thank you so much for taking that up for RK. And RK, thank you for participating. I wish you could join us on call. I mean, anybody could join us on call. So I'm really looking forward. But yeah, let's go on to Ajay's question. In the RFE, they've asked for more evidence about my employer's ability to pay the prevailing wage. What kind of financial documents can we submit to address this concern?
We already talked about this. This is a question I answered before. Tax returns,
Similar one, like yeah,
things like that. So it's I think it looked like the same one, but tax returns, analysis of tax returns, profit from the previous year, current employment with the company, assets the company has that they could liquidate. All those. If it's a closely held company, you can look at if it's an individual. We had one recently. We won where it was an accounting firm, and basically it was a sole proprietorship. So we used the sole proprietor's income to show that he could afford to pay somebody to do that job. And it explained that now that they won't have to do it, so they'll make more money. So it's kind of again, requires a level of skill that you get when you've been practicing law for 40 years that you don't get as a brand new lawyer.
Mm-hmm. All right. Thank you so much for taking that up. And let's talk about Elon Musk's, given that his influence on the technology sector, how do you think his involvement in the administration is going to affect policies on high-skilled immigration visas, whether it's H-1B or STEM-related pathways?
He will be the contrary voice to Stephen Miller, telling Trump, don't cut out STEM, don't cut out H-1Bs, don't do this stuff. But Stephen Miller is going to win that argument. Just is. You have to understand that. Stephen Miller is like a son to Donald Trump, an evil son, but a son nonetheless. Musk will quickly lose focus, and he'll go on to the next thing. But while President Musk is still around, I guess we'll see what he does. But again, I don't see him really affecting policy in a positive way. I don't see it. He's a chaos agent. That's what he is.
Okay, let's see what's going to happen. But I know what you mean. I think it's always most of the time contradicting with many others in Trump's team, right? So let's see what happens. So
True.
what legal challenges? Sorry.
I just said true. It's absolutely true.
Yeah. So what legal challenges do you see if Trump seeks to implement similar policies as before? We've been speaking that it's going to happen nonetheless. So with regard to existing federal court rulings against such measures, if you can just
Well, actually, we're kind of, I litigate a lot. I was a part of a number of teams that litigated last Trump administration. There's a recent Supreme Court case that makes our litigation easier. There used to be a Supreme Court case that said that if an agency makes a policy, that the court should give deference, should say, you're the experts, I'm not, I'm going to uphold it. That was overturned last term by the Supreme Court. So it is now much easier to challenge policies of the federal government. And I'm actually looking forward to litigating in this context, because I think you have to understand, we won virtually every case filed against Trump. Virtually every case we won. And I would say of the 300 cases we filed when he was president, I think we won 299 of them. We won almost all of them. We will win all of them next time. Because while these guys are, these nativists have a vision of the way they want America to be, our laws don't let them do it. And so we will bring declaratory judgment actions, challenges under the Administrative Procedures Act, and for delayed cases, mandamus cases, and we will win them.
Yes.
And nothing's better than beating Trump at court. Nothing's better.
Okay. Looking forward for a lot happening in 2025 is all I can say. So, how do you expect, the potential for litigation to evolve with regard to Trump's immigration policies, especially if they are perceived to be restrictive or discriminatory?
As I said, litigation is going to be awesome. We'll be litigating all these issues. It will not, what's one thing about Trump that's happened that's really important is he's created a cadre of immigration litigators that it used to be like 5 of us in the whole country that litigated these cases. There's hundreds now, hundreds of experienced, qualified litigators. We're going to bury these people in lawsuits. We're going to become the sand in the gears to slow down the deportation machine, and we're going to do that under the law because we're going to make them follow every jot and tittle that exists in the law to protect immigrants in the United States.
For sure. All right. So, I think I have a few more questions. But before that, we should address one more from the audience. Sudhir. All right, so let's take up this last one then I have, and that is, what strategies can immigrants and their families employ to navigate any changes or uncertainties that might arise under Trump 2025 administration?
Well, don't be traveling outside the United States if you're from a Muslim majority country on January 20th. If you're from a Muslim majority country, you should be in the United States on January 20th if you want to come here next year, because that's going to be litigation. If you got kids born here, get them passports. If you are in the United States on a visa, make sure you're meticulous in making sure that visa is extended early at the 6-month mark to make sure you're always in status. Make sure all the lights work in your car so you don't get pulled over for a reason that cops make up that your lights are out. Simply live a perfect life, because that's what the Trump administration will want you to do to avoid you being deported. You don't want to end up in an immigration jail cell. That is a really depressing note to end on, isn't it? And be happy, because people like me fighting for you.
For sure, yes. And you can find Trump's telephone number scrolling on the screen, 404-949-8154. And you can email chuck@immigration.net. So, folks out there, I think it's a wrap for now. I'm so excited that the holidays are coming up. It's the Christmas season. So, here's wishing you, Charles, and your family out there a Merry Christmas and, of course, a great end to 2024. And also to our viewers, if you have anything to say before we go, Charles.
Oh, well, again, we want to wish everybody an extraordinary Christmas season. It is a great time of year to remember the great blessings that we have with our family and our friends. Enjoy this time together and be prepared in a week, in 10 days, to begin the fight again. Have a Merry Christmas and a Happy New Year.
Thank you so much, Charles, for that very sweet message. And here's saying bye for now. And I'm hoping to see you in 2025. And I think by then there'll be so much happening. So there'll be a lot to talk about. So
That there
I'm
will.
looking forward for it already.
Have a happy holiday. Bye-bye.
Happy holidays. Bye bye. So thank you so much, everyone out there, for joining us today. It was great having you. Please do not forget to like, share, and subscribe to Immigration and Jobs Talk Show. We are on YouTube, LinkedIn, Facebook, and on X. And also, you can call me, write to me if you have any queries, and we can direct your questions to our attorneys. And my number is 408-335-6444. And you can also email me. My email address is nipa@staffingly.com. Thank you so much, everyone, and stay back. Watch out, Immigration and Jobs Talk Show, because we have so much awesome content that we have shared with you and a lot more coming up. Bye bye for now. Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and I'm really happy to welcome you folks. And before we start off with today's discussion, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, thank you so much for joining us today. We are streaming live right now on YouTube, LinkedIn, and on Facebook and on X. So please feel free to join us in this conversation by commenting, whatever questions you have, because we are going to have our guest attorney for today, and it's going to be great to have her for an hour where we can also address your questions. So yes, thank you so much for joining us, and it's a very critical topic we are going to dive in today for all immigrants and their families. So yes, with the release of January 2025 visa bulletin, many of us are wondering, what does it mean for us and our loved ones and our future plans, right? And we're going to unpack this for sure. But before that, please help me welcome a very special guest, Attorney Prashanthi Reddy. She is a leading expert in immigration law with years of experience, guiding individuals and businesses through the complexities of U.S. immigration process. Thank you so much, Prashanthi, for joining us today.
Hi, Nipasa. It's good to be back.
Absolutely. And friends, we have a breaking news regarding the upcoming H-1B regulations effective January 17. And there are new changes that aim to streamline, the process and address key compliance issues, raising questions about the impact on both employers and employees. So Prashanthi, before we really dive into our topic for today, I have this question. If you could tell us, what are the key changes in the new H-1B regulations effective January 17th, 2025?
Right. So we had an idea that this was coming, but it was coming because they did publish the regulation in the Federal Register, but then they have a comment period. So they were waiting for comments. And then based on the comments, they often change the final regulation. So this is the final regulation and it's already published. And it was published yesterday. The 17th is effective 30 days from January 17th. Guys, ladies and gentlemen, it is now official. And this will be the final regulation. And this is a big deal because for a while there hasn't been any regulation on H-1B. At least there hasn't been a comprehensive regulation such as this on, the H-1Bs. So this is a big deal, and that's why we're bringing it to you as breaking news. So let's dive right into and there's some very interesting things and path-breaking changes that you'll see, and some of them are, more of what you saw in the past, which is just being regularized now, because of case law and, lawsuits, they were not able to implement. So we knew that it was coming. And some of the aspects of this regulation are completely new and path-breaking. So let's dive right into it. As I said, the final rule was, and significant changes to the H-1B program have been introduced in this rule. And as I said, 30 days to take effect. So we're talking about January 17th, just days before the Trump administration will take over. And this was done deliberately because they wanted to put it in before the Trump administration came in, so that it'll be difficult now for the Trump administration to make their own rules. This is the rules that the present government wants to have, right? It's good and bad. It's not like the Democratic government is completely free on H-1s. No government is. But at least it's a mixed bag, right? So under the Trump administration, in my opinion, if they wouldn't have passed any regulation, then the Trump administration would have passed a much stricter regulation. So let's go right to it. First is they're giving deference to previously approved cases. So if you're filing a extension or an amendment, and if it's been approved previously, and if nothing has changed, if there are no new material changes, then USCIS will automatically approve those cases without again sending requests for further evidence. So that's called the deference policy, which is, I mean, already supposed to be there, but now they're putting it into regulation, so it'll be implemented for sure. They've updated the definition of specialty occupation. This rule revises the definition of what a specialty occupation is. This is the very core of who can get a H1 by revising the definition. That has a significant impact. So they've broadened the range of degree fields related. So right now, as per the regulation, a specialty occupation is an occupation where a bachelor's degree, the job requires a bachelor's degree in a specific field. They've broadened that to include in a range of degree fields that are directly related to the job. So it doesn't have to be one specific field. It can be different fields, as long as those fields you can show that those fields are related to the job, right? So it's not changed drastically, but there is some change, and this really makes a difference because there are some occupations in which a range of degrees are required, and usually those occupations don't get approved for a H1 because then USCIS comes back and says that it's not a specific, it's a range, and therefore we're not approving it. For example, I can give you an example of systems analyst, say, where it says bachelor's degree in engineering, math, physics, computer science is required, and USCIS would previously say that it was not a specialty occupation. Now, as long as you can show that that engineering degree, that math degree, that physics degree is related to the position, even if that's the industry, it's still a specialty occupation. They usually go into the Occupational Outlook Handbook, which is a DOL publication, which is online, which you can check. They usually check that, and whenever there's something in that, in the Occupational Outlook Handbook (OOH), which says that a range of degrees are required, USCIS will generally send an RFE. So this, we can expect that more jobs will open up for a H1 and less RFEs, as long as we can show that the degrees are related. CAP exempt employers, they are narrowly expanding what the definition of a CAP exempt employer is. So for CAP exempt nonprofit research organizations or government research organizations, they have included a few more organizations into the CAP exempt employer category by replacing the term primarily research to research as a fundamental activity. So it means that the organization doesn't have to be only doing research. Even if they do other activities, as long as the fundamental activity is research, they can still qualify. In the past, their primary job had to be research. Primary mission had to be research. Now it's not so. It just has to be a fundamental or one of the main activities. The other change is bona fide position requirement, meaning the H-1B petitions must now show that the offered position is a legitimate specialty occupation position, ensuring that the job meets all the criteria for the program. This basically means, in short, that, for example, if you're a consulting company, you have to show that you actually have specialty work, specialty occupation work available, meaning that you have to submit contracts and work orders. As you know, after 2020, after the Cessna versus ITServe decision, USCIS has not been asking for contracts and work orders. Now they will go back to asking that, but not to the extent that they were asking it before 2020, meaning that they will not ask for all 3 years to show that there is a requirement for 3 years, so show 3 years of contract availability. They will ask, at least to start off, you have a legitimate, contract, even if it's 6 months or whatever it might be for. But the contract requirement has come back. So this is significant because in the past CAP, we've seen that people have applied even without any contracts or anything, any client, especially if you're a consulting company, and they've still approved. Now, if you're not a consulting company, you still have to show that you have a bona fide requirement. So if you are hiring this person for not a contract position, but using them within the company, and you're not contracting them out, then you'd have to show that your company has enough business to require this. So you could show a tax return, you could show contracts work or that your company has with their clients in general, and you can show the volume of business in many ways. Maybe a list of clients, maybe your bank statements, maybe your invoices, to show that you actually have a need for this person. But this bona fide position requirement comes up mostly in a consulting scenario. Then they've also codified the site visits. So USCIS earlier always conducted site visits, but it was kind of voluntary. So you could either allow or not allow the officers into your office, though, I mean, I don't see why you wouldn't, because if you didn't allow them into your office, they would write a negative report and then your H1 would get denied or revoked, and there would be a black mark against your company. So now USCIS has actually codified their authority to conduct site visits, and they can, by regulation, deny or revoke petitions if a petition refuses to cooperate with their visit. Third-party requirements, they have specifically said for consulting companies, H1B workers assigned to a third-party work site, the job requirements of the end client are important rather than what your internal job requirements are. This is also significant. So if you are hiring someone to work as a consultant, say at AT&T, and the position is that of a software developer, then they will want to look at what AT&T's requirements are to hire a software developer. And if they require a bachelor's degree in computer science, then it's a specialty occupation. Otherwise, it isn't. So you'd have to have much more accessibility to your client and get that information from your client, or get a letter from your client stating what the requirement is. So we're back with end client requirements, submitting end client requirements, or purchase orders which have the end client requirements. Another very, very important change, and this is, I think, a 360-degree range, which is basically the rule now allows H1B to be self-sponsored. Very important. You can file your own H1 even if you are a controlling partner in your company. Very
Wow.
important. This was never the case. So you always had to file through another company, or you had to file through your consulting company. This rule allows certain owners of petitioning entities to self-sponsor. Of course, there's a limitation on the amount of the H1, the period of the H1. You can get it for 18 months and then get it for another 18 months. And then I believe you can get it, for a longer period of time. But you have to keep in mind that though the H1 could be self-sponsored, when you're filing a green card, you could still have issues filing your own green card, so this works for H1Bs, but when you have to file a green card, again, you'll have to find an employer who's willing to, sponsor you on the green card. But this is really important for a lot of entrepreneurs out there who are already, able to do their own business, but are not doing it because they are, they are restricted because of the existing H1B regulations, where you can't really sponsor yourself because there has to be an employer-employee relationship. So they have really widened this, loosened it, whatever you want to say. And even if you are managing your own business, as long as you are doing more than 50% of the job is the H1B specialty occupation job, if you're also doing the job of managing your company, which may not be a specialty occupation job, you can still do that. As long as the majority of the time you're doing, so over 50% is your specialty occupation job. So that is very, very significant. I left out the best part for, the last, but
For the last.
that's very important. And then there are other some more important rules for F1s, so revised cap gap rule. So now
Okay.
you will be authorized to work under cap gap or remain in status under cap gap until April 1 of the next year. Before it was October
Okay.
1st of the existing year, now it's April 1 of the following year. So that's also significant for F1s because they often see that when the H1B gets delayed, if it doesn't get approved by October 1st, then they have to scramble and go back into F1 status, file for, student status for another semester, file for OPT, CPT, whatever it might be to remain in status until the H1 gets approved. So they are taking that out. No need to because it's extended until the next year, April, and H1s don't take that long to get approved.
A little more relaxed.
Little more relaxed for sure. I mean, for the most part, 99% of the F1 students will not have to file for an extension to extend their cap gap. Another last change is maintenance of status documents. They want you to send your status documents while you're filing the initial petition itself. So they might ask for more documents with reference to your status. Right now, we just send the H1s and, we don't necessarily send documents from the start of your entry into the US. So now they want all the documents, I think, from the entry of into the US from your first entry, and they might want all your pay stubs, all your W-2s to make sure that you maintained status throughout your. So that's something that they never used to ask for before. Maybe in random cases they would, but now they want that in every single case. So these changes, as you can see, they're a mixed bag. There's some positive and some negative, and that's to be expected. So we have to wait and watch how this actually impacts consulting companies,
Yeah.
how this impacts individual H1B petitions, especially the self petitions, how they process them, whether there will be a lot of scrutiny and they have so much scrutiny that they won't actually approve any cases, or the scrutiny will be as it should be under the regulation, and they actually start approving these cases.
Let's see what the 2025 holds for us. But these new changes sound really good, and I really hope that this is going to benefit most individuals under H1B or who are planning to go for an H1B visa. So thank you so much, Prashanti, for highlighting all those new H1B regulations and also these new changes for F1 students. Thank you so much. Thank you so much. It was great. And these are some of the latest updates, friends. I hope you noted down. And you can always go watch it right from the very beginning, whatever Prashanti has shared. These are new updates that you wouldn't want to miss. And Prashanti, we have some folks out there who have questions for us. I think we should address them before we jump into our visa bulletin questions for January 2025. And some of them are from your channel. So let's take them up quickly, please. So Sudhindra, Sud- Sudhindra, sorry if I'm pronouncing your name wrong, but he says, hello, I do have a query. My I-129 was approved on November 25th. I'm still waiting for I-797 form. So will this new H-1B changes affect my case?
No, this is only going to be from January 17th. That is, cases filed after January 17th will have to be filed under this new regulation.
All right. Thank you so much for addressing this one, Prashanti. Now let's take up Shree's question. Hi, H1B petition is applied on November 24th for extension. Is this third party placements through consulting apply for H1B applications applied after January 18th, or will it still apply for already applied ones?
Good question. It should only take, it should only be, I don't see that it is retroactive, but I can cross check. It should only be applicable for petitions that are going to be filed after the 17th. But again, I'll cross check. And then I'll let you, Nipasa.
Sure.
Nipasa, I'll let you know, and then you can let Sri know.
We
But
can leave
as far as I know, regulations are usually not retroactive. They're always only come into play once they've been once they're active, once they're published
once
and the
they're
comment
active.
period and the 30 days is over. Yeah.
And these
But
changes are
it's
going to be effective on January 17th,
17th,
2025.
17th, correct. But if it's otherwise, I'll let you know.
Okay, thank you, Shri, for commenting. And if you have any other questions, keep commenting. And otherwise, you can join us on this conversation, folks out there, by dialing this number 425-436-6335. And the access code is 988-888. And Abhishek, hi, thank you for joining us. Charwak, we will address your questions, but please stay with us for now. So, Prashanti, let's get to our visa bulletin for January 2025. We have some questions also, so let's jump right into them. So, given the significant retrogression in the EB2 and EB3 categories for Indian applicants, what strategies can individuals take to potentially expedite their visa process?
Nipasa, shall we go through the January visa bulletin first, just to give people
Sure,
an idea as
let's do
to?
that.
Okay, so so basically, starting with the employment-based categories, for dates for filing, there's been no change. For final action date, there has been some advancement for both EB2 and EB3 categories. Let's go into that. So final action date, EB2 has moved up by 2 months to October 1. China is advanced by 1 month to April 22nd, 2020. All other countries advanced by 2 weeks, so not a big leap, but still something's better than nothing. It's moved to April 1, 2023. So India moved by 2 months, China by 1 month, all other country by 2 weeks for EB2. For EB3, India moved up by 3 weeks, 2012. China moved by 2 months to June 2020, and all other countries moved up by 2 weeks. So again, India 3 weeks forward movement, China 2 months, and all other countries 2 weeks. So you see that EB2 and EB3 both have moved forward moderately, not drastically, but any forward movement is good. EB3 also, there's been an advancement. India moved up by 3 weeks to December 1, 2012. All other countries, except of course for China, advanced by 1 week. So very short advancement to December 8, 2020. And then going to the family-based categories, India, China, and worldwide advanced by 1 month for F1. That's unmarried sons and daughters of US citizens. Now they're on November 22, 2015. Philippines advanced only by a week to 2012, March 8, 2012. F2A, spouses and children of permanent residents. Again, Mexico advanced by 1 month. And India, China, and other countries advanced by 3 weeks. For F2B, that's unmarried sons and residents. For F2A, the only change is Mexico. Married sons and daughters of US citizens, Mexico went up by 1 month, Philippines by 2 months. All other countries went up by 2 months as well. Of course, not US, not India. The most backlogged, which is brother and sisters of US citizens. Philippines went up by 3 months. India went up by 1 month. Any advancement is good because it's very rare. Now that was the final action date table, but but the dates for filing table, which we presently can look at, has also changed for family base. So Mexico went up by 3 months. India, China, worldwide. For F2B, Mexico went up by 3 months. That is unmarried sons and daughters of permanent residents. For F3, married sons and daughters of US citizens, India, China, and worldwide went up by 3 months, which is a good advancement. And brothers and sisters, that's the F4 category, which we were just talking about, 5 months to 2008. India advanced moderately by 2 weeks to 2006. So always look at the dates for filing tables, because those, if USCIS is allowing you to use those tables are usually ahead of the final action date table. It's just that you won't get a green card immediately, but you'll be able to file for a 485 and be in a 485 status. and get the advanced parole and employment authorization as well.
Right. Any advancement is good, and this is very rare to see. So all these good advancements are good news, and thank you so much, Prashanti, for going through the visa bulletin for January 2025 for us and highlighting those important changes in the advancements for both the dates. So now let's go to our questions, if that's fine. But before that, Sudhindra has said, "Thank you, Prashanti ma'am. This eased my anxiety. Kudos to you both." Thank you for your question and thank you for that, Sudhindra. So going to our question, we see the significant changes in EB1 and EB2 categories for Indian applicants. So maybe if you could tell us a few strategies that individuals can take to potentially expedite their visa process.
Right. So we see, even though there has been some forward movement, there's still retrogression for EB2 and EB3 for Indian applicants and Chinese, people from China as well. So, in order to navigate this, there's some things we can do. There's not a lot we can do, of course, other than advocacy to change that. But some things is to see if you qualify under EB1. So if you possess extraordinary ability, or you're an outstanding professor or researcher, or you've served as a multinational, you've worked as a multinational executive or manager, you can consider applying under EB1 or see what you can do to make yourself eligible for EB1. You can file under NIW if your work is substantially intrinsic to the US and helpful to the US. Then under EB2, you can file under national interest waiver. The advantage of this is, even though it's still EB2, you can bypass the labor cert process and thereby gain some time, because the labor cert process takes more than a year now. Always make sure you file concurrently. If your dates are current, don't file the I-140 first and then wait. I mean, you could do that, but in order to speed up the process, you should file both the I-140 and 485 together, because by the time you get the I-140 approved, maybe your dates will no longer be current. So concurrent filing, even if the I-140 gets denied and you lose your money, concurrent filing might be the way to go, especially if the dates have become current. Cross-chargeability. If your spouse was born in a different country with a less backlog, so if she's not born in India or China, he or she, then you might benefit from your spouse's countries of birth. Always make sure you cross-check your spouse was not born in this country as you. And last but not the least, always maintain your non-immigrant status. Ensure your current visa remains valid, so that while you're waiting, you don't accrue unlawful presence and then have to leave the country.
Thank you. Thank you so much, Prashanti, for addressing that and for highlighting those changes. And before we go into our next, let's take up Prabin's question. Does this rule apply for transfer and extension? I think he's talking about the new H-1B regulations.
It applies to everyone. Transfer, any H1 that you file, cap, extension, transfer, amendment, anyone.
But after the date, January 17th, 2025, Prabin. Thank you for your question.
Correct.
And thank you for participating. Let's go on to our next question now, Prashanti. So, how does the advancement in family sponsored categories, such as F1 and F3 categories for Indian applicants,
Yeah.
impact the expected wait times for green cards?
Well, so unfortunately, as we've seen, right, there's no significant advancement. There is advancement of 2 or 3 months, but as you've seen, F4 categories still remain backlogged. So I would say, in order to prepare to, so that when your case gets current, what you need to do is document ready, right? So keep all your documents ready, especially your birth certificate, marriage certificate, those kind of documents. You have to keep them ready. So that's one thing to keep in mind. Other thing is stay informed. Regularly check the monthly visa bulletin for any changes in priority dates. And keep yourself updated. Don't miss. Sometimes the priority dates are available only that 1 month, and then they become unavailable the next month. So get an automatic email, and you can register to do that so that you get it into your inbox whenever there is a new visa bulletin. That way you won't forget to check. The reason I was talking about document readiness is you might not have your birth certificate, you might not have your marriage certificate, perhaps your birth certificate was never registered, then you need a non-availability certificate. And this is since you don't have it and you don't have control over how long it'll take, because this has to be done by the register of birth and deaths in the town that you were born. Do that in advance and keep them ready. And then, of course, as I said earlier, consider alternative paths between the employment-based and the family-based, and see which one has shorter times and apply for both if you're able to, right? So that's another way to kind of be prepared despite the retrogression.
Thank you so much, Prashanti, for highlighting that as well. And family sponsored categories, I think folks out there are pretty tensed how to go about this, and especially with all these backlogs that have been significant all the while. And I think, thank you so much, Prashanti, for addressing this again.
You're welcome.
Let's go on to our next question now. Let's take up this one. Can you explain the implications of the EB5 category, showing a favorable environment for investors? And what does this mean for those considering applying for an investor visa?
So while the visa bulletin shows that the dates are pretty good and current for most countries, including India, you have to keep in mind that the processing times for EB5s are not good. So while the priority dates might be available, your processing times are about 4 years just for USCIS to process it, which is ridiculous. I don't know why they're doing this I guess they're doing this because they don't want to give out EB5s. There's no other reason. They're trying to stop the EB5s or kind of stall them or reduce them, whatever it is. So processing times are really, really long. So you have to keep in mind the processing times when you look at the total time taken to get an EB5. And while you might, if you're outside the country especially and you're investing that kind of money, and if the processing time is taking 4 years plus, even if your priority date is available, and then takes another 2 years to get a permanent green card by removing conditions, then you're already looking at 5 to 7 years, and then we don't know what the priority dates will be then, right? We're only looking at the priority dates now. So do it, but keep in mind all these things with reference to processing time and how that might impact you. And keep in mind the requirements of, the 1+ million and the 800,000, depending on where you're investing, and that you need to create and preserve during this time 10 full-time jobs. So you have to continue to have those 10 full-time jobs. And if you're using a regional center, make sure that you do your due diligence to make sure that the regional center has, has good, good investments. So these are a few things to keep in mind, I think.
Thank you so much, Prashanti. And folks out there, I would like to tell you that you can also join us in this conversation by dialing this number 425-436-6335. You can join us, and when they ask for the access code, dial in 988-888. Once you're in, you just say hello and we will be able to hear you. And otherwise, folks out there, this is Attorney Prashanti Reddy, and you can also have a one-on-one consultation with her, and her phone number is there on the screen. Her number is 212-354-1010, and you can also email Attorney Prashanti Reddy, and that is prashanti@reddyesq.com, and go visit www.reddyesq.com to get to know more about Attorney Prashanti Reddy. Let's go on now, and we have Arpita also, who has joined us with her questions. Arpita, please stay with us. We will address your questions a little while later. Prashanti, with the visa bulletin, showing current priority dates of most employment-based categories for, other countries, that is rest of the world, what factors could contribute to these variations in processing times between regions, if you have anything to highlight?
Yes, the processing times. I mean, the priority dates are definitely going to be different depending on which country you were born in. It's based on country of birth, remember, not country of citizenship. First of all, it depends on the demand and supply in your particular country. For example, because everyone gets only 7% of the total green cards. Every country gets 7%. So for high demand countries like India, the wait time is much longer due to the country caps, right? Also, each category has, again, a cap. So depending on which category you're filing in and what is the demand in that category. So for EB1, the demand is less. So, the wait time is less. If you're EB2, EB3, the demand is higher. This also, the efficiency of the USCIS in processing these, administrative efficiency also makes a big difference. So processing times, especially if you're filing outside the country, your wait times will differ depending on the consulate that is processing your green card. Even though part of the processing takes place here, the final immigrant visa petition is processed for India, example in Bombay, and Bombay has a wait time because they have only so many slots available for interviews. So that could add to your processing time as well, depending on which consulate. And also USCIS often delays processing of cases. So depending on at that particular time, what USCIS processing times are, that could also account for variations in processing times. So I think all these have an effect on your processing time. Hello, Nipasa? I think we lost you. Oh, there you are.
Ma'am, control here. I'm trying to get in contact with Nipasa again. Let me see.
Okay.
One
Okay.
minute, ma'am. 1 minute, ma'am.
I think she's back.
Nipasa, you okay? 1 minute, ma'am, please. Sorry.
Sure.
Sorry, folks.
No problem.
Sorry, guys.
Thank you so much, Prashanti, for addressing that for the rest of the world. I think there was some internet lag. I had to rejoin. But thank you so much, folks, for staying with us. This is Immigration and Jobs Talk Show. I'm Nipasa Pradhan with our guest for today, Attorney Prashanti Reddy. So it's been great having your questions, and I think we're going to address them in a little while. But Prashanti, if you could also, tell us how do the changes in the visa bulletin also affect the family reunification process, especially for siblings of US citizens, the F4 category, which you had touched upon a little bit earlier. But what steps should families take to prepare for possible delays and advancements?
Yes, so the F4 category is severely backlogged for most countries and especially for India, as we discussed. And I guess the only thing we can do is timely file your I-130 petition as soon as possible so that you can, be in the window. Maintain communication, keep in regular contact with NVC if you're outside the country. That's a National Visa Center to update them on any changes that might have taken place, right? Since it's taking 20 years, you might have had children, you might have gotten married, right? Unfortunately, sometimes the sponsor might be no more as well. So you have to continue to maintain contact with NVC and update them on any changes that are taking place. Also explore other options. And you might want to think whether you want to file an I-130 or not at this point of time, or you have other ways of coming into the country, or filing a green card if you're already in the country. Consider filing a B2 if you want to come and meet your family members for a short period of time, or consider another non-immigrant petition like a student visa, or coming to work here so that you can, reunify with your family members. So alternatives should always be looked at. If you're filing an I-130, remember it might be better not to file it if you're going to file a non-immigrant petition. That requires you to have intent on not to immigrate. So for example, like a B2, an F1, you may not be able to file an I-130. You might have to hold off on that and file this first, and then file an I-130 once you get onto a visa which allows dual intent, like a H1. So these are strategies that you have to think about, considering the long processing times for an I-130. And I think an attorney can really help you and advise you on strategizing on the best path forward.
Absolutely. And folks out there, you should definitely contact Attorney Prashanthi Reddy, and you can email her at prashanthi@reddyesq.com. And moving on, Prashanthi, if you could also tell us what potential legal challenges or policy changes could impact the visa bulletin and immigration trends in the upcoming months. We already touched upon the latest updates on H-1B regulations, but anything else you want to add?
Well, with the new administration set to take over in January, we have to see. Visa limits are established by the law, right? And unlikely to change immediately. However, there might be legislative proposals or bills like the Fairness for High Skilled Immigration Act that could be reintroduced. You never know. For years and years, nothing has happened. I don't expect anything will happen under the Republican controlled House and Senate legislature, but let's wait and see. You can never say never. This H-1B regulation came out after so many years. That will happen. Who knows? Policies can always change for governments, right? Right now, it seems like the Republican Party under Trump is not pro-immigration, but I'm hoping that they'll surprise us and change their policy. And the Elon Musk and people who have Trump's ear might have some influence over the present government, and I'm hoping that they'll have enough influence to bring about bring about some positive changes, at least with reference to business immigration. Court decisions can often influence immigration policies and procedures. I am not sure in what scenario this can go before the court, but if it does, and if they are, if the judge decides that the visa numbers, the way they're counted wrong, and maybe family members should not be given a separate visa number, if that's something that they can decide after looking at interpreting the regulation in the Immigration and Nationality Act, then that's a possibility as well. But we have to wait and see.
For sure, Prashanthi. And I think we should also address some of our questions from our viewers. So let's take Abhishek's one. I noticed the January 2025 visa bulletin has some movement in EB categories, but it's not as much as I expected. Why is the movement so slow for certain countries?
Because the demand is so high and they don't want to release numbers quickly. They want to wait and see because we have the entire year ahead of us. So I think they're doing it slowly. That's for that reason. They want to wait and see.
Yes. Thank you,
If they are,
Abhishek, for your question.
if there are visa numbers still available, then you can see likely that there'll be some movement towards the end of the year, maybe August, September, because the year end is October.
Right. Let's hope for the best. Thank you, Prashanthi, for addressing this. Let's take up Charwak's question. What are the key differences between final action dates and dates for filing applications for immigrant visa applicants, and how do they impact the application process?
Um, right. So the final action date table actually is the date when your priority date is available. The dates for filing table is something that the Department of State introduced to allow you to file applications in advance, because the way they um, the way they calculate it is that they're hoping that by the time you file and by the time the case gets processed, your final action date, priority date, will actually be available. So that's how they calculate it. So it's usually dates for filing are, a few months in advance or maybe a year in advance of your final action
Mhm.
date table. The advantage of the dates for filing table and the huge benefit that it has is that it allows you to file your adjustment of status early, before your actual date becomes available. And this allows you to file for a 485 and allows you to maintain status without having to maintain a non-immigrant status. So it allows you to continue to be on 485 for years together and have EAD and advance parole. That has been a boon for a lot of people um, who have suffered due to the unavailability of visa numbers, because maintaining a H1 for so many years is very difficult, because a H1 is a very stringent visa status to maintain.
Right. Thank you so much, Charwak, for your question, and thank you, Prashanti, for addressing this. Let's go on to our questions from our YouTube channels first, and then maybe we can take up Arpita's question. So, Control, if you could display the first one. All right. Meanwhile, Prashanti, like I have one more question to go. So, given the significant disparities, between employment-based and family-sponsored categories, how should applicants prioritize their visa strategies to align with their personal and professional goals?
Right. So this is again similar to what we discussed with reference to retrogression for the family-based F4 category and how you should maybe look at alternatives. Uh, I guess it's the same for this. When you're deciding between, I mean, most family-based categories, immediate relative, of course, is a no-brainer, because if you are a U.S. citizen child under 21, or if you're a spouse or a parent, there is no visa numbers required, so you can file immediately. So obviously, if you're one of them, would definitely file under the family-based immediate relative category. But even if you're a permanent resident spouse, you might consider filing that rather than doing EB1, EB2, or EB3. So you have to assess what are the priority dates for each and evaluate. First, assess your eligibility for each category and see what you qualify under, and then evaluate the wait times categories that you qualify under, and file. You can no one you can file for both under certain circumstances, but again, I think you need to speak to an attorney to see if it's a good idea to file under all categories, or just stick to the categories that are better, and also be flexible, be ready to change or file under the a different category if this category gets backlogged. So always be flexible, be prepared in a month's notice to file under your that particular category. It happens to jump forward. So yeah, these are the
Right, right.
few things to keep in mind. Assess your eligibility, evaluate your wait times, of course, consult with an attorney, and stay flexible so that you can pivot to the other
Absolutely.
category when required. And when I say pivot, I also mean
Yes, yes.
pivoting between employment-based categories, between EB2 and EB3 as well.
Mhm.
And
Thank you so much.
also, Nipasa, in order to pivot, you have to know there is something called changing of the underlying basis. So you don't have to file a new 485. If you file under EB2 and you want to pivot to EB3, you can just ask USCIS to change the underlying basis of 85. And this in certain situations is possible even between a family-based and an employment-based category as well. So you might not have to file for a new 485, you can ask USCIS to pivot your 485 to the family-based category. But again, consult with an attorney before doing that.
Absolutely. Thank you so much, Prashanti, for addressing all these and highlighting the important things to keep in mind. And folks out there, it's always best to consult with an attorney. So it would be great if you could also consult with one, and why not Attorney Prashanti Reddy? So you can email her about your case, and her email address is prashanti@reddyesq.com, PRASHANTHI @reddyesq.com. Thank you, and let's go ahead with our questions now from our YouTube channel. So, Control, if you could display it, please. Um, the first one is: are these rules applicable for already selected H-1B applicants whose petition is not yet approved? And please give information about the H-1B petition delay happening right now. Prashanti.
So no, as we discussed, these rules should not be applicable for H-1B petitions that are already in pipeline. They should only be applicable for petitions that are going to be filed after January 17th, as per regulation. And again, I had said that I would cross-check that and get back to you with reference to if there's something written in the present regulation, because it only came out yesterday, makes it retroactive. In general, it's only regulations are only are take into effect from the date that it's published, or the date that they say it will take into effect.
Okay. Thank you so much, Prashanti, for taking this up for Indhu.
Nibasa, about the H-1B delays happening right now. In my office, I'm not really seeing those delays, but perhaps you are. Perhaps this is with reference to your particular case, and there could be some reason for it. Maybe you're going to get an RFE, and that's why they're taking longer to respond. I mean, if you want to overcome that, just convert your case to premium processing. If you can do that, I know it's a lot of money, but if you want to get approved faster, that's definitely one way of doing it.
Right. Thank you. And for an RFE, you have around 45 days to respond to it, right? Or 60
Actually,
days,
more
is it,
than that.
Prashanti?
Depends, but
Okay.
usually the maximum time is 80 something days. So there's plenty of time to respond to an
Okay.
RFE.
All right. Thank you so much, Prashanti, for taking this up for Indhu. And I hope this was very helpful for you, Indhu. And even otherwise, you can always contact Attorney Prashanti Reddy. She could guide you personally on your case. And that is prashanti@reddyesq.com. Let's go on to our next question. This is also on our YouTube channel. How long does it take to get a receipt if you have filed an H-1B transfer in premium processing? New employers sent the FedEx last Friday, and it dispatched on this Monday. Still, after 5 days, don't have a receipt number. They have filed in premium. Is there a delay going on nowadays? Never faced this much delay in premium transfer. Is this normal?
Yes, because it could be that, usually what happens is I would like to advise that, file online, because you get a receipt immediately if you file online. So try to make that into a practice rather than FedExing your case to USCIS. Of course, I understand in some instances you cannot file online because you have a H and you want to file the H1 together so that both process together. And in that situation, you cannot file online because you can't file a H4 online. But otherwise, I would suggest file online and you'll get the receipt immediately. But with reference to premium processing, you should usually get an email within the first 1 week of filing with the receipt. But I'm not surprised if you didn't. I wouldn't panic. Sometimes they don't. And that doesn't mean that they're not processing your case. It might just mean that they're as yet. And I have noticed premium processing, it's supposed to be 30 days. They never take the 30 days. It's usually processed within a week or 10 days. The only thing to make sure is that FedEx was delivered and that you have confirmation of the delivery. After that, I wouldn't worry too much about not getting the receipt within the first 5 days. Wait and see.
5 days. Okay.
Not
Thank you
yet
so
time
much
to
for
panic.
not yet time to panic. Yes. Shaba Kahal, thank you so much for your question, but I think you'll just have to be a little more patient and wait. Thank you, Prashanti, for addressing this one. Let's go on to our next control. If you could display it, please. This is from Pradeep. Is Indian Chartered Accountants considered for H-1B specialty accusation for accountant job? I have only Indian Chartered
Occupation,
Accountant
yeah.
certificate.
Right, occupation, I guess. Um, CAs can qualify to work as accountants. They cannot they cannot work as CPAs in the US, so that they cannot file taxes, but they can work under a licensed CPA as an accountant. And yes, an accountant is a specialty occupation, and yes, you can file a H1 for an accountant.
All right, this is good news for Pradeep. Then thank you, Prashanti, for taking this one. I think we have one last one from our.
And the other question he had was, if I only have an Indian Chartered Accountant certificate, is that sufficient? You require a bachelor's degree, your degree in accounting, but your chartered account certificate, along with your bachelor's degree, if it is in can qualify you, or make it, if you send it to the evaluator, which your attorney will do, they can consider it to be the equivalent of a bachelor's degree in accounting. So yes, using that, it's possible to qualify as an accountant.
It is. It is. So the evaluation is much needed since he must have done it from an Indian institute. I mean, his studies. So evaluation is a must before that, right? Thank you,
Correct.
Prashanti, for taking this up.
Yes.
This one is, I think, our last one. I have never traveled to US and working with Company A. My H-1B petition got approved with Company A. Now the project is being wrapped up and Company A is not willing to send me. Can I transfer my H-1B approved petition with Company B and travel to US? If yes, what will the process be and how long does it take?
Yes, you are cap exempt in this situation because you have previously filed a H1, even though you worked. But of course, or how they exempt is often the interpretation of who is cap exempt, and often change. USCIS right now will consider this to be a cap exempt case, but moving forward, if USCIS gets more strict with reference to the interpretation of who is cap exempt and who is not, they might insist that in order to be cap exempt, you have to actually start working for the company. But as of now, yes, you are cap exempt. You can file for another H1 and then get your visa. Once you get an approval, if you already have a visa, you can use the existing visa and the new H1B approval to travel as well.
Okay. All right. Thank you so much, Prashanti, for addressing this one, and thank you, MD Nazim, for joining us with your question. And I hope that was, good. Good. I mean, if you have more questions, you can keep commenting. Thank you. And Prashanti, maybe we could take up, if you still got a little more time, we can take up Arpita's question.
Sure, one more
I am an
question.
Indian national. All right. I am an Indian national currently working in the US on H-1B visa, and I'm interested in applying for a green card under EB3 category. However, I'm concerned about the per country limit and potential retrogression. Can you explain how the EB3 category works and what are the specific requirements and procedures I need to follow to increase my chances of a successful application and given the current visa bulletin?
Just that you apply under EB2 category if you qualify. Just to let you know, in order to your job should require either a master's degree or a bachelor's plus a 4-year bachelor's plus 5 years of work experience. So if you qualify under EB2 and you file your I-140 under EB2, then if EB3 becomes available or shoots ahead, then you can always file your I-140 under EB3. This way you can have an EB3 as well as an EB2 application. This gives you more flexibility. and you can use either or. 85 depending on the dates. If you file under EB3 to start off with, if you file your labor cert under EB3, then you will not qualify under EB2. So if you are EB2, and then you can always, downgrade to EB3. But if you don't qualify for EB2, which may be, yeah. So if you don't qualify though for EB2 and that's why you're interested in filing for EB3, then by all means go ahead and do it. The requirements are the same. You have to file a labor cert. You have to have a bachelor's degree, or if you're doing EB3 under specialized workers, then you can have even less than a bachelor's degree. File the labor cert first, and once it gets approved, you have to file the I-140.
Thank you so much, Prashanti. And Arpita, all the best. I'm sure you will figure out what's going to be best for you. And I think it's always best to consult an attorney. And why not contact attorney Prashanti Reddy? You can call her directly, and her number is 212-354-1010. You can also email attorney Prashanti Reddy. Her email address is prashanti@reddyesq.com. And please go visit www.reddyesq.com to get to know more about attorney Prashanti Reddy and the law offices of Prashanti Reddy. Uh, Thank you so much, Prashanti. It was great discussing, the latest updates on the new H-1B regulations and also the visa bulletin for January 2025. Thank you so much for joining us.
Thank you.
Well, I think it's going to be Christmas coming Wednesday. I still hope that I'll be able to see you, but even if not, here's wishing you Merry Christmas to you and your whole team out there.
Thank you. And I like to wish you and the audience that's listening happy holidays as well.
Thank you so much, Prashanti. Thank you. This is it for now. Folks out there, thank you so much for joining us. And that's all we have for today's discussion. If you found this session helpful, please don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. And also hit the bell icon so that whenever we have discussions like these, you are notified. And don't forget to follow us on social media, because we are there on not just YouTube, but also on Facebook, LinkedIn, and on X. So yes, follow us for updates on future episodes and webinars. And remember to stay informed. It is the first step to making confident decisions about your immigration journey. Thanks for watching, and stay tuned on Immigration and Jobs Talk Show, because we got a lot more coming up. And also look out for our 4 p.m. Show, which is Daily Immigration Dose with my co-host Sam. So yes, see you then. For now, keep on having a great day ahead. Hello, everyone, and welcome to Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and I'm really happy to be here. Before we start off with today's discussion, and I invite our guest for today's discussion, I have this disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, once again, friends, welcome to Immigration and Jobs Talk Show. And today we are going to dive into a topic that touches hearts and changes lives: adoption law. What are the key legal steps of adopting a child? I know adoption is a profound journey, and not just emotionally, but legally as well. It fulfills the dreams of countless families, and it also requires, exploring and understanding a complex maze of legal requirements. So, from choosing the right adoption agency to finalizing the whole process in the court, every step needs to be handled with utmost care and precision. And to help us understand this intricate process even better today, I'm really honored to welcome our esteemed guest, a general counsel and attorney at law from Sing Law, New Jersey. With years of experience in family and adoption law, our guest has been a guiding light for countless families in their adoption journey. So, without further ado, please help me welcome attorney Seema Singh after a real long time. Hi, Seema. Thank you so much for joining us back. So good to see you.
Hi, Nipasa. Thank you so much for inviting me. And yes, I've been away for a bit, but I'm back here now, and I'm looking forward to this show. It's
Me
something
too.
that touches my heart with people adopting some child who's in need. So it's awesome. Thank you so much for inviting me.
Thank you so much, Seema. And yes, we would love to know maybe some of your favorite cases or some favorite stories also that you would like to share a little later in the show. And, before we begin, also, folks out there, let me tell you that you can also participate in this, in this webinar by commenting whatever questions you have, especially with regard to the topic of discussion. And you can even call us, in fact, you can call us on this number that's there on the screen, 425-436-6335, and the access code is 988-888. Once you're in, you just say hello and we will be able to hear you. So, yes, thank you so much. And without further ado, I think, Seema, we are ready to start our show. And I have these questions. But before that, maybe you could tell us what can folks out there expect from this episode today?
I mean, people who are looking to adopt, I will, walk them through what are the steps for adoption, what are the requirements, what are the different kinds of adoptions, and then there are, questions such as, how do you locate the birth parents or the birth father rather, and what happens in cases where the birth parents change their mind, at what point can or cannot change their mind, and any other questions that people would want to know. And if those living in New Jersey or in the US, how are children adopted, the process for adopting them from foreign countries or from interstate, following the ICPC laws. And whatever other questions they have, if I can answer them, I'd be glad to answer. But this is what they can expect to hear on the show.
Thank you so much, Seema. I'm really looking forward to today's discussion. And I have this first question, and let's just jump into it. So, what are the key legal steps required to adopt a child in the United States?
So before you even go into the legal steps, there are non-legal steps, and then there are legal steps to follow. So the non-legal steps include, first of all, an inquiry into, where one can adopt a child, or people who putting them up for adoption, they go to an adoption agency. So the first step is to identify the birth parents and which child can you adopt. So there are various ways of doing that. First, you can go to adoption agencies. There are other placement through networking with friends. Sometimes people go to their churches or temples and talk to their clergies or doctors. And then in New Jersey, you have the New Jersey Division of Youth and Family Services, and they have a foster care system where one could adopt eventually, but foster care is not adoption. Those are just for temporarily housing these kids. But it could become a resource to identify a child who could be put up for adoption later on. So once you have identified the birth parents, the process starts. And there's a home study that is conducted. So it's an opportunity for the agency to learn about the prospective adoptive families and for the families to learn about the role of these adoption agencies. So a pre-service training is first provided. There's 27 hours of training to the prospective adoptive parents to sort of walk them over, what is required, and to determine if adoption would be feasible for them or not, and to prepare them for responsibilities to, for these children. Then there are these adoption agencies do individual home visits to the parents, the birth parents who are wanting to put up their child for adoption. And they go through the family's history, the family story, who the family members are, and it's a detailed one. Then they check into references for these people, talk to other family members, talk to neighbors, talk to whoever they feel is necessary. And they establish whether there's a criminal history, what's the educational background, the employment, childcare, all of those issues are determined. Then finally, there's an approval and licensing. So since July 2005 in New Jersey, it's necessary for adoptive families to be licensed by the Office of Licensing, that's the OOL. And then once they complete the home study, the resource family workers will forward this study to the Office of Licensing. And then based upon their findings, you get licensed. And then once you're licensed, then you wait for an availability of a child. Or if the child is already earmarked, then you start that process. So once that happens and the licensing takes place, the next step is the selection and the pre-placement. So when the family is finally selected for a child, then these adoption agencies will meet with them, and they will go through the child's family background history, which they've done previously as well. And then after the pre-placement, if both the families, the birth parents and the adoption agency are comfortable, and sometimes also the child's opinion, if their child is 10 years or older, their opinion is also taken into account as to what they feel about the adoptive parents. And then once that's all in place, then the placement and the supervision starts. The child is then placed at the adoptive parents' homes, and obviously, it's a new environment. A lot of times the state would recommend that they go for counseling and therapy to make them, in sync and jive with each other. And it's very important for people to understand that there's some fear, there's discomfort because you're in a new environment. So within 5 days of the placement, the adoption agency will come there and they will discuss with the adoptive parents if there are any issues or how things are going. And especially for school-age children, there are many more issues than for a smaller baby, an infant, or a child less than 5 years old. So at that point, if they are school-going children or teenagers, they recommend a lot of counseling and therapy just to make them in sync with each other. Once that is complete, then unless there are specific issues that need to be addressed, then the adoption agency, 6 months after the placement, will then forward their consent to adopt to the adoptive parent's attorney, and the attorney will file the legal petition to adopt and secure a date for the final hearing. At that point, the adoption agency will submit to the court all the study work that they've done, the research, all the investigation, and sometimes the adoption agency will also attend the final hearing. And sometimes the judges will also speak to a child if they're 10 years or over, just to see how the child feels about it. And that's extremely important. So once the court is satisfied, then during that time, he will make the adoptive parents the legal parents of the child with full rights as the birth parents. And then subsequent to that, the attorney will get an amended birth certificate. If the child's name is being changed, they will have an amended birth certificate with the name as given by the adopted parents. And then the original birth certificate will be placed under seal by the Bureau of Vital Statistics. And that is basically the process.
Wow.
Anything else you need to
Yes,
cover?
there's so much going on, and every step needs to be given proper attention to, with all documents required, I'm sure. So
Yep.
maybe if you would like to highlight some very important documents, maybe, Seema, for folks out
I
there
mean,
who really want to
the
adopt.
home study is the most important part of it, where you have to prove your financials, your education, whether you have any criminal history or not, how the environment in your home is, and whether the child will be comfortable there or not. That's the most important part. And adoptive parents, how loving they are. So these caseworkers actually come and really do a proper interview. So that is the most crucial part, I feel. And the other very important part is to identify the child that you want, because that could be a challenge. You could be on a waiting list for a long time otherwise. So a lot of times they recommend that, sometimes they come with these private adoptions where they already know the children. So those become easier. But the court scrutinizes it and makes sure that the adoption is being done for a legitimate purpose and not just to exploit a child.
So true, so true. We will talk further on this, but let's go on to our next question for now. So, Seema, if you can explain the different types of adoption as well, would be great.
So there are many types of adoption, and I have some notes here. I didn't want to miss out on anything. First of all, adoption is where a legal rights and responsibilities and duties and privileges and relationships of the child with their birth parent changes and is conferred upon the adoptive parents. And there are many types of adoptions, which one is a finalized adoption, which is the legal transfer of all the parental rights and responsibilities from the birth to the adoptive parents, and that's what I've just covered. It's that whole series of steps. Then there is, and that includes the agency adoptions, which I just covered, because an agency adoption is where the birth parents and the child independently come to that agency, and the agency sort of builds that bridge and matches the child with the parent. Then we have foreign adoptions. There are children in the US who are adopting from foreign countries. Those become challenging at times because you have to, the adoption agency becomes the immediate relative of the orphan or the alien child for the purposes of immigration. And they have to follow all the USCIS immigration laws. They also have to comply with the Inter-Country Adoption Universal Accreditation Act, and they have to comply with each country's supervision and visitation requirements. And then once they come into the country, there are Hague Convention on Inter-Country Adoption once they enter the United States that they also have to comply with. So foreign adoptions can become a challenge because of all of these laws that you have to, you have to jump through these hoops. Then you have private adoptions, which is where the agency becomes involved in providing services to each birth parent, legal parent, prospective adoptive parent who is considering to place the child for adoption. In a private adoption, there is a direct contact between the two sets of parents. And sometimes they often have already met before the child's birth, or they attend the birth at the hospital. So it's very early on in the age. And there is direct contact between them. So they've already met, they've spoken even before the child comes into being. Then there is independent adoption. And this is where the child is received in the adoptive home from a source other than an agency. And then subsequent to the placement, they are placed first, and then the court orders an agency to conduct the adoption complaint investigation. So like in a finalized adoption, you have the home study and all that taking place first. In an independent adoption, the child is adopted, and then before you go to court for the final, for the formalized documents, the court will then appoint an agency to conduct these, the ACI, the adoption complaint investigation, and to make sure that that home is, a proper place. Then you have step parent adoptions, where, adoption of a child by the birth parent's current spouse and or a relative adoption that's, between in the families. Then we have another situation of open adoption, where there is, even after the adoption, there is some kind of a minimal contact that the child maintains with their birth parents, whether it's sending a letter on every birthday or, meeting minimally once a year. So those open adoptions in New Jersey are not enforceable. So even if some promises are made upfront that, okay, yeah, you can keep in touch with your children, and then the adoptive parents change their mind, in New Jersey, the birth parents cannot enforce that because open adoption is not recognized in New Jersey. Then you have interstate adoption, where there could be adoption between the different states of New Jersey and Pennsylvania, or, those states get involved. That's where the Interstate Compact on Placement of Children, which is the ICPC, that gets invoked. So there's both for the sending and the receiving state. there are laws that have to be followed for that as well. So these are the various kinds of adoptions that that are out there for
Out
people to
there.
consider.
Thank you so much, for covering that in details, telling us about the different types of adoption that are available out there, existing out there. Thank you so much. And at this moment, Seema, I'll just quickly say hello to our folks who have joined us. Farooq on YouTube, then Sunita, we have Ahmed on LinkedIn, Sahil as well. Thank you so much for joining us with your questions. We are going to address them shortly. So please stay with us on our show. Let's move on now, Seema. So, what are the general eligibility criteria for prospective adoptive parents? And, are there specific legal or financial prerequisites to meet?
Yes, there are requirements. Age is an important one. They have to be at least 18 years or old, which I feel 18 is also too young. But yeah, the age is 18 or older and at least 10 years older than the child that they want to adopt. That's one requirement. Then you have the residents. The adoptive parents must be New Jersey residents. This is if the adoption is happening in New Jersey. Then health. The adoptive parents must be in good physical and mental health. Then you have the background, which is extremely important. They should have a clean criminal and financial background. A home study is conducted. They have to pass this home study, which includes criminal background check, interviews, visit to their home, references must match up. That's pretty strenuous. It's like a very detailed kind of home study they need to pass. Then licensing. They have to be licensed by the OOL, which I covered prior. And after they pass the home study, they have to get this license. And the licensing inspector will visit the adoptive parent's home to ensure that they meet these licensing requirements. They have to be licensed to adopt. Then married couples must both agree to adopt the child. It cannot be that one spouse wants it and the other doesn't. They will not allow an adoption to go forth. Then subsidies. Sometimes adoptive parents also get subsidies, which includes a monthly payment and one-time payment for legal fees. It all depends on the scenario. That's not a hard and fast rule in every case. Then the birth parents, the New Jersey laws to protect birth parents. There are specific laws to protect the birth parents, including financial support and the right to change their mind. They have a right to change their mind before the finalization. So these are the requirements that are needed. And in New Jersey, there is no discrimination. All peoples of all race, religion, sexual orientation, and marital status are eligible to adopt. There is no such discrimination on any kind of, any person.
All right. Thank you so much. Thank you so much, Seema, for letting us know about all these different criteria that are out there. And we're talking about home study, does it happen that, suppose real parents, like real birth parents of a child, if they're not able to meet some certain requirements, and maybe there are people in the neighborhood noticing it or in the school noticing it, do you think people from home study can come and probably seize your child?
Well, that's if some complaint has been filed to DIFUS. But if an adoptive parent wants to put their child up for adoption, then the review is different. If they are not treating their child properly or things are going on, then DIFUS gets involved. That's a whole different process. And sometimes DIFUS can take your child away till things are resolved. And that's where foster care comes into place. They put them up in foster care so that the child has a temporary home while things are being resolved with their, birth parents. So two different things. When they put their child up voluntarily for adoption, the review is different than if they are mistreating the child or there are issues in the home that are not, conducive to the child's upbringing there, and somebody has complained.
Mhm. Mhm. All right, all right. Thank you so much, Seema, for highlighting that as well. Let's move on now to our next question. And tell us, Seema, is it mandatory to hire an attorney for adoption, or can prospective parents navigate the process independently?
You can. I wouldn't recommend it because at some point you do need an attorney to file those petitions and get the orders finalized, get the birth parents, the records sealed, um, get the new birth certificate. You do require an attorney at some point. But yeah, you can go ahead and do it on your own. I wouldn't recommend it. And I've seen in one case that I was handling where an attorney was needed actually to identify the the child being adopted. So sometimes attorneys have these resources as well, where they can help you find a child or identify a birth parent. So it's really a person's choice, but I know it's easier to navigate through this as an attorney. And I'm an attorney, so obviously I would say that.
Absolutely.
Not
Yes,
sympathetic.
folks. And you can actually go and contact
You
Attorney
can.
Seema Singh as well. And her phone number is here on the screen, 609-454-3169. And you can email
68.
her
3168.
3168. Did I say it wrong? Okay, let me repeat that. 609-454-3168. That's a number, and her email address is seema@ssinglawcom. And go visit www.ssinglawcom to get to know more about Attorney Seema Singh. And Seema, of course, I'm sure you have many cases. Maybe if you have something very close to your heart with regard to adoption, it'll be really nice to know it from you.
I mean, I do, and I have not done many adoptions, but the few
Okay.
that I have done, one is still in the pipeline, and we are like keeping fingers crossed that it goes through, because it's this lovely couple who've been trying to have a baby. They just can't have a baby. They've tried IVF, and by the way, if you have a surrogate that you're proceeding with, you cannot adopt. So it has to be one or the two. So in that case, there was a surrogate involved, and then the adoption agencies found out, because you have to fill out this questionnaire. So they first rejected it, and then unfortunately the surrogate, miscarried. So then they went back to the adoption agencies, and right now, they did identify a child, but it hasn't yet come to fruition. So we are keeping our fingers crossed. That's the recent one that's happening. So
Yes, let's
then there was
let's
one
read.
where
Yeah.
there was one where they took this child from foster care, and that was like really sad. He was a boy, and he loved this couple, the adoptive parents or the foster parents. They took them as foster care, subject to adoption later on, and the parents had passed away. But then the grandparents arrived from India, and they snatched this child because they were. And a lot of times people want to take them because the state is funding it, which is very unfortunate, because you have older grandparents who are taking this child. How long are they going to live? Right. So that was really a sad scenario where they got so attached to this child. The child was very attached to the adoptive parents, but they took him away because it was foster care leading to adoption. So that was a sad one.
I hope they're still in touch though.
No, they had to break ties, because it was very tough for them to keep in touch, and then the grandparents sort of discontinued that connection. So they were
It's
devastated.
heartbreaking sometimes,
It
Ray.
was very, very, very heartbreaking. So it's a very emotional kind of it's an emotional thing,
It
adoption,
is, it is. It's
and
hard, I'm
especially for
sure.
people who can't have children. I can really, I feel their pain.
Mhm, mhm. Well, I think it's like good news for some and sad news for the others, but it's mixed emotions, and yes, very emotional journey, I think, for many. Thank you, Seema, for highlighting some of those cases that you went through. And let's go on now. Let's come back to our questions. And now, if you can tell us, how does the Interstate Compact on the Placement of Children, the ICPC phase, ICPC impact the process? When adopting a child from New Jersey.
So, Inter-Compact on Placement of Children Act is invoked when you have a child in a different state being brought to New Jersey, or vice versa. So it is, for both the sending state and the receiving state, there are a set of laws. So once the baby is born, the adoptive parents will travel to the sending state to pick up the child. If permitted by the hospital policy, the adoptive parents can also stay there during the birth of the child, but they must wait for approval from the sending state's ICPC before they can leave with that infant. But they cannot return to the receiving state either till the approval of adoption has been granted by the receiving state. So, yeah, if they've identified a child in a different state, the child is born, they can travel there. But till all the receiving and the sending states laws are cleared and they get approval in both the states, they cannot bring the infant back home. So once the infant is in the home, once that is all clear, they're in the home, then a complaint for adoption is filed within 45 days. And then within 90 to 120 days of the child entering the home, the court will schedule the preliminary hearing. Then the notice of adoption is served on both the birth parents, upon the birth parents, in accordance with the statute of the state where the child is now. And especially this is done only if the legal rights are not surrendered, because now you have to formalize it. So it goes backwards in the case of ICPC. You first bring the child, then all of this is done. And at the time of the preliminary hearing, the birth parents' parental rights gets terminated if they have not filed any objection. And then a final hearing takes place 6 months later. And then most courts in New Jersey will not require an appearance at that time. Then it's just, it's stamped and you are on your way. So that's how the
thank you so much.
ICPC works. That's for in the US interstate.
Okay.
With the
okay.
foreign laws, you have the USCIS laws and all those other accreditation act that kicks in.
Okay. Thank you so much, Seema, for taking that and for your detailed explanation. I think at this moment we should address some of the comments from our viewers. So
Sure.
let's take one by one. Control, if you could just pull them up, please. We'll come back to our questions again, but let's go with Ahmed on LinkedIn saying, can you adopt newborns within USA and outside USA?
Yeah, sure, you can adopt, but again, there are laws you have to pass, like all the steps that I went through. You have to make sure that you comply with them. I covered that in detail. So you have to make
Yes.
sure if you within USA is the ICPC, it's within different states. If you're in one state, you're adopting from another state, then you have to get approvals from both the state. And then
Each step is very
USA,
crucial. Yes.
outside USA, I covered the immigration laws, and that at that point the adoption agency becomes the parent or the guardian for the person for the child who's coming into the country.
Right, right. So, Ahmed, I suggest you can watch this whole episode again, because once we are done streaming, this episode is still going to be available, and you can go through, because each step is crucial, and Seema has already covered that in this episode. So, thank you for your question, and if you have any more further questions, you can keep commenting, or better even, just join us in this call. You can dial this number 425-436-6335, and the access code is 988888. Once you're in, just say hello, and we will be able to hear you. Thank you. Now, moving on, let's take up Sunita's question on YouTube. My spouse and I are considering adoption, but we've heard the process can be overwhelming. What are the first legal steps we need to take to ensure we are eligible to adopt in our state? We
I,
already
I
identified a child we want to adopt through a private agency.
So I don't know which state they are in, but each state has their own adoption laws. The laws that I covered belong to the state of New Jersey. So if you're in New Jersey, if you go back to my, the whole show, you'll see all the steps I've outlined. But an adoption agency can actually walk you through those steps. You should hire an attorney, because eventually you will require that attorney to formalize that entire process and to finalize your adoption, to do the changes in the birth certificate, to seal the birth parents, the records of the birth parents. All of that is sealed, and very rarely, I've never heard of these being ever reopened. So if you go through that, if you can get a child right away and everything goes fine, the adoption can really go smoothly. So the biggest issue is to identify the child, and if there is a child ready to be adopted. So your best bet is to go to the adoption agency in your state and discuss it with them. There are sometimes attorneys who do adoptions in that state. They have the resources also to help you identify. So that's what I would recommend.
Thank you so much, Seema, for taking that up for Sunita. Sunita, thank you for your questions. If you have more questions, you can keep commenting, or please join us on this call. Let's go on now. Let's take up Sahil's question. This is on YouTube. What are the key differences between federal and state adoption laws in the US, and how do state specific laws impact the domestic infant adoption process?
Okay,
Anything
I
you want to
covered
say?
all of New Jersey. So if you go back to my show, I have covered how these laws are impacting and what processes are in place for the adoption. There are, identifying the child. There's an inquiry process. There is a home study that's conducted. There are references that are obtained. Then you go to the court. You go for licensing, where the home study, all of that is produced. Once you get your license to adopt, that's when you can actually adopt. I've covered it in detail if you hear the show from the beginning. They may be
Right.
just getting on right now.
Yes. Yes, Sahil, you can always go back and listen to whatever Seema has already touched on because she has covered each step very much in detail and it'll be very helpful for you too. I hope that you were there since the beginning of the show, but even if not, you can always go back and listen to it.
But
Thank you, Sahil.
if you're going to an adoption agency, they can walk you through these steps as well. Hire an attorney in your state, wherever you are, to adopt, and they can help you as well. An adoption attorney, in fact, has resources as well to help you identify a child.
Perfect. Thank you so much, Seema. Thank you, Sahil, for your question. Let's take up Amir's questions on YouTube. I'm interested in adopting a child from foster care. What are the specific requirements and timelines under the Adoption and Safe Families Act that I should be aware of? And how does the interstate compact on placement of children impact my adoption process if I'm adopting across state lines?
So I've covered that as well, the ICPC laws. You have to make sure that you get approval from the receiving state and the sending state. So if you're in New Jersey adopting from Pennsylvania, you need to get approval from both the states before you can bring the child into the receiving state. And then the complaint for adoption is filed, the notices are given, the parental rights are terminated for the birth parent, and it's transferred or conferred upon the adoptive parents. And the birth records are sealed, new birth certificates are created. I've covered that in detail, the ICPC laws. But foster care is for temporary placement of a child in a home because of reasons that they could not survive in their home or they're not ready for adoption yet, the consent has not been obtained. So all of those things factor in for foster care. But if you are getting a child from foster care, that has its own separate steps, and it's a 6-step process for fostering a child, and then later on, if they are up for adoption, to adopt. So for that, you have to first request information from whichever state you're in. I know in New Jersey you have the US Kids that you can contact, and they can give you information on fostering. They have an orientation meeting for the fostering parent, where they will walk you through the journey of fostering, how to become a foster parent, the characteristic of what kind of kids are in foster care, the foster care rules and regulations. They'll walk you through all of that. Then you have to submit a foster care application, and your agency's social worker can help you put all the required documentation, the background checks, the personal references, the state-specific criteria, all that is compiled with your application for fostering. Then you attend a pre-service training, which is about, I believe it's 30 hours of formal parent training, which covers essential topics from what to expect to trauma-informed foster care. Then you have a complete assessment and a home study. A home study is done of your home to make sure that it is compliant with the foster care rules. Home visits and interviews from social workers take place to ensure that you're a good fit and that you're ready to be matched with a foster child. And then finally, you have to get your foster license, which is, it takes about 3 to 6 months, and it'll get you your family license, and then you're ready to, welcome a foster child to your home. And then once that foster child comes, you have to be prepared that it's temporary. That child is not there. You're not adopting the child. You're just a foster parent. The birth parents or somebody from their family could come and take that child. So, and sometimes that is, traumatizing for the parents who are fostering them. But then there are other times where people are taking foster children for the wrong reasons, just to get the money, because there's, I think, $700+ that you get for each child that you foster from the state of New Jersey. And
Mhm.
there are other there's other kinds of monies that you get as well. So for example, if you're working and you're fostering a child, you could also get childcare services while you're working, or special transportation reimbursement, or any infant care items, um, car seats, bicycle helmets, all of that can be provided. And then
Mhm.
flexible funds for the child's special needs. If it's a special needs child, then that money is given as well. So it's a huge responsibility when you are a foster parent. You have to do it for the right reasons.
So true, so true. So, Seema, talking about foster parents, foster children, is there like any specific hard and fast rule, or as in like the minimum time or the maximum time? Just, I mean, because there's so much chances that they could get attached to each other, right?
I don't believe there's any minimum or maximum time. That's,
Okay,
it's on a case by case
so
basis.
it can
The
go on
child,
to a year, 2 years, 3 years.
I've known of an individual who fosters three or four children, and I would always wonder why she's been selected as a foster parent, because
Mhm.
I didn't believe her home was equipped for four children, but
Okay,
she had them for almost 3 to 4 years.
wow,
So, but then there are foster kids that can come for a few months. So
right.
there's no hard and fast minimum or maximum requirement.
Mhm.
It's on a case by case basis.
All right, all right. Thank you so much, Seema. Thank you. And let's go on now. We have Rajesh who has joined us on YouTube. He's asking, what are the key provisions of safe haven laws and putative father registry laws, and how do they impact the adoption process, particularly in cases of infant relinquishment and unmarried biological father's rights? Anything you want to say on this?
Well, first of all, in New Jersey, a birth mother, doesn't need to identify who the child's father is. And if
Okay.
it's not identified, the father has no rights because no notice is provided. But if a father's name is mentioned on your birth certificate, then you have to follow the process and give them the due notice. And within 120 days, if once the proper service of notice is done and they do not respond, um, then it's waived. And if a mother refuses to give her father's name, that the courts will waive that. In New Jersey, it's not required, but I'm not sure about other states. I know New Jersey, if the father cannot be found, then that's an at-risk adoption because then the father could surface at some point. But if the father's name is not mentioned on the birth record, then that's waived. So
All
I'm not
right.
sure what kind of rights those are, but that's what it is. If a parent is missing, then there's a diligent search that must be conducted, and proper service of you need to contact all the proof of contacting all the different agencies, for example, the local post office, the motor vehicles, the county welfare agency, the municipal, the state police, the state prisons, um, and any other social service law enforcement agencies need to be send a notice regarding finding that missing parent. And then failure to receive a response within 45 days is a negative response. So you
Okay.
have to do that due diligence to find the parent, if the father, if the name is mentioned on the birth certificate.
All right. All right. Thank you, Seema. Thank you for taking that up for Rajesh. Rajesh, thank you for your questions. If you have any further questions, please keep commenting or join us on a call, okay? And Seema, let's get back to our questions. I have a few more. So, if you could tell us, for international adoptions, what are some common legal hurdles, families face, and how can they prepare to overcome them?
It's all the immigration laws and the laws of the state where they are coming. And we know they keep changing. So if you filed and there's an amendment to the law, you have to comply with that as well. So it's like a moving target. And that's where the challenges arise. And then there are certain countries where it's easier to adopt kids from versus others. And then the
Yes.
country of, like I know from India, to adopt a child is pretty tough because of certain laws there. But I
Mhm.
know I have many clients. Um, I didn't do the adoption, but I've heard that they have adopted from Korea or China, and it's very easy to adopt. So it all depends country by country, and the challenges you face is all related to the immigration laws and the accreditation act of that particular country.
All right. Thank you so much, Seema, for taking
It's
that
on
up.
the Inter-Country Adoption Universal Accreditation Act um, that you have to comply with in the other countries. And then the Federal Immigration and Naturalization Act is the law of the US that you have to comply with.
Right, right. Thank you, Seema. Thank you for taking that up. Now let's go on to my next question, and if you could tell us, what legal steps are involved in obtaining consent from the child's birth parents, and under what circumstances can parental rights be terminated?
Is this adoption, or because parental rights can also be terminated with other scenarios, even if you're not adopting? The court can, on a petition by a family member or DIFUS, terminate
Let's
parental
cover both.
rights.
Let's
If
cover
the
both scenarios.
Right. So that's a whole legal process. You have to file the application. There's hearings. There's again interviews, home studies. A guardian ad litem is appointed, which is the attorney for the child specifically. So you can get the parental rights terminated for many other reasons, not necessarily just for adoption. And getting consent from the child's birth parents is all again the steps that I've covered. The
Yes.
birth parents will come and voluntarily say we are putting our child up for adoption. So basically, they are consenting, but subject to whether the adoption agency feels that, gets an entire rundown on the background of the families, who does a home study. So in both scenarios, a home study is done with the adoptive parents and with the birth parents. They go and check out all the background so that they have it in their record to supply it to somebody who's wanting to adopt. Whether they have special needs, all of that is identified. Any criminal history of the parents, adopting parents would want to know what's the background of the child.
Yes.
So when the child is voluntarily putting it up for adoption, to me, that's consenting. But in other scenarios, a court can intervene based upon a petition made by someone or the other to terminate the parental rights because of mistreatment of the child, abuse. DIFUS can intervene. So there are many scenarios where a parental rights can be terminated. It's
Yes.
a
Even
strict threshold,
separation.
but it can be done. It has been done.
Right, right.
And
Right.
sometimes one spouse will move against the other spouse to terminate their parental rights and to take sole custody of the child. And
Exactly.
in those scenarios, it happens a lot in divorce cases where
Yes.
the one parent is not suitable or has lot of issues, where the other parent will move the court to terminate the parental rights. But again, the court can appoint a guardian ad litem for the child to make sure that a child is represented as well.
Right,
So
right. Thank you, Seema. I mean, thank you for highlighting those and for taking this up and for the detailed explanation. Thank you. Very much important, I think. And now, going on, let's move on to our next one. So, what happens if a birth parent changes their mind after placing their child for adoption? How does
so
the law, the law protection for both the child and the adoptive family in such situations? I mean, what do they do?
So when I took you down the steps, we came to that final step where the court terminates the rights and hands it over to the adoptive parents. Once that happens and the parental rights have been surrendered, you can't go back. Then
Oh,
the
okay.
adoptive parents have equal rights as the same rights as the birth parents. So once
Mhm.
that is finalized, everything is locked, sealed, closed. You cannot turn back.
I think in most cases they'll ask the child then who did they want to choose? Is it?
No, that's already done. When the
Okay.
child is 10 years or older, I walked you through that. They
Yes,
come
yes,
for
you
the
did.
hearing, and at that point, a child has a right to express their opinion, but it's making sure that they are 10 years or older and are not influenced by someone else. Their opinion is also taken by the court. So that's
Yes,
already
yes.
done.
It's done,
Once all of
right?
that is done, and please understand that the child has already been placed in the adoptive parents' homes. So when you're coming for this hearing, it's 6 months after. So at that point, you can change your mind before everything is signed and sealed. But once that is done, and the parental rights are surrendered, you can't go back.
There's no going back.
No. But you have enough time before that.
Exactly. Exactly. All right. So, anything that protects, these, any law that protects the birth parents if they want to go back? No, nothing, right? Once it's done,
No,
it's
it's
done.
in New Jersey, all records relating to adoption proceedings, including the complaint, the judgment, all the petitions, the affidavits, the testimony, the home study reports, the briefs, the notes, and any relevant document, they are sealed by the county clerk, the court clerk, and they may not be opened to inspection or copying without a court order, which is almost never occurs.
Okay.
In some cases, the court may choose to provide an adopted child with medical information without releasing the names of the birth parents. But there may be some medical information, that's needed for even the adoptive parents regarding the child that the court will release, but not the names.
Okay. Okay. All right. Thank you, Seema. Thank you for taking that up and for the detailed explanation. So, if a birth parent wants to maintain contact with the child post adoption, how can adoptive families navigate open adoption agreements while ensuring they comply with legal boundaries?
In New Jersey, they are not enforceable, but many
Okay.
states do have that. And I do not know much about the other states, but in New Jersey, even if the birth parents and the adoptive parents agree that they'll be able to maintain contact, and then the adoptive parents, decide no, it's affecting the child to settle down, then that's not going to fly.
Okay.
Marianne?
Thank you, Seema. Thank you. And what about cases where these adopted children, find out later that they were adopted, and they really want to know who their birth parents were? What about situations like that?
I know a lot of them go hunting around, and I know the
Yes.
court records cannot be reopened, but they may find other places to find out and dig, and you keep seeing these talk shows where somebody just discovered 50 years later who their birth parents were. So I'm not sure how that works, but I know court records. I've never seen it being reopened, because that
Mhm.
literally strips the adoptive parent for all the rights and responsibilities and what all they've done to the child. So it's pretty unfair.
It is. It is.
I don't know how to
But I
answer.
think, yeah. But once I think some of them, they really, of course, they are hurt that their own birth parents left them, and when they want to hunt, some want to, some don't want to hunt them down. But I think the all they want to know is why, right?
In a
I
lot
think
of
that's
private adoptions, like between families, I know we have a scenario right in our friend circle where the child was told when she became a teenager, about 16 years old, she was told who her birth mother was. And they have a great relationship even today. I'm sure maybe deep down she despises her birth mother, but they seem to have a good, cordial relationship. But where these legalities, from totally unknown parents, I don't think an adoptive parent will allow them to find out about.
so true. So true. Well, Seema, anything more you want to say
It's
about?
very, it's a very emotional topic.
It is. It
Adoption.
is actually. Actually, yes. So many lives involved and so much responsibility. Some fail with their responsibility and open to adoption, and there are other cases where they find out later, like we just spoke just now, and they want to hunt them down. But yeah, so much, I think so much has been happening. Any more or any case study you want to tell us about, Seema, before we wrap up our show for today?
Well, what I would really say is that if you're planning to adopt, make sure that both parties are in sync and they are equally loving to a child from a third party. Because sometimes you feel yes, but when the child comes in, one parent is like not fully there, and it's very
Mhm.
unfair to the child you're bringing in. And I've seen this happening, and that's why I bring it up. You have to be fully in sync, because when you adopt a child, he's your legal heir, or he or she is your legal heir. Whatever you have belongs to them. So you got to be really in, be true to yourself that you really want to adopt someone. A lot of people can't share, thinking that it's someone else's child. So make sure that you're adopting for the right reasons. You're really wanting to adopt. You really love children, because I don't know if I could adopt, being very honest. I don't know if I can adopt someone's child.
Mhm.
So you have to really, do soul searching and be honest to yourself. Is can I adopt? Can I be true to this child that I'm bringing in? And I've seen really loving parents. My friend's daughter has adopted children from Korea, and I see the way those kids are like Indian. They look Korean, but they're
They
completely
speak.
Indian, and they are so loved by everyone. So that makes you feel good. I love seeing that, but I'm not sure if I could do it. So you really have to be true to yourself, because this is a very emotional. It's an emotional process. You really have to love children. So that I would really caution everyone that do it for the right reason. Sometimes people feel, oh, we are married, we're not having kids. Okay, let's adopt. But that's the
Mhm.
wrong thing. Make sure you really love kids to adopt.
That you really want to give them
Really want
your
to give,
all.
yes, exactly. Not only your all, your financial all.
Financial all, everything. I mean,
That's
because you're leaving behind everything and your kid. So
yeah.
yes, I'm sure. Must be so hard. But yes, so wow, a very emotional topic, and I'm sure I'm only folks out there who are going through all these processes will know. And we would love to know your side of the story as well. So, folks, if you have anything to share about yourself or your friends, families, anything, we would love to know. So keep commenting, maybe tell us, you can mail us. And if you need an attorney, maybe to navigate through your adoption process, why not contact attorney Seema Singh, and her telephone number is 609-454-3168. You can even email her. Her email address is seema@ssinglawcom, and you can go visit www.ssinglawcom to get to know more about attorney Seema Singh. Seema, it's been really great chatting with you, and today's topic was, heart touching and very emotional as well. It was really good to know from your side, especially about New Jersey, the laws and the legal steps with regard to adopting a child. So yes, will be that'll be really nice. And anything more you want to add before we leave, Seema?
Well, thank you so much for inviting me. It's a lovely topic. I love covering this topic. Uh, but again, anybody not having children, you can reach out to me if you're looking for adoption. You can do it yourself as well. So you don't need an attorney. I do want to say that. You don't need an attorney. It's always good to have one, because sooner or later you will need them to formalize all your steps. You have to be in court for that to do it. But yes, you can do it yourself as well. If you are willing to teach yourself and do it, go for it. But again, adoption is a beautiful thing. There are so many children out there who could, be in a good family, in a good environment. And if you have an open heart, an open house, bring someone in, I just think it's so good to give back. It's a way to give back if you don't have your own children. If you have your own children, think 10 times, because you don't want that disparity to come. And I'm not even sure how willing adoption agencies are to give you a child for adoption if you already have children. I think they're more pro to people who cannot have and are willing to bring somebody home. But absolutely, if you can give a home to a child who's out there, who's an orphan, who has no one, it's the best thing you can do ever. Or to even a child who is in a family that cannot give a good upbringing to that child and wants to give them up for adoption, go for it.
Thank you, Seema. Thank you. Really, I mean, those end notes were also very important to keep in mind. So, thank you so much for joining us today. And I really hope to see you back once again very soon, I hope. Though it's the holiday season kicking in, I know we are all in the holiday mood.
I know everybody. Happy holidays. Enjoy your new year 2025. Can't wait for the new year to come. But everybody stay blessed, enjoy, stay healthy. Most important. Keep your health in order, because health is wealth. And without that, you could have everything and you have nothing. So good luck to all of you. Stay blessed. Dipasa, thank you so much. And Job Talks, always a pleasure to be on this show. Thank you.
Thank you, Seema. God bless you too. You stay loving and kind, and
Thank
I hope
you.
God blesses you more with more love and abundance. And happy holidays to you too. Merry
Good
Christmas.
news, all the blessings.
Thank you. Thank you.
Thanks.
And see you soon, Seema. All the
Yes.
best.
Thanks.
Thank you, folks. Thank you for joining us today. It was a great time, and I hope you enjoyed this discussion. If you have your questions or stories to share, please feel free to keep commenting. We would love to know your side of the story as well. And yes, don't forget to like, share, and subscribe to our channel. We are Immigration and Jobs Talk Show. We are on YouTube, LinkedIn, and also on Facebook and on X. Don't forget to connect with us, and yes, hit that bell icon so that whenever we have discussions like these, you're also notified. Thank you so much, folks, for joining us, and stay tuned on Immigration and Jobs Talk Show because we have so much to share with you. Bye bye for now.
Grab a water while you do the intro.
Hello, everyone, and welcome to Immigration and Jobs Talk Show. I'm really happy to have you all join us. And I'm Napasa Pradhan, your host for today. Before we go on to today's discussion and we have our guest for today, I want to read out this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks out there, thank you so much for joining us today. We are streaming live right now on YouTube, LinkedIn, and on Facebook, and also on X. So, please feel free to join us by commenting wherever you're watching us, and I will definitely tell you what is today's discussion going to be. But yes, for most of you all, thank you so much. It's been great that you join us, in these webinars. But we would love it if you can also join us, on call, conversation with us and of course our guest. And you can do that by dialing this number 425-436-6335, and the access code is 988-888. So once you're in, you just say hello and we will be able to hear you. So, yes, today we are going to dive into this. One of the most anticipated updates in immigration policy. I think, it's been a while that we have been anticipating this, wanting this to happen, and it's finally happening. So, modernizing the H-1B program. This is a critical topic for both employers and also workers, as the Department of Homeland Security, that is DHS, has announced significant changes and has aimed at improving flexibility and efficiency in the H-1B visa process. So we are going to discuss in details today about this. And joining us today to break down these updates and discuss their impact is none other than Attorney Justin Rivera, who is an immigration attorney and an expert in employment-based immigration law. Thank you so much, Justin, for joining us once again. Really good to have you.
Yeah, thank you for having me, and an early Merry Christmas to everybody.
Absolutely. Here's wishing you too a Merry Christmas. I can see it's looking very festive out there at your home. So here's wishing you a good one, to your whole family out there.
Thank you.
And also to Wasden immigration litigation. I think I should wish them all.
Thank you. Yeah, appreciate it. Looking forward to the time off.
Absolutely. So, Justin, I mean, today's discussion on this topic, modernization, modernizing the H-1B program, and what to expect and how will it impact your business. So, could you tell the folks out there what can they expect from our episode today so that they stay with us?
Yeah, I mean, in terms of what this does for us going into next year, I think it's a very important changes. I mean, some of the stuff is going to be good, as I'll highlight, but some of the stuff, well, I think a lot of it is good, to be honest. So a lot of it's good, some of it's bad. One aspect of it is probably going to be very bad for specific types of employers. We'll dive into it. A big point to point out on this is the regulations themselves actually go into effect on January 17th. And a question that's already on everyone's minds is, after these regulations go in and are codified and the administration changes, are there additional changes made? Is there anything that's pulled back? How would that happen? So the impact of them is TBD. We will have to kind of see what the impact is in Congress with what the new administration wants to do. But for now, this is the playbook. This is what we're going to have moving forward and what we're going to be dealing with. And like I said, some of it is pretty beneficial. There's stuff in here that I think is very helpful, specifically for beneficiaries. Some stuff that's really great for employers as well. Then there's some other stuff that I think is going to make third-party placement more challenging going forward. And then there's some other stuff that's, honestly, it's problematic from my opinion. And I think that you might end up actually seeing litigation on it, if not on some other aspects. But we will do, as deep a dive as is permissible within the hour on all of these aspects. And hopefully everyone comes away more informed and prepared for when these regulations begin their implementation.
Absolutely, Justin, and I'm sure we are all looking forward for this to happen. I mean, long time, right? People have been wanting changes, especially with the H-1B visa system. So, yeah, we will dive right in. But before that, hello to you too, Rag. Thank you so much for joining us on YouTube. He says, hello, Nipasa and Justin. So, also, Trisha, hello to you. We are going to address your questions. Just stay with us. So, Justin, my first question to you would be, if you could explain, how the DHS rule strengthens U.S. employers' ability to fill jobs and what impact it could have on the economy.
So I think at the end of the day, there are certain aspects of this that are great, because I think it's going to modernize and provide clarity on a system that is, for better or worse, overseen by people who are officers, who are in, service centers, that are 9 times out of 10 making decisions that are based off of limited training materials or, prior experiences. One of the biggest things that I think is going to be beneficial is the definition of specialty occupation kind of being updated. To point out this, basically what they've said now is that a degree requirement normal does not mean always within the criteria. So right off the bat, what we're establishing here is a specialty occupation can be a position that typically requires a degree in a specific specialty. It doesn't always have to require a degree. Immediately, what that does is create a more expansive definition, which in turn should make it more simplistic to adjudicate that a position is a specialty occupation. Another thing that was great that I saw was that the petitioner can accept a range of qualifying degree fields to qualify, but they must be directly related to the position. And what they mean by that is there has to be a logical connection between the degree and the duties of the position. All of that is great. I think that is very beneficial. What that does is it shows me that when the service is adjudicating these cases for specialty occupation, they are saying, okay, does this position require a degree? And are the degrees that the petitioner says are required, do they make sense in relation to what this person does? Now, does that mean that someone who has a bachelor's degree in, basket weaving is going to be able to qualify for a position as a computer systems analyst? No, there's no logical connection there. But what it does is it allows for a logical expansion of those fields to where it makes sense. And what I mean by that is this. In the previous administration, when the Trump administration was first in, there were denials that were seen for IT related positions where they basically curtailed it to such a narrow view that they basically said, if you don't have a degree in computer science, you can't do this job. You can't hold this position. And modern day, that's ridiculous. Obviously, people can do those types of jobs based on their degrees, even if the degree has a mild variance to not just being computer science. This opens that door, which puts us in a situation where hopefully the adjudications for specialty occupation makes sense. And so when there is a case that's denied, there's a rational explanation as to the justification for the denial that isn't something as simplistic as you can only hold a degree in X to qualify. So I think that's good. I think that that's going to help people moving forward. Another way that I think that you're going to hopefully see companies benefit is the codification of deference for prior approvals. What that means, just in a non-legalese way, is if you were on an H-1B and you're filing a new H-1B and there's no big change, you should get your case approved based on the deference to the prior approval. Absent a material change or some new evidence that USCIS did not have at the time of the previous adjudication, it should almost be a rubber stamping. So what that means is, obviously, we know there's a significant visa backlog. There are people who are on H-1B now or have been on H-1B for several years that are probably going to continue to be on H-1B. If they are remaining with that same employer and they're not having a significant alteration to their petition, their extensions should just be streamlined, which is great. Again, we don't know what the impact of that's going to be from the new administration, but in theory right now, that should be what we see. Other small things were the itinerary requirement has been completely removed, which is great. I don't think it was something that was really given any consideration now anyway. The acceptance of matter of semio solutions, without going into too much detail, basically really clarifying, when you need to file an amendment versus when you don't need to file an amendment. That's great. Entrepreneurs saw a huge win for them in that, they are codifying the ability of company owners to sponsor themselves for H-1Bs. So that's a big benefit as well. And then there's some other stuff as well that we can kind of get into that's more beneficiary centric. But I think overall, those changes are going to help companies make it easier to bring people in on an H and keep people on an H.
Right. And these changes are only effective from January 17th. So people who have applied before that date, it's not going to affect them, is it?
It should not. There should not be any impact from it until that 17th date, range of implementation.
Okay.
Inevitably, when there is changes, though, you're going to see a period of transition where things are weird, because attorneys, we play within the rules that are provided to us, but a lot of what we do is related to precedent. What have we seen before, and how do we use that information moving forward? So you may see some weird RFEs come out initially as both the petitioners and the officers begin to kind of play within the rules of the new changes. But I'm hoping, at least for these perspectives, it'll be a positive change.
Absolutely. So we'll quickly take up Rag's question. He's asking, the H4L2 bundling with H1L1 ends on January 18, 2025. Will this affect first-time H4 or L2 applicants, with regard to, I guess he's saying, I-539 and I-765?
So this kind of is a remain to be seen thing. It's not. I don't necessarily think you're going to see an uncoupling of the adjudications. I would wait. I would wait and see what happens closer to the actual end date of this administration to see if there's anything else that's put out or provided. I will definitely say this, as I've spoken about before. I think a big idea of the new administration is going to be delaying things where they can to make processes more difficult. And one of the easiest ways that they can target that is by splitting the premium process benefit for the adjudication of H4s and L2s. So it wouldn't shock me if that's something that we're dealing with. But to go the other way, there is a rational benefit to USCIS in keeping the policy in place, especially when you look at it when it's coupled with the idea of the deference that's going to be provided to previous extensions. I think that if you just are already going to approve the H and you can approve everything else together in unison, you get the case out. And for the officers that are trying to work through large caseloads, that's probably going to be a big consideration for them. So I would really say I would wait and see. Yeah, unfortunately, the first-time filers, that's going to be a problem, right? Because for work authorization, there's already been guidelines put in place that, help people retain work authorization, even though their I-765 is still being adjudicated. And those L2 and the H4, they each have their own classification for that. So people with extensions, they're going to be in a better situation than people it's a first time. If it's a first time and you're looking at the complete unbundling, if you're applying for an H4, you're going to have to wait. And you're going to have to wait and look at those process times. That also being said, I wanted to sneak in at some point during this conversation that I did see that the Vermont Service Center has announced layoffs recently. So they're going to be laying off people, which is going to likely slow down processing even more. So I think that that's something to work into the calculus as well, how you explain to me that an organization that can continually raise fees has to lay people off, don't really understand. But, I don't understand their business model in the first place. But yeah, I would definitely say, to answer your question, if they do actually put the kibosh on the unbundling, first-time filers aren't going to be in a great situation, because they're going to be kind of going back to how things were, in the late 2000s to early 2020s, where you're looking at those, 5, 6, 7 month delays.
Right. Thank you so much for taking that up for Rag. And Rag, thank you for participating with your question. We would really love you to join us on call. Why not call us on this number, 425-436-6335, and the access code is 988888. And this goes out to all the viewers out there, including Ravi, Trisha, and Rag as well. So Justin, let's move on to my next question to you is, how does the modernization of the H-1B visa program redefine specialty occupations, and what does it mean for both employers and employees? You said this a little bit in the introduction, but if you could elaborate a little bit.
Yeah, so kind of, piggybacking off of the first my previous, statements, the expanding the definition so that you're not really nailing yourself to one specific degree type for any sort of position or field is fantastic. It's definitely a positive. So that should be helpful for employers because it's going to give them an easier roadmap to showing that a position is a specialty occupation. Our company normally requires a degree to do this, and these are the degree fields that are related. As long as there's a rational basis between the two, should be able to move forward without too much of an issue. So that's the good part for the petitioner. And the good part, I think, for the employee is it gives you a little more wiggle room in terms of what it is you're doing and how you can qualify for the H-1B. Because we also got to look at it from the prism of this. The components that USCIS is analyzing are supposed to be, is the position a specialty occupation, and does the individual have the requisite work experience or degree or combination required for the position. And so I think that helps the employee now, because you're not stuck with the idea that you just have to have a degree in, let's say, computer science in order to do an IT related job. Where I think that the modernization is problematic is in related to third-party placement for the specialty occupation definition. There is language included within this new guidance within the regulation that basically says if someone works at a third-party location, the third-party work location must be providing work that is in a specialty occupation. And as a result of this, the idea is that the third party's requirements for the position are most relevant in determining whether or not the position is a specialty occupation. So I can understand the logical conclusion from this, which would be, okay, yeah, if the person's working at Sears, Sears has to require a degree, in order for the person to do the job. Otherwise, it doesn't make sense that it's a specialty occupation. That's the logical thing. Here's the problem with that. Third-party placement requires you putting someone at a client location. That client is not bound by the same conditions as the petitioner in order to, service the employee. The reason why they have a contractor is they don't want to deal with having an employee. So the first issue becomes, is the client even going to furbish that information as part of the process for the petition? Like, let's say, for example, an H-1B employee is working at Apple and they move to Google. Well, part of that is you file, an amendment to move the person to Google or Apple or whatever. Is the manager of the project going to immediately issue a letter from the company on company letterhead saying, yeah, this is a position with our company that requires a bachelor's degree in XYZ, and turn that over? Or are they going to say, yeah, I'm not giving that right now. Get him over here and let's start him working on the project. So that kind of becomes, I think, the first problem is, I think this is a way to almost backdoor the reintroduction of requiring in-client letters, a practice that was definitely used ad nauseum by the Trump administration to deny cases, because let's work backwards from this. If you can't provide the in-client letter to show that the position requires a degree within a specific specialty, then they can deny your case saying they can't establish specialty occupation. So that's one issue that I look at and say, that could be problematic. Let's say you even do get the client letter and you provide it to them. USCIS is adjudicating the case and they look at it and say, well, this says it requires a position in X, but I used my favorite tool as an officer, Google, and I went on Google and I looked at the company and I looked at job postings for the company. And the job postings for the company online don't say that this position requires a degree in X. It just says it requires a degree. Well, now they're going to issue a request for evidence and say, well, we can't tell if they actually have a position that's required in this specific specialty. Then you're getting into a fight between them with, like, okay, just because you saw something online doesn't mean that it takes away from the evidence that we presented to you. All I'm saying in this is, what I don't like about that is you're opening up the door for evidence that has to now be provided that previously wasn't necessary, because it, in my opinion, is kind of outside of the scope of what should be asked for in terms of who makes the decision on whether or not this person's position qualifies. And that, I think, will probably lead to some bad adjudications. And unfortunately, we'll have to wait and see how that is dealt with, because you're going to have to look at what the officer's decision-making is. The benefit, obviously, is that they have to at least issue a request for evidence. But even so, that's not something that I saw that I was a big fan of. And I do think that it could be problematic for employers, any employer that's doing third-party placement.
Right, Justin. Thank you so much for covering that in detail. And you already covered, I think, half of my next question, where I was almost getting to, ask you to tell us about the main benefits, but also if you could highlight and also challenges you've already,
Yeah.
highlighted for us. Yeah.
Yeah.
So,
No problem. So some of the other things that I saw before, because I'm trying to be positive before I'm negative here. Some of the other things that I saw that were beneficial. The employment authorization expansion for people that is on what's called cap gap. So cap gap
yes.
is this idea that, if you're on an F1 and you're working and you get an H-1B approval and you file an H-1B change of status, the cap gap will allow you to remain in the United States and continue working legally up until the date where that person changes status. That's great. But before, cap gap ended on October 1st. So if you were someone who had a change of status that was filed but was not approved on October 1st, you lost your work authorization. You're able to remain in the United States because you have a timely filed change of status, but you can't work. The problem there becomes, if the company can't have you working, then why is the company going to keep you? And obviously there's things that you could say, well, why didn't you do premium? Maybe there's an RFE. All of this is to say it was an issue. which would lead to people basically front loading the adjudication of change of status cases for October 1st, because everyone knew that those people's cases had to be put at the front of the line. What has changed is they have now moved that cap gap authorization all the way to April 1st of the following
Of the
year.
next year. Mhm.
Yes. And that's a phenomenal benefit, because what it does is two things. It removes the stress from the employee in worrying about having work authorization, and it removes the stress from the service centers in having to front load their review of petitions that are change of status. Hopefully, at the end of the day, it provides a more streamlined process and less issues. Another thing that was really good is they are allowing you to change the start and end date as the reason for a denial if a case is denied and then subsequently approved. And I know you're thinking, okay, how is that much of a benefit? A motion to reopen takes forever. A motion to reconsider takes forever. An appeal. The benefit there is there have definitely been scenarios where someone ends up with a denial and then it's appealed. And then let's say it's on their cap exempt H-1B, their first H-1B where they've gone through the lottery. Well, if for whatever reason that case ends up getting reopened, it could, in theory, be denied if the end date had passed. So because of that, you had seen situations where perhaps USCIS had said, yeah, we made a mistake, we're going to reopen the case, but we can't approve it because the end date of the validity period that's been requested on the petition is passed. Now what they're saying is, instead of doing that, what we'll do is, if we reopen the case and the end date is passed, we're going to send you a request for evidence and basically tell you, give us a new LCA, give us your new start and end date, and we will honor it on this petition. So I think that's beneficial. It should be helpful. Will it help a lot of people? Probably not. It's probably going to help a very rare sliver of people. But for that sliver of people who the benefit is they, don't have to go through the lottery again. They have an approved H-1B and they can, file an extension and maybe get their perm sponsored. That's a huge deal for them. So I think that that's great too. The other thing that I thought was good was they expanded the definition of nonprofit. Basically, they changed it to say, instead of saying the primary reason of the entity must be research, it's now fundamentally a fundamental activity. So I think what the whole purpose of that was is they want to expand the scope of nonprofits being able to use H-1Bs. And obviously, if you're not aware, if you work on an H-1B at a nonprofit, if it's a cap exempt employer, that means that you can work there without having to go through the lottery. So that's beneficial. And I do think, from my reading, the goal is they do want to expand the ability for nonprofits to have access to these employees. Because the regulations itself, it actually says, we're not worried about people cheating the system, because we know that this is research is very competitive already. So the fact of the matter is they already want to hire the best and brightest. So let's give them the ability to do that. The last thing is the beneficiaries can be cap exempt even if they're not employed by a qualifying organization, as long as they spend half of their time providing essential work to support a fundamental objective of a qualifying organization. So what that means is, theoretically, you could be placed at a client location as long as it's a nonprofit organization and more than 50% of your work falls within that parameter, and be cap exempt. So I think all of that stuff's great. I think it's very positive, and I'm very hopeful that it will be used in the best way possible, and that there's no one trying to do anything untoward or fraudulent to, get within that nonprofit parameter. Just the real quick, the the entrepreneur stuff. I apologize. I feel like I'm running on time so fast. The entrepreneur stuff. Yeah. The fact that entrepreneurs can now, sponsor themselves for H-1Bs. That's a positive too. And that it's been established before, but now it's been clear cut. That's great. The bad stuff, bona fide employer. It seems like they've basically changed the definition of employer-employee relationship to bona fide employer. Under the guise of bona fide employer, they are attempting to reiterate the idea that contracts or similar evidence to confirm the position is bona fide are required. My reading of that is if you haven't already, be ready if you're a third-party company to be asked for contracts and work orders between everyone in the succession of contracts. So if you're going from petitioner to vendor to end client, they're going to say, give us everything in there. So will that stand? I'm not sure. We'll have to see, but that's not something I like. A random one, petitioner needs to be have a legal presence in the U.S. and be amenable to service of process. I think that's clearly coming off the basis of they want to try and hit employers for fraud. And in order to do that, they have to be able to go after them. So they want those people in the U.S. A thing that I didn't like about the beneficiary ownership, the initial approval can only be 18 months. And the first extension can only be 18 months as well. What that basically means is they want you to prove to them that this is legit, that this business is legitimate, probably that it's growing, bringing in revenue, bringing employees. I would say it would not shock me if we saw a lot of denials between the first approval and the first extension, meaning that first extension, I wonder what they're really going to look at to show that you qualify for the second 18-month extension. We'll have to see. Lastly, before we move on, we can talk about this in more detail later, but I know I am going over on time. The really bad aspect of this is the codifying of site visits and noncompliance. Before, site visits were they were not mandatory. They were, you could choose whether or not to participate in the site visit as part of the program. Allegedly, under this, they're now saying that you must comply with site visits, and failure to comply can actually lead to a denial of an active petition or a revocation of a prior petition. This is different than before, and it's going to have to change how everyone looks at things. But I'm going to come out and just tell you guys right now, because the language was in the regulation. The language within the regulation clearly states that based on their data, non-compliance rates were found to be higher for workers placed at off-site or third-party locations as compared to workers placed at a petitioner's on-site location. They have initially claimed that close to 19% of their investigations have yielded a fraud finding. And that's non-compliance. That's where people are able to opt out and not participate. Now that the participation is mandatory, coupled with their already stated conclusion that more fraud is committed at third-party placement, it will be open season on third-party placement. That's going to be a huge part of, I think, regardless of the administration change moving into next year. It will be a huge thing. So, as I've said before, and I'll say again here, you really need to make sure that you're ready for that and that your employees are ready for that. But yeah, that's pretty much it in terms of what everything is, as kind of an overview of what's good and what's bad. There's some other small stuff in there that I'll try to get to, but I think those are the big points to highlight of what will be beneficial and then what will be challenging.
Thank you so much, Justin. I mean, that was a detailed coverage, and I think very important points that you've highlighted. And folks out there, thank you so much. And if you have resonated, please let us know in the comment section. And also, you can join us on this conversation by dialing the number that's displayed on the screen. And so Justin, let's go on. And I have my next question, and that is, what are the conditions under which H-1B holders with controlling interest can qualify, and how does this impact their ability to start or lead businesses in the U.S.?
Right. So this is again one of those positive things. Essentially, they're saying that individuals who are beneficiary owners, and a beneficiary owner is someone that owns a controlling interest, which they have defined as more than 50% or a majority of voting rights, it's permissible for that individual to sponsor an H-1B for themselves. The purpose of this, as stated in the regulations, is they want to give entrepreneurs the opportunity to essentially open new businesses in the United States, because opening new businesses should lead to job growth, right? You open a business, you hire employees, that job growth helps the community. So that's their basis or point. What is interesting is, and they even admit in the regulation, is there's still a further need for guidance kind of on how you qualify for that specialty occupation as the owner of the company. I think there's language out there right now that says something along the lines of more than a certain amount of your duties, maybe it's 50%, qualify within that specialty occupation parameter. But what that might lead to is a bit of confusion over what kind of positions are and are not a specialty occupation. I mean, I think obviously if you're going to be running a company that has 10 or 15 employees, and you're doing high level, let's say IT work or healthcare work or something of that nature, you're probably going to be able to show that you require a specific degree. The things that might be more complicated are the more recent technological developments like artificial intelligence, things like that, where there's not as much prior guidance to show whether or not the person qualifies. So we might see pushback on that with RFEs, but I'm not super worried about it. At the end of the day, I definitely think it's beneficial. I think that it's great that this is done. And I think that it should lead to people, doing the sponsorship, being able to be on an H-1B while having the organization, while beginning to start up an organization, and it should be helpful. As I said before, my only caveat to it is only approved for 18 months, and the first extension is also only approved for 18 months. Most people know this. A lot of businesses fail. That's just how it is. You start a new business, you're not able to generate revenue, the business isn't going well, the business goes under, whatever. Only giving someone 18 months to then establish that the company should continue because it's experiencing growth or whatever. I am a bit hesitant as to what those adjudications are going to look like, because I don't know what it is that the service centers are going to think shows that the person qualifies for the extension. Now, let's look at deference. If we're still implementing the idea of deference, the original petition and everything's the same for the extension, should the extension be approved? The thing about it is, you can see by looking at the language that the reason why they have these short approval notices is they want to deal with fraud. They want to stop the idea of someone saying, I'm going to create a company for myself because really I just don't have a job available and I'm on an H-1B. So I'm going to start, Jay's Consulting Inc. and open the company and file. And now I'm going to be back on an H-1B. And once that time's done and I find another employer, I'm just going to file that, because that's not the underlying purpose of this. The purpose is to have people open legitimate businesses. So I think overall it's great. I think that people that fall into this category of controlling interest, the more than 50% of majority voting rights, they're going to be able to successfully get these H-1Bs. The thing I'm really interested in looking at, though, is what ends up being the approval rate of those initial extensions.
Absolutely. I think we all are looking forward, and I really hope that these changes are going to benefit most folks out there. And we also hear that people who are going to be paid more, like they're going to select people on wage levels, right? If they are going to be paid more, they're going to be selected first. Is it going to be like that, Justin?
So, here's the thing about when you're talking about the wage levels for the H-1Bs, there's this idea floating around about in the lottery kind of applying a weight to what a wage is going to be, saying if you're filing a position at level 3, then you get accorded more, weight than somebody whose position's at level 1. I haven't seen the actual implementation of that coming down the pipeline. I also think that it would be much harder to do because the way the system's set up now for the lottery is it's beneficiary centric. And what that means is you enter a person in, and no matter how many times you enter that person in, their number rate is 1. It's always 1. So 7 petitioners can sponsor for a person, but the person is the person for the rate of selection. It's just 1. How does that work if you then bring in a weighting system with the levels? Are you saying, okay, we've selected 1 who put the highest amount of money, and then you go to the person that has the highest amount of money? I'm not sure. And the other thing with that is what happens with actually making those changes within the system. Now, before, all you have to do now to register, very easy. You create a petitioner page, you enter the beneficiary's information, you sign, you pay the $10. Or actually, it's going to go up, right? So the amount's going to go up now. But you pay the amount. Now you're adding in a labor condition application. So now the LCA is going to have to be certified. You're going to have to know the position and where the person's going to be working. And remember, they can't start working for your company in this position until October 1st. So you're adding in a lot of calculus to a system that's already kind of rudimentary. And they've already come out and admit they've admitted that the way the system is now is working. They actually came out and said, we're not really trying to mess with this. It's worked. Registrations went down last year. So we think the underlying goal, which is to remove the fraud that was taking place, is gone. I'm not sure they would then subsequently go back and then tack on new issues. Now, where you could see wage levels as an issue is in their relation to qualifications for a specialty occupation. And what I mean by that is we saw a lot of in the previous Trump administration of it's the level 1 wage issue. Basically, the argument coming out saying, if it's an entry-level position, how is it a specialty occupation? How does it require a degree? And I think that's where you saw people basically start to say, we don't want to deal with that issue, so we're just going to put the wage up. We're going to go up to level 2 or up to level 3. And because we don't want to mess around with level 1 at all. Could I see that coming back in a big way? Absolutely. So I definitely think that that's probably going to be something where if you're a petitioner and you're filing a level 1 wage for someone on an extension, someone that's already been with your organization for 3 years, and you're saying they're still a level 1, they're going to stay there, that could be an issue for you. The other thing would definitely be, looking at someone who's in a position where they manage or supervise others, people that create things. If you're creating technologies, I don't know if you can be level 1 and create technologies, or they don't at least, and then you have to prove it to them. So that's where I think you'll probably see that come in more. And then who knows with the next administration, if they want to come out and figure out a system, devise a way to increase the wages further, then we'll have to wait and see if they do.
Okay. Thank you so much, Justin, for addressing that and for the detailed explanation. I think we should address some of the questions from our audience now. Rag is back with another question, so let's take that up first. Does USCIS still use Dun and Bradstreet data, and how imperative is it to update location details in DNB?
Yeah, I don't really know. I mean, it's probably a tool that they still can and may utilize. So I would say for those that do, continue to update it. Yeah, but it's not something that I have readily available off the top of my head. But I would just definitely say if it's something that you have been using already as a tool, just continue to use it, and expect if USCIS has used it with you previously that they will prospectively.
Okay. Now let's take up Amay's question. Hi, Amay. Thank you so much for joining us. Let's take it up. I am on H1B and working as a contractor. My spouse is on H4 EAD and she's working for another client as FTE. My current client has offered me the FTE role. If I switch to a new employer, will it impact my spouse's visa status? Please let me know.
Yeah, so generally speaking, no, it won't impact her. The F4 or the H4, the H4 is conditioned upon the maintenance of the primary status. What that means is the H1B holder, has to maintain their status, and by proxy of that, the H4 holder is able to show that they qualify as long as they meet the underlying guidelines, and that's if you're a spouse, marriage, that can be proven. So if you move to another employer and you're still maintaining your H1B, it shouldn't be an issue. There shouldn't be any problem with transferring. Now, here comes the issues associated with that, though. Just off the top of my head, when you move to when you move your H1B, you transfer to another employer. Your period of approval, your validity period, is going to change, right? Your validity period is no longer going to match your spouse's because your spouse's validity period was subject to your previous H1B. What that means is you have to be mindful of the fact that when her H4 is set to expire, she needs to file an extension, and it's going to be an extension that's probably well before your extension. So that's issue 1. Have I seen that be a problem? Absolutely. I have seen people who come to file their extensions that have moved to an employer, and that H4 has been invalid for 6 or 7 months. But they didn't think about it because they just thought, okay, the H1B transferred, we're fine. So that's one thing to think about. And also to think about as well, if you're filing that transfer, maybe just file an H4 with it as well for her, just so that you guys have those same validity periods for your approval notices. So that's one thing to consider. The other thing to consider is this. In very rare circumstances, so, I can't do an exact percentage, but very rare circumstances, I've seen where someone moves to another employer with a transfer, that the H-1B employer is going to withdraw the H-1, right? Because you're not working on it anymore. In very rare circumstances, I have seen that H-1 withdrawal trigger the H-4's withdrawal. And basically what happens is USCIS says, well, that H is no longer active, so the H-4 is no longer active. That's wrong from a policy perspective, but in a legal perspective, it's wrong. But here's the problem with that. You have no grounds to attack a withdrawal. If an H-4 is withdrawn, it's not like a denial. There's no appeal. There's no ability to reopen or reconsider. Withdrawal is withdrawal. It's gone. It's done. So you have somebody who's moved to another employer and started working, and then they or their lawyer receives a withdrawal for the H-4, and they're like, why did this happen? Well, now you're in a position where you have to file a nunc-pro-tunc H-4, basically saying you should forgive my time out of status because you guys screwed up. Is it going to get approved? Probably. Why wouldn't the government approve it? I mean, they're the ones that screwed up. Is it going to get approved? Great. But what about the problems associated with that? If your wife's working with an employer and she's no longer in H-4 status, is the employer going to come back and say, hey, you can't work with us, you're fired? So avoiding that issue is just, again, filing the H-1 and H-4 together and just filing it for peace of mind. Is it necessary 100%? No. Can you do it just to avoid those two scenarios? Yes.
Okay. There you go, Amay. Thank you so much, Justin, for taking them up. Amay, I hope you got your answer. Well, Rag is back with another one. When is FDNS visit done for L1H1, and is it on time or periodical? One time or periodical?
So, yeah, I will say, Raj, I'll answer your question, but I do want to say if we could get to Trisha's question as well, because she had asked one at the very beginning, I think that maybe we could get to that too and speak with her as well. But
yes,
okay,
so sorry, Trisha, for leaving you out and your
it's okay.
question out.
She got in at the very beginning, so I want to reward
Yes.
that participation.
Let's take it up. Yes. Our company
Okay.
heavily relies on H1B employees for specialized roles. So, if the program becomes stricter or more selective, how should we adapt our hiring practices to ensure compliance and still get the talent we need?
Yeah, so I mean, like I said before, I don't think that the way that they've changed specialty occupation, the definition is actually harmful. I think it's positive. I think it's beneficial. The way that I don't like it is obviously the notion that if you place someone at a third party, that third party has to make the determination that the position qualifies for specialty occupation rather than the actual employer. But that being said, I think regardless of that, you're still going to see an administration change where the new administration is going to come in and try to tighten guidelines, even if they've been changed. My thought process for that is this. I would probably, if I could do whatever I want, if I ran a company that hired H-1Bs and I wanted to ensure my continued ability to hire people in specialized positions, what I would probably do is make sure that your hiring practices are up to date with compliance for the definitions of specialty occupation. So what does that mean? Well, when you make positions publicly available, you post them, right? Most of the time when they're posted, you can access them on the internet through, LinkedIn or Glassdoor or anything like that. I would consider ensuring that those requirements for the position show that the position requires a degree in a myriad of fields, maybe going as far as to listing some of those fields. You could maybe tack something on like, this is not an exhaustive list of the position of the, fields that are acceptable, but are the position or the fields that most likely align with the position, something like that. Long story short, doing that kind of gives you the opportunity to say at the outset, like when we're hiring, we're only considering these kinds of degrees and people with degrees in this field, because that's what we know is needed for the position. So that's one thing I would do. In your hiring practices proactively, I mean, if you already hire people with degrees and you're continuing to do so, you should be fine, because one of the ways you can show evidence of specialty occupation is showing that similar individuals within your organization hold a degree in a specific specialty. If you're able to produce that evidence and show, look, I have 17 programmer analysts. All 17 of my programmer analysts have degrees that are logically related to the roles that they're performing. I'm hiring an 18th programmer analyst. Makes complete sense that, you're showing that requisite requirement. So I think those are ways that you can do that. And I mean, honestly, if you have the ability to do so, I would just start doing it now. You have a little bit of time and opportunity. to do that. So I would say prospectively try, and hopefully that aids you in the event that you're, filing in the future and you're having to deal with an RFE or a notice or whatever. Sorry, I dropped something.
No worries. But yeah, thank you so much for taking that up. And Trisha, thank you so much for your question. If you have more questions, you can keep commenting. Now, if we can, let's go on to some of our questions we have. But if you would like to take this by any chance.
Yeah,
from
absolutely. Raj, thank you for coming back, man. FDNS done for L1H1, is it one time or periodical? Mostly it's going to be one time. And I say mostly because unless they have a real reason or justification to make another visit, they're gonna try and empty the clip on the first one. So they're gonna want to try to go and procure as much information as they can in person, and they want to physically talk to you and get whatever information they can. The regulations are basically kind of saying when they talk to people now, they want to talk to the person, they want to talk to the person's manager. So already they're with these new regulations, they're saying, well, not only do we want to talk to you, we need to talk to your manager. And if you're at a third party site, that means we need to talk to the manager at the third party site as well. So right out of the gate, they're basically saying, you're not heading us off by just saying, just talk to me, or just talk to my attorney. They're going to say that these other parties need to be involved as well. Now, does that remove the ability of you to have an attorney handle the answers for you? No, it doesn't, because you can have representation. So I would still marry myself to the idea that if you are a party to a site visit and you are someone who employs peoples on H's and L's, you need to make sure they're trained, and you need to make sure they know what to say and that they want to move things first off to a platform where there's a record. Meaning, either you can do a call that's recorded or you can go on email, and that you want to have representation there. The reason why I say that is I have seen a decent amount this year of officers who have formed conclusions based on statements that the employees are saying they did not make, or they are based on statements that do not align with what they were intending to say. But you have to understand these FDNS officers, and I will say this until I am blue in the face, their goal is to find fraud. They want to find fraud. They're not coming to be your friend. They're not coming because they're just doing their job. They want to find fraud. The more fraud they find, the more they justify the existence of their job. So that is their purpose, to find fraud. And so the reason why I say, involve an attorney and get things on record is you want to make sure that everything has been properly done and all the information that's been provided is legitimate and related. I'll give you a perfect example right now. We just engaged with a company who was completely compliant with the site visit. They provided everything to the officer up front. They provided the additional documents that the officer had emailed them for the first time. And they even provided documents for another employee who was allegedly not related to this site visit at all. Just another person they threw in and said, hey, while we're here, give us this guy's docs, right? In no way related to the petition. They engaged us because the officer has now come back and asked them again for not only the information that they provided, not only the information in their statements, not only the information for the additional person. They now want a list of every employee in their company, every project that person's working at, the wage the person is making, the person's supervisor at the third-party work site on the form, on a detailed form, along with all of these people's approval notices and all of their labor condition applications. So why am I telling you this? The purpose I'm saying is this. If you don't push back against FDNS officers and say, okay, that's enough, I've given you everything that I need. Or if you don't at least know your rights to provide what is and isn't actually necessary, they will take everything. They will take everything available to them. And I'll tell you this, if they provided that information, those documents, they will turn around and subsequently investigate every person on that list. And you got to remember, the purpose of this FDNS site visit is supposed to be related to compliance with the petition at issue. So that's one person's petition in relation to one H-1B that has now been extrapolated to include every employee on a non-immigrant visa for the organization. And what I mean by that is not just your H's, your L's, and your F1s. The whole organization. And that's a company that was complying at a timeline where they don't have to comply. So imagine what that's going to look like next year when instead they're going to say, well, I'm going to threaten you with non-compliance and just deny your case.
There
So
you go,
yeah,
Rag. Thank you so much.
it should be one time, but what will not be one time are the amount of email correspondences that the officers will subsequently send you.
Mhm. There you go, Rag. You have your answer. Thank you so much, Justin. And we have a couple more questions from our, uh, on YouTube. So let's take that up. Control, if you could display, please. So this is from Harsh Bansal. This is asking, hi all. My wife's H-1B extension was approved last month, but we haven't received the original sorry, 797 approval notice. So her employer provided courtesy copy I-797C. Can we use courtesy copy for the Dropbox appointment in India? We need to travel urgently next month. Really appreciate the help.
Yes, you can. I think that the old school practitioners would say that you must carry the original copy with you. That's not necessarily the case anymore. You can use a copy both at your appointment and when entering through CBP. At the end of the day, we're in a digital world. All the information that they need is already accessible. You're not going to really be able to pull a fast one on them by presenting a copy that's somehow fraudulent or been marked in a way. So you're fine. If at worst, if you're asked about it, explain you never got the original, and you should be okay. You can always request another copy. Thank you, Raj. Happy holidays. You can always request a duplicate. You do have to file for it, and it does cost you money. But if you want peace of mind, you can do that. But at the end of the day, you can you're completely fine with using a copy. As I tell people often, the only place that I have dealt with pushback lately with originals is the DMV, the whatever department within the state that issues driver's license. For whatever reason, sometimes they push back and say you need the original.
Okay. Thank you so much for taking that up, Justin. Now let's go on to our next one. Control, if you can display our next question. How long does it take to get a receipt if I have filed an H-1B transfer in premium processing and new employer sent the FedEx on last Friday and it dispatched this Monday, still
Yeah.
like 5 days and they don't have a receipt number?
So this isn't completely surprising. As I said earlier, the Vermont Service Center is going through layoffs. Other service centers are going through layoffs as well. If you filed your case right now, it's the holidays. A lot of people are taking vacation time, which lowers the numbers of officers that are available. So yeah, I wouldn't be shocked if you haven't received the receipt yet. Here's the thing with premium. You get a digital courtesy copy that's going to go to the email address that was provided in the petition. So if you G28'd, then that's going to be the attorney. If you didn't use an attorney, it should go to whoever the signatory for the company is or whatever email address they put on there. So you should be getting something. 5 days is a little vague. I want to be clear. 5 business days matters. 5 days that includes a weekend, you don't count that. That's not part of the calculus. So remember that when you're thinking about this process. If you sent a case on Thursday and it got there I sent it last Friday. Sent FedEx on Friday and it got there on Monday. Oh, sorry. So you did answer. So it has been there for 5 days. So yeah, 5 days is pushing against a long time to not get a receipt notice, but it's not entirely surprising. I would maybe check and see if you did get a courtesy copy. If you don't have a courtesy copy yet, do this. I cannot stress enough. Easiest way to make sure your case was accepted or not if it's been a while. If you filed with checks, see if the checks have been run. If the checks have been run, you're good to go. It means USCIS has accepted your case. If you filed with a credit card, see if the credit card payment has come out. If it has come out, they've accepted your case. And so at least you have the peace of mind, even without the receipt number, you know that the case has been taken in. I had a case recently that I think it took me 6 or 7 business days to get a receipt. And what happened was the night before I got the receipt notice, I got the alert on my phone that the credit card fees had all come out. So that's how I was able to tell. So I would say look at that. Look at the checks and then or the credit card or whatever. If you get to day 8 and you have not had those checks come out, default thought is rejection.
Okay. Well, there you go. I think that's it for today. We should wrap up our show, right, Justin?
We
Since
can take that
you
last question if you want.
cool, so let's do that
If you
then.
don't mind.
Control.
If you want to get off, you can stop.
No, I was just worried if you're in a hurry. So H-1B visa refuse status. So my Dropbox appointment was on December 12th, 2024 in Chennai. The status changed to application received on December 12th. And on December 13th, it has been updated to refused. I'm yet to receive intimation on when I can collect my passport back, which will likely have the slip proving more details on the next steps. This is my third time stamping, not sure why it shows as refused. Any insights?
That's very interesting. That's a very interesting question. So I obviously tell you by the default, most times when the consulate takes your passport, they're going to approve it, even if they need to address additional information. So the fact that it changed to refused is obviously puzzling. What's more puzzling is that you haven't received any correspondence from them in relation to the visa refusal. That's very shocking. Most of the time, you're at least getting a 221G when you walk out of the consulate that gives you an email address or something to reach out to them. So what I would say is if you're trying to be proactive and do something, obviously we all know the consulates don't pick up phones and talk to anybody. That's never something they're going to do. Usually through a little bit of perusing, you can find their email address, right? Other people have gotten it in connection with 221Gs or whatever, and you should be able to find that email address that way. What I would recommend as your first step is emailing them and just giving a very basic explanation. I would honestly front load it with, you guys have my passport, So I think that I would start off with saying, you have my passport. I need my passport back if my visa is refused. And I also need an explanation as to why my visa was refused. They're obligated to provide you with that, and they're obligated to provide you back a copy of your passport. So I would do that, and then hopefully that works out. And then once you get the basis of the refusal, you can work backwards to see if you want to apply again or if you want to use LegalNet or whatever avenue. But yeah, step one is at least getting a copy of that doc. And that would be my starting point because nobody's going to answer you anyway. The other option you would have is if you have a representative, if you've already lived in the U.S. and had property in the U.S., if you have a congressional representative, you could try reaching out to them and explaining. They love to help, and the consulates are more responsive to them than they are to everyday people. So that would be my other option.
Cool. Thank you so much, Justin. And I think, folks out there, you can also consult with Attorney Justin Rivera, and you can contact him and his phone number and his email address. So his phone number is, if you could just put it on the screen, please, so that folks out there can note it down. Control. So the phone number where you can contact with Attorney Justin Rivera is 844-592-7336. Please note it down. It's there on the screen. And you can also email him support@walsden.law and go visit www.walsden.law to get to know more about Attorney Justin Rivera and, of course, Walsden Immigration Litigation. And also, please do not forget to check out Walsden Immigration Litigation on LinkedIn. And last but not the least, it's the holiday season, Justin, and I'm super excited. I'm sure you two are. So here's wishing you, your family, once again, a very Merry Christmas and, of course, happy holidays, and wishing you more love, abundance, and blessings this season.
Thank you very much. Merry Christmas to you and everybody that was on. I hope you all have a great holiday, and I will see you all next year.
For sure. Thank you so much, Justin. And thank you once again, for this very, very insightful session. And if you have anything more to add, before we say bye, you might as well.
Yeah, no, I'm going to get out of here. It was a pleasure. All right. I'll have a good one. Bye.
Thank you. Thank you so much. You have a good one too. Great day ahead. So folks out there, thank you so much for joining us today. It was great having you. Really lovely. And Rag says, thanks for this episode and happy holidays to you both. Happy holidays to you too, Rag. Thank you so much for joining, and stay with us. Watch out our space here on Immigration and Jobs Talk Show, because we keep having interesting discussions on different topics, all related to immigration and jobs. And also, we have another upcoming show coming up, Daily Immigration Dose, which we do with which I and my co-host hosted, and that's with Sam. So look out for it, 4 p.m. Eastern Time. And of course, please do not forget to like, share, and subscribe to our channel. You can also write to me, call me up, or WhatsApp me. And my phone number is 408-335-6444. You can email me at nipa@staffingly.com. So for now, this is it. Y'all out there have a great day ahead, and see you again here on Immigration and Jobs Talk Show.
Hi everyone, welcome to Immigration and Jobs Talk Show. I'm your host Rajni Bharara, and before I move ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our attorneys and guests, including comments and replies from users, is not legal advice. Use of information is at your own risk. Welcome back, everyone, to Immigration and Jobs Talk Show. Like I said, I'm your host, Rajni Bharara, and today we are here to discuss the latest trends and insights in immigration law and employment opportunities. Well, I'm thrilled to have you all join us with us today, and I want to again extend a heartfelt welcome to all of our viewers today. Thank you for joining us. Your interest in these important topics is what makes this show very, very special. So thank you again. And today we have a very special guest joining us, Erin Green, an esteemed immigration attorney and an H-1B visa expert. Erin brings over 20 years of corporate management experience, working with clients ranging from venture startups to large multinational corporations. He is the founder of EEG Immigration Law Group, where he provides exceptional legal services and strategic solutions for complex corporate immigration issues. Erin has a remarkable track record, having overseen thousands of immigration petitions for high-tech, defense, and biotech companies. He has served as the exclusive U.S. immigration advisor to the American Israeli Chamber of Commerce and has extensive relationships with Department of State officials representing corporate clients at the U.S. Embassy in Tel Aviv. In addition to his legal practice, Erin is a passionate educator, frequently delivering presentations on immigration processes and compliance to large audience across the country. His commitment to transparent service and dedication to his clients truly sets him apart in this field. Today, we'll be diving into an important topic, H-1B visas, current trends, fraud crackdowns, and what to expect next with none other than Erin Green. We'll explore the latest developments in H-1B visa sponsorship, discuss the recent crackdowns on fraud within the system, and look ahead to what applicants can expect in the upcoming year 2025. So without any further ado, let's welcome Erin Green to the show, everyone. Erin, welcome to Immigration and Jobs Talk Show. How are you doing?
Hey, good to be here. Doing good. Thank you.
Thank you so much. It's a pleasure having you on the show, Erin. Thank you for agreeing to be a part of the show. And guys, we have Erin's details displayed on screen in case you want to write it down. So you can write down his phone number, his email, and his website in case you want to get in touch with him. So make sure you do that. Now, Erin, without any further ado, I know we are here to talk about H-1B, but before I do that, I actually want to talk to you about, the pics of Trump's administration. I mean, the pics that Trump has had in past few days of in the last 1 month for his administration. So, Erin, how do you anticipate these appointments are going to influence immigration policy, and particularly regarding H-1B visa?
I think the new administration will be very strong on the border, on preventing the mass illegal waves of immigrants coming in. That's the focus. That's what he ran on. That's the people he's putting in place. Mr. Holman and all these others are going to be focused on that. What we have right now is a free, open border on our Mexican side where anyone can just walk in. I'm completely against the asylum scam that is going on and the ways that the last the current administration has ignored immigration law to levels that are just unexplainable. For those of you who don't know, asylum means you're in a country, but you have to get out, you have to flee, you're in fear of your life, the government's going to come and kill you or cause harm to you. And if you can get to the next closest country, you're supposed to file an asylum claim and be there until your case is heard. Unfortunately, while we do have a lot of poor people coming from these countries that just want to work, they do not qualify for asylum. And asylum was not created for someone who just happens to need a job or to be poor or maybe lower class. But what they've done the last 4 years, and even before that, they've allowed these folks to come in illegally using this asylum. It's a big scam, and the government's perpetrating it. So to get back to your point, I think most of the efforts will be on securing a border like every country needs, allowing people to come in legally, allowing real asylum claims to be heard, and hopefully not allowing millions and millions of these phony asylum claims to be perpetuated. With regard to the H-1B and the business community, I happen to think that Trump is a businessman. People working with him are looking to increase the economy. The economy has been down the last 4 years. We've had inflation. We've had a lot of problems. So on the business side, I expect things to get better, get smoother. Hopefully wait times will go down. And we'll see better processing and intakes of cases. And those are some of the things I'm looking forward to. There's a lot of fear mongering out there done by whether it's law firms or just particular political interests who always want to fear monger and hope for the worst. But we don't see any evidence of that. For what we see so far is a business friendly administration like we saw last time.
Okay. But Erin, a lot of people are also saying that it's not only going to, Trump and his administration are not only going to go after the legal ones, the illegal ones, but also it's going to be bad for the legal ones and strict scrutiny. And, basically, it's not going to be good, not just for the illegal ones, but also for the legal ones too. So what do you have to say about this? Do you think it's going to be hard or bad for the legal immigrants too?
I don't think so. I don't think. We've seen 4 years of this administration. In my firm, we processed hundreds, thousands of H-1Bs. Certainly, where they're stricter on, for example, third-party client-side cases, and then it goes back. We've seen trends where there's more RFEs, and then less RFEs, and then more RFEs, and then RFEs targeted. We see them coming in trends. But the trends don't really correlate with the administration that's in power. It doesn't matter. It seems like they're more internal, and they just seem to adjudicate in different ways in trends. So if you're talking about H-1B adjudications, it's hard to predict what the next trend will be. I mean, for example, I can tell you 20 years ago when we used to do L1s, L1As, and L1Bs, L1As would never get an RFE. They were so straightforward. for example, if you flash forward 12 to 15 years, you have them starting to RFE L1s as a trend, and L1As particularly. And so there's nothing correlating with the law or changes in law or changes in administration. It just seems to be internal trends that seem to come up and down, with what we see in our data. But I don't predict any stiff change where they're going to say, oh, we're not accepting H-1Bs. They can't do that. I don't see how they would do that or why they would do that. That would just harm the business community.
Okay. But do you expect any changes in the H-1B lottery process with the new administration?
So to give you a little bit about background about the H-1B lottery, as you know, before they went to this electronic system the last couple of years, they had just the lotteries where you prepared the entire case and you sent it in with your filing fees, which were a lot. Then they would do the lottery, and then they'd send the ones back that didn't have the paper, that didn't get accepted in the lottery. Then they went to an electronic system, which they forego all that paper being produced and sent in and all that mail, which is smart. However, it kind of opened up the door a little bit for easier methods of fraud. But I don't know if you're going to ask me about fraud, but before we get to that, I don't see it. And are you asking about how the process has changed this year's particularly from the years prior?
No, yeah.
Well, okay. So let's talk about the fraud, for example. So when they announced that they were going to electronic, I said in my head, I said it right away. It just popped in my head. I said, this is going to be a catalyst, and we're going to see hundreds and hundreds of thousands of more applications. Not necessarily because the economy is better or they're needed, but because it's going to be easier to do fraud. Because think about it. When fraudsters come together and they put these ploys in just to get H-1B approvals or lottery applications, the law is that you can't. So if you have a related company, you can't submit multiple applications for the same H-1B applicant. But if the companies are not related, you can do that. When they went to an electronic, now, of course, there was fraud existing before. Companies could do that, and they were willing to submit these huge applications with all the fees. And I guess if they got more than one applicant accepted, they would lose a little bit on the fees, right? When you go to an electronic system and you don't have to send any fees in, you're just entering names and maybe their birth dates and passports, etc. Then you have less overhead. The fraud scams have less overhead in terms of having to put all those fees up front. So what happened is they got a little bit smart, and I predicted it. If to get around the law, if you think about it legally, if let's say 20 people came together and opened 20 different companies, okay? But none of those people were related or had any other ownership interest or relationship with any of the other 20 companies, right? So you have 20 different companies. However, now let's say they have 100 people and they want to get them H-1Bs, right? So let's say each one of those 20 companies enters those 100 people into the system, and they could do that because technically they're not related, although it is technically a fraud scheme because let's say they're colluding to do that. That's where it can become so much easier to perpetuate fraud with the new electronic system. But now we see a lot of crackdowns going on, so they're getting a lot smarter. I think this year what they've done differently is they're starting to, they're asking for the passport number of the individuals now. So this year what they've done is they're looking at the individual. So if they're accepted, supposedly they're not accepting them again. If that makes sense, if that same individual has, and they announced that in their bulletin in January, and they've done that supposedly. So that's one way that they're cutting back on the fraud schemes. And then the other way is they're doing a lot more investigations into the filers when they see that.
Right.
For example, I have a company now, and we were doing an H-1B, and then we got an RFE or a NOID, a notice of intent to deny, which is similar to an RFE. And it talked about the past filing from the CAP, which I've never seen one of those before. And it was talking about, so the person we were filing for our company, but they had been accepted in the CAP for another company. And they were looking into the companies and asking questions about the companies prior. So you can see that they're on to these companies now who are doing that, which is a good thing, which will make it more fair for everyone who needs H-1Bs.
Okay. So hopefully it's going to be all good for the H-1Bs at least, and also for the immigrants.
Yeah, I think so. The only changes for next year, I think, is they're going to probably implement instead of $10 to enter someone, I think it's going to be 200. And they wanted to do it this year, but at the last minute, they decided to keep the $10 fee in place. So it'll be a little bit more. I think it'll be 200 per person you want to register, which is interesting. But other than that, I don't know if they're going to change much from this year's fiscal year cap to next year. We don't have the announcements yet, but they usually start announcing them around this time, and then in January they start coming out with announcements and changes if they want to make any. But I can tell you, 780,000 caps last year was not a result of the economy. It was, I mean, if you look at versus the previous years, it's several 100,000 more. It's that was because it was easier, and I predicted it. It was easier because you don't have to file all the. And they've gotten smarter in how they're doing it and set up these fake phony H-1B. We used to call them job shops when I worked at Infosys. And they're out there. They crack down on them, but they're out there. I can explain what that is if you want, or we can move on.
Yeah, please go ahead. We would like to know more about it. Yeah.
So when you're looking at an H-1B, a job shop, so technical staffing companies like yourself can have legitimate jobs and legitimate clients. And the requirement is technically that you're supposed to have a bona fide offer of employment for the employee that you're submitting the H-1B for. What the job shops do, and your H-1B employees or applicants or people who want to get H-1Bs have to be very wary of them, is they come along and they try and they say they can get you H-1Bs. They don't really have jobs lined up that are ready to go, bona fide job offers. They just try, and some of the other things they do is they try to take money from the employees. So anybody out there who's looking to get an H-1B, be very wary of these job shops. What they're doing is they're making a profit by trying to get H-1B lottery numbers in high volume and then utilizing those by placing people in the U.S. after the fact. Whereas a legitimate staffing company or a legitimate IT consulting company will obviously have clients and have jobs ready and available and file based on those jobs. And even when they're entering the lottery, should have that those jobs in place. There's a little bit of a difference there, you can see.
Okay. But hopefully now that Trump is going to be back with this strict administration, it's going to, if not completely go away, at least it's going to be slowed down, right?
I really don't know. In terms of enforcement and investigations and audits, I mean, even during the Trump administration, we saw times when there were more audits and more and less audits. For example, FDNS audits are random site visits, which they do on H-1Bs and L-1s, where they're supposed to come to the office or the place of work. A lot of the officers are lazy and they'll just email you. But so I can tell you, the last 4 years we hadn't seen a lot of them. I've seen very, very few. I just even got one recently. But so I can tell you, just within the last 4 years, there was like virtually none, and then maybe now lately a little bit of ramping up. But it's very sporadic. So it's hard to say that just because this administration comes in, there's going to be more FDNS visits and we're going to do a lot of them or. But in any case, a legitimate H-1B should not be worried about an FDNS site visit. They're very straightforward. They want some documentation. We did tons of those when I worked at Infosys. And so it's not something that should alarm anyone. And even if you get an FDNS site visit, they're looking just to make sure that what's in the application matches what's on the ground. That's basically all they are.
Okay. Thank you for answering the question, Erin. Now, I would also like to know about, because in Trump's last administration, this Buy American, Hire American was his initiative, right? So how do you foresee this policy actually being reinforced or maybe altered in this new term, especially, concerning H-1B visa holders?
Yeah. So the argument, the H-1B argument on are H-1Bs good for America and the economy versus are H-1Bs taking American jobs has been going on for a long time now. At least the debate back and forth.
Mhm.
I can probably argue both sides. But more likely, for starters, let's look at it this way. We have the most IT jobs in the world here. I think that's a fact. Statistically, anyone will know that. We have universities and our Americans who go to study, and they don't really go into the computer engineering or these IT fields. A lot of the STEM fields, they're very weak on that.
Mhm.
We have such a high demand, and those jobs are here and plentiful, and they need to be filled by foreign workers, for example, H-1Bs, whether they're studying here or whether they're coming abroad to work. So the argument is that the American kids just simply don't go into this field. And I think there's a lot of statistics to back that up. I don't have them on me, but I've lectured about this and I've talked about this in different places. So there's a great need for IT workers specifically. And when you're talking about H-1Bs, as you know, the vast majority of H-1Bs are IT fields and certainly STEM fields. So you can make the argument that this is a much needed, our economy it needs these workers to come in, these H-1Bs to come in and do this work.
Mhm.
The flip side is sometimes what happens is these companies, whether it's, Wipro or Tata or Infosys,
Mhm.
they come in and they do an efficient job. They have clients who have, at least in the past, have had their own legacy IT departments. And what happens sometimes is that these vendors will come in, these companies, and do a great job. They'll hire them and they'll completely replace the IT department. So let's say there were 200 Americans working there, or mostly Americans, and then you bring in someone like a Wipro or a Capgemini or an Infosys. They come in and they just basically take over the whole function for the company. And this is where you can see a lot of American workers being laid off, and then it becomes a political issue, and then it gets into the press. And even though it might not be that many workers at the end of the day, it could be a whole IT department of a company, a major company. Sometimes they're replaced or rehauled. And then you can see the political drama that unfolds. Well, here you can see people are talking about losing their jobs or, having to train the replacements in many of the situations. And I've seen that. I would tend to think that if there is a robust IT hiring here where there's just so many jobs that if those folks are really talented, they will find jobs, number one. But I can see the argument where you have specific cases, and they're more emotional cases because they're more like one-on-ones, but you can get a lot of sense of when a whole IT department is replaced and the new folks coming in, they had to transfer knowledge. I can see that argument. So I can see both sides, but I really tend to think that if those folks were really talented folks or needed, that they could find jobs when those kinds of, changes happen.
Right. So now everything will boil down to the talent and the skill that the person possesses.
Yeah. Now, as far as Trump, he's business friendly. I mean, he's coming in to make the economy grow again, and we want to be the best in the world. I think he knows and he realizes, and I have seen interviews with him in the past, from the last time, where he's acknowledging that fact about the H-1B. So when you read all these articles coming out about, Trump's going to do and Trump's going to do, a lot of it is fear mongering. A lot of these people just don't like Trump because that's the fashionable thing to do on one side of our country. But you got to read it and look if there's any facts to it. And yes, definitely on the border with the illegals, I think that will be a boost. That will be a boost to business immigration because you need law and order. I mean, I have clients waiting years and years. I have all my clients, none of them want to overstay their I-94. None of them want to do anything, even remotely illegal or looking illegal or something that could get them in trouble. And these are the folks that need the services of the USCIS, which is, you're talking about wait times for EAD cards and people have to come off payroll. I mean, these are people too, and they've come here legally. They've paid thousands of dollars. Their companies have filed the right way.
Right.
And they've taken the back seat to allowing millions and millions of people to come in for what purpose. So that's my opinion on it.
But Erin, do you really believe that it has now become fashionable or cool to say that we are anti-government, especially anti-Trump? We don't believe in his policies or what he says, even though everything that he has said or done has always favored the country.
Well, when I'm talking about, well, if we're going to talk politics now,
No,
when-
let's just take immigration. I mean, because mostly that whatever policies or actions that he has taken so that so that illegal immigrants cannot get in, and so that the borders are the border policy is strict, so that illegals can't get into the country. But then people don't really favor that idea also, and say that he has always been against immigrants. So what do you have to say about that?
well, his whole platform is that he wants people to come in legally. He wants people to respect the laws of our country. And if you can utilize those laws to come in, then you should. He doesn't want there, and there should be borders, and there should be places where you enter, and there shouldn't be, drug cartels running in. People leave the crime and the drugs alone. There shouldn't be drug cartels organizing people to come in illegally and finding loopholes because there's no boundaries or no wall or this or that. I mean, no country in the world would ever put up with this. So when he's talking about that, he's not talking about, well, we shouldn't also allow legal immigrants because they're bad. He's never said that. And so the perception that will flow over into business immigration is just completely false. And there's 4 years of evidence of that. And when I try to argue with some of my immigration colleagues who are very, let's just say, anti-Trump or pro-open borders, as I call it, I say, well, why don't you point to something in 4 years, which he's done? And then they talk about, if you remember during COVID, when they kind of shut down visa processing in a lot of embassies. Well, that was shut down because of COVID. I mean, and that slowed the entire world for traveling. And I come back and I tell them, that's not a good example, because that was a few months, yes, and it was hard maybe to get an H-1B visa, and maybe a few people got stuck abroad here and there. But that was really due to the disease, the COVID that was killing people. And yes, movement was stopped everywhere by every country. So if you want to argue this, I'll argue with any immigration lawyer who wants to come on here and tell me that these asylum cases are actually legitimate and can show me how. But they won't, because they don't have the facts on their side, and as usual. But anyway, not to get into the other side of immigration. We're here for business immigration, and I don't see the fear. People who are reading all these articles, you just read them with a grain of salt. That's what I'm saying, because nobody knows what's going to happen. Number one, and number two, if you look at the track record, those 4 years, the L's and H's, which is mostly what your audience is interested in, not killed or hampered, or there may have been delays here and there, but that was due to COVID. So just be careful when the fear mongering starts, because the new administration's coming in and one side has simply lost the election. So just be careful. That's all I'm saying.
All right. Thank you so much for that insightful answer, Erin. And a lot of people have joined us and have also posted their questions. So we are definitely going to take their questions. Or maybe let's just start with Hosam's question. So Hosam said he has posted this on YouTube, and he says, I'm a medical laboratory scientist certified ASCP. How can I apply with you?
With me. So as you know, most, whether it's a green card or simply, petitions, O1s, and you need a sponsor company. So if this person is a scientist and he's working in the U, or I guess he's not in the US, I don't know. I always tell him, like, I don't find job. I guess that's your job, but we're a law firm. Our clients are companies, and we can certainly file, extraordinary ability or outstanding researcher green cards. There's an O1 category if he meets that. But like I say, most folks outside the US who really don't know much about how the process works, maybe they didn't go to school here. Really, you need to find that company that wants to hire you. You have to look either in your home country, or here, find your field, apply to jobs online. And then at some point, when someone is interested in you and your services, the question will come up if they need sponsorship. That's where I come in. So
Right.
we're not, I can't, I'm not going to find jobs for people. We're a law firm. I think you do that. If you're a staffing
Uh-huh.
company, that's probably what you would do. But yeah, after they have a job and they're like, okay, now how do I get the person into the US? We want to hire them. Then they come talk to me and we strategize and we find what solution they can have, you know, to work in the US legally. I think that's the person's probably outside the US, I guess.
Right. So, Hosa, maybe you can write to me. My email is rajni@staffingly.com. And yes, maybe you can share your profile with us. If we have anything else, anything for you, we are definitely going to get in touch. But thank you so much for your question. If you have a follow-up or a question for Erin, make sure that you post it in the comments below. Meanwhile, let me quickly take Kavya's question, which she has posted on LinkedIn. So Kavya says, Erin, she says, can we expect more jobs for students with H-1B sponsorship? Currently, companies are not ready to take students because they need H-1B sponsorship. Is there an increase in H-1B sponsorship of IT jobs for immigrants?
Okay, so it's hard. Okay, so look, when you're talking about, are there going to be more H-1B opportunities? Are there going to be less H-1B opportunities? That usually goes with the economy. I think now that we're going to have a business savvy administration coming in, we saw the last few years companies like Amazon and Meta, which was Facebook, we saw them lay off. I can tell you, Meta laid off like over 22,000 employees, or one of them in like a 2-year period. Large layoffs, and yes, a lot of them affected H-1Bs. They were in STEM fields, they were in IT fields. I can tell you, we had some of my companies. They were calling me like, hey, we got a new person we're hiring. We got a new person. And they seem to all be coming from Meta. So in terms of answering the overall question, it's hard to say, well, there's going to be more companies are going to want more H-1Bs or less. Companies want talent, and they have roles and jobs they need to fill them. They don't care if they're H-1Bs or non-H-1Bs. Now, I can tell you this. If companies are hiring H-1Bs, it's because they really need the talent and it's there. If you think about it, to hire someone who needs sponsorship is going to cost them in terms of lawyers and fees and all the headaches and potential green cards and perm filings and all those fees. If you look at it from a comparison basis, it's going to cost them a lot more, obviously. So if they're willing to spend that, it tells you, and it goes back to the first question you asked me, if they're willing to spend that, they don't have someone equally talented or even right there who's going to cost them $20,000, $30,000, $40,000 less in the long run, which goes to show you that the vast need, and I think it's only going to grow. We can see a lot of movement. I don't know if anyone's out there is doing AI, but a lot of those companies are coming up. And then the traditional companies like, the big FANG like Google and all of them, they're still hiring. Their numbers will fluctuate. I think there's going to be more opportunity, but it's hard to say, it all depends on what you're doing and what field you're in. And then, the market is still good for students, for foreign students coming out and then, sending in resumes and being hired based on their talents. Yeah.
Right. So, Kavya, I hope you have got your answer. Thank you so much for your question. If you have a follow-up, please continue posting your follow-up. We are here with Erin for some time. We'll be taking your follow-ups too. So right now we have questions from Rag, then RK, Ankit Goel, Lokesh. So many questions are here. Guys, I'm definitely going to take your questions and ask it from Erin. But before I do that, Erin, I would also like to know from you that what factors do you believe have contributed to, the decline in H-1B visa approvals in 2024?
The decline in approvals. Well, I can tell you, so are you looking at statistics where you have the top 10 visa filers and like Amazon went down a few thousand? Is that what you're talking about?
Yeah, Amazon and then Google and so many companies actually went,
So if the question is USCIS getting any more stingy or harder to approve? That's not the situation. I will go back to individual company hiring and the economy. When the economy is slow and these companies aren't making what they do, they tend to lay off. So that's probably what happened there. I don't know internally at like Amazon. I don't think they would say, well, we're just going to lay off. Although there are companies who do take a policy I've seen lately where they might say we're not hiring those who need sponsorship. I mean, obviously you can't discriminate, But for business necessity, you can ask that question when you're recruiting people. Will you need sponsorship? So that might be a trend, but I think it's more the economy has been bad. And we're in the last year or two, we're seeing ramifications of some of these big companies just wanting to lay off and making cuts and maybe not hiring as much until they can get back, until the economy can start rolling like it did, prior to the last several years.
Okay, so it has nothing to do with USCIS's strict approach, or nothing to do with the government or the law?
No, I file H-1Bs every day. They're very straightforward. Yes, you'll get an RFE. Sometimes you'll get an RFE when it's not warranted, but there's not. I would say it's even easier to get an H-1B approved now than it has been. If you think about third-party client sites, they've completely, in the past, I can remember getting massive RFEs on the third party. Oh, where are they working? They're not working at the company. And they've stopped doing that for the last several years. So we don't see those RFEs anymore. If you got a U.S. degree, they're not going to question the specialized knowledge. Yeah, they'll throw. Those are usually boilerplate RFEs, and you get those, and they're unfortunate, and they create a little bit of a delay and more cost. But right now, I don't see a huge uptick in those. I can tell you, I have seen months in the past where there's so many H-1Bs, or a particular year where they're going, but it really doesn't correlate with changes of administration from what I've seen in my experience.
Okay. Thank you so much for answering the question, Erin. Let me again move to our viewers' questions, because we are getting quite a lot of them. So let me take maybe RK's question. So RK says, just like the perm process, if you have major layoffs, you can't file new perm. That should be the case. If you do major layoffs, your site should not be eligible, get H-1B for the fiscal year. H-1B is a great program, should help add workers, not substitute. If a company has 10 American workers and apply for 5 H-1B at the end of the year, that should have 15 workers, not 10, or worst 8. I don't think so there's a question, but this is what he says.
I think he's trying to say that he doesn't want H-1Bs to replace American workers. I mean, I have a lot of clients. I've worked with big companies, small companies. I don't think these recruiters, and I deal with them a lot, I don't think the recruiters are trying to say, let's get this person because we don't want the American, number one. And then he'll make the argument, well, maybe the H-1Bs will work for less, so they're cheaper in the recruitment. I mean, we know about that when we're recruiting. Maybe we can get them cheaper. It's hard to qualify that. I just think if they need more, they're going to hire more workers, and they're going to hire them where they can get them and as fast as they can get them to get them in there. If a company's growing and the IT needs are growing and the AI is growing and all that stuff, then they need them. They're going to find it's a market out there. These recruiters are cutthroat. I mean, and then if you're coming out of school and you have a skill, like lately I saw, like maybe 4 or 5 years ago when AI started to become popular and all those AI jobs. I mean, I remember some of these students would come out and my client would be like, we got to offer them this and the perm and the green card. We got to give them everything, because these kids come out of school, they got 3-4 offers. I mean, they got companies after them for these skills. It's amazing. So yeah, I would have to counsel my client and be like, I mean, I'm doing your immigration, but yeah, I can see the talent pool. These guys with these niche talents, guys and girls with niche talents, they're so sought after that you're gonna have to offer them the perm quicker. Some of the companies would start their perm right away, right at even they're doing their EAD and they're on their OPT and they start it right away. So yeah, I just think it's economics basically. Are there cases out there where companies won't think they can fire Americans and hire cheaper labor? Probably it exists, but I think the overall mass numbers are because these jobs are there and these companies need them and they'll get them from wherever they can.
Okay. Thank you so much again, Erin. Let me take, Rizwan is here. Rizwan says, hi. Hi, Rizwan. Please post your question if you have any. And then Dezaljin, I hope I'm taking your name right. I'm sorry if I'm not. He says, hello, everyone. Please post your question in the comments below. And now let me take Rak's question. So here, Rak says, will L1A for a tech non RFE? What do you have to say?
You broke up there. Let me see if I can read that question. Will L1 tech nonprofit face extra scrutiny or even an RFE? L1A for a tech nonprofit. So there's really no difference whether you're filing for an L1A for a nonprofit or a profit. The issue with scrutiny will come whether the company can support the salary of the L1 worker, and is there a structure in place where the L1A will be overseeing professionals or supervisors. So the scrutiny is across the board for L1A. It doesn't matter whether you're a nonprofit or not. That's what they look at. And yes, L1As have been harder over the past 10 or 15 years. They used to be just a piece of cake. You didn't hardly have to file anything. Now, when we do an L1A application, we put in org charts and emails of the manager actually overseeing people, really the nuts and bolts evidence to try to avoid the RFE. When I used to do L1A petitions, there were like 2-3 pages. Now my support letter has gotten to 15 to 25 pages. And I'm trying to avoid the RFE for my client is what I'm trying to do. So I'm trying to get everything in there, as much evidence as I can. So you can just see the trends. And, L1B has been traditionally the hardest, application to be approved of all the work visas. And those you really have to put together a very strong L1B argument. It's evolved over the past 20 years from, like I say, maybe 2-3 pages and a little bit of explanation to 15, 20, 25 pages and exhibits like this. So there's been a big evolution in the L1 field, even though there's been really no changes to any L1 restrictions or laws or adjudications or obviously numbers, because there's no limit or lottery on L1s. So it's interesting.
Mm-hmm. Okay, so Rak, I hope you have got your answer. Thank you so much for your question. Please continue posting your follow-ups. Sita is also here. Sita says hi. Hi, Sita. I hope you're doing well. Please post your questions in the comments below so that we can take it and ask it from Erin. Meanwhile, let me take Ree's question. Reese has posted this on LinkedIn. Reese says, so if most companies are laying off, why do we need to import labor? Does the law have some throttle for economic slowdown?
If most companies are laying off, why do we need to import labor? Mm-hmm. Well, we talked about 2 big companies that had big layoffs in the press. And yes, other companies do lay off from time to time. I'm not sure if most companies are laying off right now. I don't know if that's the fact. But assuming that is the fact, if most companies are laying off, and I guess you're talking about H-1B fields, IT workers and STEM workers, mm-hmm. Do we need to import labor? Probably not. And that might be the reason why Amazon's or H-1Bs went down 3,000 in 1 year, or some of the other companies in the top 10, their numbers went down. That's probably the answer, is they weren't importing labor or sponsoring a lot of H-1Bs. So you might have answered your own question right there. Does the law have some throttle for economic slowdown? I don't know. What do you mean by throttle?
Reese, if you can please, write your question in detail. What do you mean by this? Because I was also trying to figure out what actually this question meant. So maybe if you can explain us what you actually want to know from Erin. Meanwhile, let me take Rizwan's question. So Rizwan says, hi, I moved from Pakistan to the USA 3 months ago. I am a front-end developer and I have applied for lots of jobs but not received job. Please, any job or intern. Okay, well, again, he says this is about a job opportunity, which I don't think we should be talking about here. Rizwan, how about you send me an email on my email ID, which is rajni@staffingly.com. Reach out to me there and I can help you with something if we have an opportunity for you. Okay, so Rak says people manager L1A has better success than functional manager.
Okay, where's the question? Okay, yeah. People manager, regular L1A has better success than functional manager. I would agree with that. Mm-hmm. We do functional manager, but functional manager L1A are much harder to prove. you have to really show that the function of the company that the person is managing has some intrinsic value or worth. So, for example, let's say it's a project you're managing. When we do those, and we don't do them a lot because, as he says, they are much harder. But let's say we have to do that because there's simply no management of people in the traditional sense. We would show that project, we would show the financial figures, number one, from that project versus, let's say, what the company's income revenue is. We really have to build a case and show them, yes, they're managing, but it's functional and how intrinsically valuable this is to the company. And you can do that with numbers. You can do that with revenue. You can do that with letters. If it's a project management situation where they're managing that project or that function for the company, it can be a project, then you want to bring in additional evidence, maybe letters from the client showing the longevity and the importance of the project to the company, how that project, without that project, the company wouldn't exist, or things like that. But yes, they are very hard to do. He's right. The functional manager is very highly scrutinized. That's not to say that the L1As are not scrutinized as well, but it's just a functional manager. You have to really put in the worth of the function that they're overseeing or managing.
Okay, so Raj, thank you so much for that comment. And Ankit is also here. Ankit says, my company is filing multiple H-1B petitions for different candidates, including me. How does USCIS determine if a company is trying to game the lottery system? Could my application be impacted even if I'm not involved in any wrongdoing?
So if he's describing a situation where an unscrupulous company is somehow filing multiple H-1Bs illegally for the same person, yes, you could be impacted because even if it's approved, they're doing investigations and they can come back and revoke the H-1B at a later point in time, which means you're going to lose your H-1B, even if you're not even working for that company anymore. An example I gave at the beginning of the show was one of my clients. They're working for this company, but now they're challenging how they were picked in the lottery, and was that legal and was that correct? And that's something new. So that's interesting to see. And it's good that they've got people who are looking at this, and they maybe have a better electronic system in place where they can kind of, look at the data and see who's filing for who. And that's why they're asking for your passport number. Because they can easily see how many applications were filed for. Maybe 150 applications were filed for one person. They could see that. And that's where they're going to start looking. So that's good for them in their investigative process.
Right. So, this reminds me of a question that actually I prepared for you, Erin. So I want to also know from you, how can applicants actually ensure that their job offers are legitimate and not at a risk of being categorized as fraudulent?
Yeah, that's a good question. Research the company who's offering you a job. See who they are, number one. I guess if you're in India, and there's a lot of companies in India, and some of them are legitimate companies and some of them are not, right? And I guess that's the situation we have here. Some red flags are they're requiring you to pay for your H-1B. You're not supposed to be paying for your own H-1B, number one. So that's a red flag. If you're the company and they're like, hey, yeah, we're going to get you an H-1B. We just need you to pay for it, or we need you to forward us some money here. Be wary of that, number one. Number two, ask questions. Where am I going to be working? Where's the job? That should be in place. A lot of times, obviously, the employee is not going to see the contract between their employer and maybe, the client, but try to ask questions around what you're going to be doing, where you're going to be, where's the physical location of the job. If you're an employee and they're filing, you're entitled to see the LCA, although that will come later after you've already decided to go with that company. But your H-1B employees are entitled to a copy of their LCA. They can see everything that's been submitted for them. You should also have a copy of the I-129, which tells the government, here's the job, where it's going to be, what the person's going to be doing, here's the salary. All of that stuff's in the application. So if you're an H-1B, if you're looking to become an H-1B, just research the company, look for some of these red flags, and don't pay money to a company in India who says, yeah, I can get you an H-1B, just we need $500 up front or something. So look for those red flags.
Right, right. But Erin, do you believe that stricter penalties for fraud will deter companies from questionable practices, or do you think that can happen?
Yeah, I mean, if they're starting to crack down on them and they can actually get these companies and prosecute them, yes, certainly stopping them from filing H-1Bs. The problem is, these companies they morph. They're one set, and then they find them and they stop them, and then they open up new companies, right? So if they're in the business, if they're in the criminal business of job shopping, they might not even be in the U.S. They can certainly prosecute the ones that are in the U.S. easily, and they have. There's been some cases, you've probably read about them. But if they're overseas and there's a lot of players involved and they're savvy, they simply open up another company tomorrow and they repeat the process, right? But yeah, hopefully they will have more efforts to be able to locate these, and then they prey on the cap lottery. This is their big money maker, right? Every year. So hopefully with all the it's gone electronic, but with all the data that they want, they can do a better job of pinpointing who the lawbreakers are and who are the actual legitimate H-1B filers.
Right, right. So now with upcoming changes under under Trump's administration, what adjustment should applicants anticipate regarding H-1B visa policies?
Okay, like we discussed before, I don't think there's going to be a negative impact to companies filing H-1Bs, adjudications of H-1Bs. I hope it gets better. Just this past year, we have fees on H-1Bs and Ls and other business immigration visas that we've never seen before, called the asylum fee. I don't even know how this is constitutional, because these companies are filing these petitions and they're paying now an additional asylum fee on top of all the other fees we have to pay for the illegal asylum scam program that's going on the border. Now, why that floats into business immigration, I don't know, but you can see there's something that hopefully they will do away with. I don't understand why businesses have to pay an asylum fee for a program that is just overwhelmed and in my opinion is a scam. So hopefully that will go away. That will make things a lot easier for small companies who are already paying exorbitant fees, and now they got to pay an extra $300, and even bigger companies who have to pay $600 for every application, on top of the ACWI fee, the fraud fee, the I-129 fee, and all these other great fees that we have. When I started practicing immigration law, I was in Israel at the time. This must have been around 2000 or 1999. The fee for an H-1B was $85. There were no other fees.
Wow.
Now I file a fee for my client. They're looking at almost $5,000, not including premium, for one H-1B. $85, $5,000 premium. I remember when they started the premium program, it was an extra $1,000 or even less, I think. That's gone up every year. Now it's $2,800 to add premium to your case. Lovely. And USCIS takes in so much money in fees. Just USCIS, if you think about it, if it was run properly, they could make massive profits for the government. But apparently they don't, because now they got to add more asylum fees onto it. So they're not making profits, and the wait times and the client service, in my opinion, in 20 years I've been doing this, has gone like this. Now you can't even talk to. A year and a half ago, I could at least get someone on the phone. Now they've gone to all these things where you got to email them. They've gone to the lockbox. The lockboxes are just a nightmare. Now they have vendor companies coming in and intaking all the mail before it even gets to USCIS. And I can tell you the folks doing that are not the best, let's just say. And these lockboxes are sending cases back at a rate I've never seen in over 20 years. We're getting cases back for the stupidest reasons, for little things here and there. It's just very frustrating what's going on right now. And I'm hoping with all of these efficient people that he's hired to look at USCIS and efficiently clean that up, because that could be a moneymaker with these fees as high as they are. You could be efficient and make money and bring back the client service that we used to have, which wasn't 100% the best, but at least it was some good client service where you could, they make mistakes and clients pay a lot of money. So when you make a mistake and clients pay money, you need to have some client service that can help efficiently. So hopefully that will change for the better as well.
Okay. Well, let's hope that. Thank you so much for answering the question. Erin, RK is back, and this time he says, do you think it would be a good idea to make it that 70% of the H-1B must be granted to individuals like F1 students who have already invested, lived, worked inside the US?
It's interesting. It's an interesting. First of all, as you know, F1 students, if they're in the STEM field, they're going to have 3 H-1B lotteries to make it. Now, most of them do. I do have some. We have some that go 1, 2, and 3, and unfortunately, they get unlucky. So I can see that. I don't know if that would be a solution. Maybe something for F1s where after their STEM OPT was finished, and they could show that they applied for 2 or 3 lotteries and didn't get it. Maybe they could get some kind of extension. That could be a good idea. And then they could keep applying for the lottery. Maybe that could be. When you focus on 70%, that might not be fair to other companies who rely on H-1Bs who maybe don't have a lot of F1s. So I have both types of companies as clients. But yeah, there's a lot of things they can do. They've talked about in the past, making it. You could also say, well, some of these big companies, they get thousands and thousands, and you might be a little company and you only need 1 or 2 H-1Bs. Is that really fair that they're depositing 3,000 or 10,000 H-1B lotteries and you're depositing 3? And maybe all the ones who are small companies should get all those filled before all the big file. Well, that would hurt the big filers. There's been a lot of different proposals on how to make it. They had it they proposed maybe H-1B should go first to the highest salaried applicants. The problem there is now you're going to kill small businesses. Microsoft's and Google's, that'd be great for them because their salaries tend to be very high. But now you're killing the other side of the H-1B filer. So I don't like that. There's a lot of proposals to make it more fair. Right now, as we stand, it's traditionally anywhere from 33 to 40% chance of you making an H-1B lot, closer to 40 if you're a master's. If you have a U.S. master's, probably closer to 32 or 33% if you don't have U.S. master's. So those are pretty much the numbers. Now, I can remember one year a few years ago where we didn't have a lottery. I mean, they didn't fill the numbers. That was when the economy was really bad, if you recall. And the H-1B went on. I mean, when I started doing immigration, there was no lottery. Of course, there were 300,000 H-1Bs a year, and they went on year round. So we just filed them whenever they came up. Yes, this lottery system is interesting, but I guess it has to be there because the demand is so high. How else could you have a fair way of intaking them? But I mean, there's a lot of different ideas out there. I don't know what the best one is. It would have to be really thought through and fair to different kinds of H-1B filers.
Right. I mean, people can come up with their ideas, but ultimately it will depend upon the government, what they come up with and what they decide to do, right? So thank you so much.
Yeah, F1 students are a big part of, they're already here, number one, and they tend to be very talented in terms of these niche IT fields, even more so than your run-of-the-mill, let's say, H-1B worker at one of the big Indian companies. You know what I mean? These folks are very highly specialized. They're already here. Culturally, they're very attractive. They've already blended in. There's a lot of advantages to them. So maybe they should look at something to help the F1 students a little bit more. The STEM OPT is great. We haven't had that forever. That was new a couple of years ago that came in. Maybe an extension of that, but yeah.
Okay, so actually Lokesh also wants your advice. He says, I have been with my current employer on H-1B for 3 years, but I received a better offer from another company. With the current climate of fraud crackdowns, how likely is that my transfer petition might face extra scrutiny? What can I do to avoid any delays or rejections?
Okay, so H-1B transfer, or what we call H-1B portability cases, is exactly here. You're working and you have a great job offer and you want to jump ship. You want to move to the new company. So first of all, the first thing to note is that your current employer will not see the new H-1B application. They have no way to see that. So your current employer will never know that you talked to a new company or that even the new company filed an H-1B for you. So as long as you're staying with your current employer and don't tell them anything, you really don't have any jeopardy of losing your current job. That's why a lot of the we do a lot of H-1B ports. When the H-1B workers are porting, they always want premium because they want to have the H-1B approval in their hand. So first of all, H-1B ports can start working when the application is filed. They don't have to wait for the approval, which is great. However, a situation like this, where you already have a good job and you got another good job, is going to file an H-1B for you. This guy wants premium so that he can have the approval notice before he says anything to this job. I understand. It's a sense of security because you could start working with the other employee based on the approval, based on the filing, and then something can go wrong in that application. Now you screwed yourself, and you're going to be really screwed. So yeah. So if the new employer could file in premium, that might be good for you. That way you don't even have to involve your current employer until you have a new approval notice, and then you can move. That's usually what's been going on. That's what we see most of the time. My client gets a new one. They're like, yeah, but they want premium. And then the client's like, well, I don't want to spend $3,000 if I don't have to. They can start working with me now. I'm like, yeah, but a lot of these port H-1Bs will not start with you until they have that a little bit of the security of knowing they have that approval notice.
Right. Okay,
now, if you're talking about, go ahead, sorry.
No, please go ahead.
If you're talking about fraud crackdowns based on what's going on with the lotteries, that can come and hit you. If you were involved in a lottery with an unscrupulous company and you feel that maybe they were doing something, they were one of these, what I call job shoppers, then you got to be careful. That could come back and hit you at any time. That's out of your control. You're not going to know what investigations are going to be done against a company that you had an H-1B with 2 years ago, and then they're going to bust them, and now they're going to revoke every single H-1B they had. And then, yes, you could be affected by that. So.
Yeah, right. So thank you so much for that advice and for that answer, Erin. Lokesh, I hope. And Erin, we also have questions which are posted by the viewer on a Facebook group. So if you allow, I would like to share my screen.
Yeah, sure.
If it's possible.
I can run over. I have time. Share. I can answer questions. That's fine if you want to go a little longer. Yeah, I can hear you.
Okay. Thank you so much. Okay, I would like to share my screen. Okay. So this is one group where people have posted questions regarding H-1B. So this anonymous member says, because of long waiting time of NIW, this is, I think, an EB1. Maybe let's take H-1B related question. Okay, Kaushik has posted this 14 minutes ago, and he says, hi all, if you valid visa until April 2025 and have renewed H-1B petition till April 2028, you are good to enter US with the existing visa along with renewed petition without restamping with new petition, right?
As long as the visa is valid, unexpired visa, correct. So let's say I work for company A, I have a visa for 3 years. I port to company B, I got an approval notice, and now I want to travel. With the new approval notice of company B, you can use the visa from company A as long as it's valid. In my example, it's valid for 3 years. Yes, you can keep using that visa to go in and out, even though you're not working for company A anymore, but you must have the approval notice for company B to show them every time you enter, if you don't want to get a new visa stamp.
Okay.
But the visa always has to be valid. You can't come in on an expired visa. That's one thing you cannot do.
Right. Okay.
Kaushik, I hope you have got your answer. Let me quickly read. So actually, we've been continuously getting questions on this group. Please respond fast. I have doubt. I have Dropbox appointment today. My pay stubs have old pay and company didn't mention my new salary in employment verification letter. And in Dropbox, they won't ask my revised offer letter, but I have it. How will they know about my new salary? What should I need to do?
If you've already submitted everything in the Dropbox, there's nothing you can do. They're going to send, you've already submitted your passport. They'll send it back to you with the new visa. If they have a problem, they'll let you know. Getting increased salary is not a big deal. In fact, if you're an H-1B in the U.S. and you've gotten a huge jump in salary, we don't file H-1B amendments for that.
Okay.
So I don't panic. This person's panicking too much.
Right. So maybe they need to calm down a bit.
Yeah.
It happens because you have just applied for the visa, so that's fine. This anonymous member says, can I get stamping to passport, which will be expired in 7 months? Once stamped, I can get passport renewed and can fly to US from India with all new passport and valid stamping.
Yes. If you have let's say you got an H-1B visa, but then the passport expires, but the visa is still good, you get your new passport, you travel with both passports, and he will look at the visa in the old passport, and you can travel like that. Correct.
Okay. So, okay, this person says, hi guys, I worked with DXE Technologies in India, which was an HP enterprise back then. Now I skill set. Okay, no, this is not related to. Hello, please assist me in understanding the table. Okay, this is again a table. Okay, this person says, I got NOIR, H-1B after USCIS site visit. Any idea how long will it take for USCIS to take final decision? Employer replied for the notice.
So the NO notice of intent to revoke was received, and the employer already responded to them. And that was outside a regular filing. I guess or was it a premium case that was filed?
Not much details I hear,
Well,
but this
I mean, if
it
it was
says H-1B after USCIS site visit.
after a site visit, okay.
Yeah.
It's hard to say. Those can sit for a long time. I guess there's no premium in play here. So if they've responded, it's hard. It could be all over the map. It could be a couple months. I don't know. We've had those that have pended for a long time, and we were like, wow. I mean, the good news is you're still working and you don't have to leave or anything. So
Okay.
It's hard for me to get. Timelines are the hardest questions I have for my clients, because you can look online and see time frames, and those are usually not really good. And then someone's asking you, well, when am I, it's not premium. When am I going to get my case? We can look at trends, but it's hard to really give really good pinpointed timelines of when you will, outside of premium, of when you'll get cases back. It's tough. That's a very frustrating part of it.
Okay. So, all right. Thank you so much for answering these questions, Erin. I think we have had a great show with you. We did try to cover a lot of questions, though still a lot of them are pending, but we still try to cover a lot in today's episode. So thank you so much for being here. And to our lovely audience, I would like to say that if you would like to get in touch with Erin, please give him a call on the number I would like to display on screen, or maybe I would like to request a control to display on screen.
Yeah, 469-459-1771. That's the office. You can reach me.
Right. So please give Erin a call on the number if you're trying to get in touch with him. His number is 469-459-1771. I would like to repeat it, 469-459-1771. You can also email him. His email ID is erin@eeglawgroup.com. And you can also visit his website, which is www.eeglawgroup.com. Yes, you wanted to add something to it, Erin. Please go ahead.
I was just going to say, if you're calling me, I can give you advice and help you. But if you're really looking for a job and you don't have an employer, we're a law firm. You need to, find some recruiting companies. After you have an employer in place and maybe a job offer, and you need assistance or you have questions, I can answer those questions. But I can't. Sometimes we get questions where they're just looking for a job, and it's we're not in that business. So
if you're looking for a job, guys, you can get in touch with me. My email is rajni@staffingly.com. And if you're looking for any looking for help related to your immigration related case, so for that, please get in touch with Erin. We have already displayed his information and also have read the information for you so that you can note it down. So make sure that you get in touch
with Erin as soon as possible. And thank you so much for joining us today. Erin, thank you so much for being here. It was lovely having you. Maybe we can have you for another episode so that we can cover more questions in that show. But thank you so much for being here again today.
No problem. Good talking to you. Thanks for having me. Good to be here.
Thank you so much. And guys, thank you so much for your questions. Please continue posting them, because whenever Erin is going to be back, we are going to take those questions in that episode, or maybe we can directly ask him by writing an email to him asking for the answer. So we are going to reply to your questions in the comments below. So you make sure that you continue posting your questions in the comments below. But for now, that's it from my side. I'll have to take your leave for now. I'll be seeing you again tomorrow. But for now, thank you. Keep watching and keep subscribing to Immigration and Jobs Talk Show. Bye for now.
Hello and welcome to today's episode of Immigration and Jobs Talk Show. I'm your host Sam and I'm back again with a very exciting episode that is lined up for you today. So before diving into today's topic and announcing the name of our very special guest, here's a very important disclaimer. That is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So use of information is at your own risk. So, folks, once again, welcome back to Immigration and Jobs Talk Show. I'm your host, Sam. And today we are diving into a very critical and timely discussion. That is, how will the Trump's administration impact EB2 NIW, EB1A, and asylum applications? So, as we all know, folks, that immigration policies have been a very significant, we have seen a very significant changes in recent years, and also understanding how these changes affect highly skilled workers, individuals of extraordinary ability, and those seeking asylum is more important than ever. So, to explain and clear all your doubts and to guide you on the right path, we have an expert with us today. Please join me in welcoming attorney Amin Yacoub, an expert in immigration law with an impressive track record, with a strong background in litigation. And before his current role at Bogan Months and Months, Mr. Yacoub ran his own solo practice, helping clients navigate complex immigration and litigation challenges. As an EB2 exceptional ability and NIW immigrant himself, Amin understands firsthand the complexities of the immigration process. His personal experience drives his passion for delivering top notch legal representation to his clients, ensuring not only quality but also efficiency. With a nearly 99% approval rate in securing EB2 NIW and EB1 visas for his clients, Mr. Yacoub is a true leader in the field. So, first of all, welcome to Immigration and Jobs Talk Show, and it's an honor to have a show with you. How are you doing?
Good, and thank you for the kind introduction. It's a pleasure to be here.
Absolutely, and it's an honor, to have a show with you, and we are really grateful that you are here with us. So thank you so much for joining us. And also, I would like to ask that, before diving into today's topic and going to talk about today's episode, I would like to know that were you expecting Trump to be back in White House?
Yes, I did actually. I would say I did expect him to be back when Musk especially joined forces with Trump, because Musk hasn't failed yet in any of his endeavors. So it meant a lot when he joined forces. And he was like giving $1 million a day to people and stuff like that. So it's just I felt like he's going to come back to office to correct the economy as well. So people are feeling it here in the US and feel like they need to have a better economy. And that is usually the number one drive for the presidential election in the US.
All right. So, I would also like to ask that how do you think that under Trump's era, how do you see the future of US? Do you think it will be a new era or a nightmare for US?
Yeah, I think we've seen Trump before. So it's not like we're just exploring a new candidate here. So we've seen him from 2017 up to 2021. And it was, 2016 up to 2020. And it was not a bad year at all. Was the economy went up and everything was, in terms of immigration, nothing actually changed during his era. I would say Americans were, at least according to polls, were feeling satisfied with the economy. Were feeling satisfied with the low mortgage rates, interest rates, and everyone had kind of a chance in applying for jobs and having employment in Trump's era. But of course, people blame the COVID-19 2020 on what happened during Biden's administration. But my point is, it's just the last period that we actually witnessed Trump doing work as a president of the US. He was not as bad as the media might actually show. And it's all like a political fight in the US. Media is trying to show a picture of Trump. He's like anti-immigration and anti people who are willing to actually help the US be a better country. And that's not true. And that's why I'm interested in talking about immigration under Trump, because it's a completely unpopular opinion if compared to whatever is going on the media or whatever is going on the newspapers. So that's how you. So the other party here is the Democratic Party. Everyone tries to influence the public somehow so that they vote for them, so that they actually get them to the seats of power. So we just have to be neutral and watch closely and wisely in order to see what is true and what's not true.
Absolutely. And also, as you mentioned, that media has portrayed Trump in a little different way. And we can see that, even when Trump was serving food to in McD, then also that, that social media post just spread like fire. And it was also giving a different opinion that he's serving because he wants vote, or there was some kind of other opinion, that people were portraying in a different, actually in a little negative way. And
Yeah,
on the other side, if we look upon the Democrats, then I would say that for Democrats, the media was a bit lenient. They were more supportive, right?
yeah,
So
yeah.
I think that's why. But also, I would like to know from your side that can you be a little specific about that why Trump won in this election? Instead of, as media plays a huge role, and what media was portraying that what people believe, but out of that also, people supported Trump and made him choose him the leader. So can you please go ahead and share the reasons behind it?
Yeah, so you're asking about my personal reasons why Trump is coming back, not the objective reasons here, or
That's
not.
okay, you can give your reason.
Yeah. So again, Trump is a businessman. He has more knowledge about the economy and how it works. And we have seen, so that's kind of objective and subjective at the same time. We've seen Trump before doing his job as a president from 2017 up to 2021. And we have seen the vice president, Kamala Harris, doing her job as a vice president from 2021 up until now. So when we compare both candidates, we basically see two people who are not new people to us. They have been in power, they have been doing things, so we can just observe and see, was the economy better under the first or the second one? Was every aspect? So what was immigration better and faster for under the first presidential candidate or under the second vice president who's currently still in office? And by doing that, just a simple analysis to me, it seems kind of obvious that we can see that actually Trump, even asylum, nobody would actually wonder that. It's like asylum was much faster under Trump, and I'm talking about affirmative asylum. So that's an immigration issue, and of course, this is one of the biggest portions of the policy of Trump. So he's not anti-immigration; he's anti-illegal immigration. So what he wants to do is to vet people coming in so that he focuses all the efforts, all the efficiency of USCIS on legal immigrants and basically move things faster. In 2017 up to 2021, what we usually had happen was they actually accepted people in asylum in 5-6 months. They scheduled an interview in 5-6 months. Now an interview would be scheduled in 6 years. So we are seeing a completely different era in immigration under Biden's administration. And everyone is so panicking about Trump. Everyone is so panicking about Trump and immigration. Again, because of the media here. So that's why, I feel like it's important to actually show what is true and what's not. And my opinion, may convince you or not, but I'm relying on data here, and I'm relying on statistics as well. Approval rates of EB2 and AW and EB1A under Trump's administration and under Biden's administration. So hopefully that will be useful, and hopefully that will actually make immigrants relax a little bit when they think about applying for EB2 and AW or EB1A under Trump, not under Biden, because everyone is so panicking right now. And I want to say, do not panic. This is not going to be worse. I think it's going to be much better actually for you.
Wow, that's great. I think this is really insightful, and this conversation, I'm loving it from my side. And also, I mean, before delving into the questions that we have prepared for today's topic, there's one more question that's intriguing in my mind. Do you think, as Trump says, that there will be a mass deportation from the very first day that he'll be joining the office in 2025? So, do you think that that will happen, because there are millions of people and practically that's not possible? So,
Yeah.
what's your call on that?
So is it possible? Yes, it is possible. Is it practically possible? Possible? I don't think so. He tried to do the same thing in the first year he actually took office in 2017, and he couldn't. And when he's saying mass deportation, again, we have to be very specific about what kind of population he's actually trying to deport. So anyone who has legal papers is not subject to this mass deportation. But anyone who has entered the country without any legal papers, without a visa, and they entered through the borders and they came to the US unvetted, probably he will do his best to deport these people. Now there is a status in between, which is people would actually come through the borders and try to obtain a legal status. So the question becomes, what happens to those in between people? So they would be in a safer condition than those who actually came to the US and remained without papers. And you would be surprised. We actually have many unvetted people coming through the borders. And I don't think that's wrong to actually, make a legal move regarding undocumented immigrants or people who have never respected a rule in the immigration law. I think that happens normally in all countries around the world. So no country actually allows anyone to come in. You have to have a visa. So it's not like something out of the ordinary here. But if you do have papers, no one is going to be able to touch you, because you have to be before a court, which we call a procedural due process, before an administration, whether Trump or anyone else, actually has any decision over you or deporting you. So if he decided to deport someone with legal papers, let's say a CO8 pending asylum status, then he would actually advise USCIS to refer them or defer them to court. And once they're referred to the immigration court, then they would have what we call a day at the court. So they can represent themselves, they can have an attorney, and if they won the case, they're going to be remaining here in the US legally. If they lost the case, then they will be deported back to their home countries. So that's important to clear some, again, complexities regarding the mass deportation and the media, hyperbole statements that's like, just people are leaving, people are going to be, Trump is going to basically take people, arrest them, and remove them from the U.S., all immigrants. So generalization is not accurate here. And it's important to distinguish between all these strata of people and immigrants in the U.S.
All right, that's great. So thank you so much, Amin, for explaining that and taking that question up. Now I would like to shift our topic, shift our eyes on this topic, that how will the Trump administration impact EB2, NIW, EB1A, and asylum applications? So, I mean, my first question to you is that how might the Trump administration focus on merit-based immigration affect the adjudication process for EB2 NIW and EB1A applications?
Yeah, so that's one of the most important questions that we actually get on a daily basis right now. So how would he impact those kind of policies? So first, we have to distinguish between what he can do and what he cannot do. So as a president, he is having very specific authorities that he actually allowed to do. So, for example, we have the matter of Banasar right now, which is the landmark decision behind the EB2 national interest waiver. Is he allowed or is he authorized under law to basically reverse a court decision? That's a no here. So the answer is no. Is he allowed to change immigration law, the INA Act of 1990, which actually put forward the national interest waiver, the EB2, and most employment-based immigration visas? The answer is no, because Congress has the authority to actually put it, reverse it or change it, amend it with a majority of votes, which is very, very difficult to do because we have, again, even if we have right now a Republican Congress, we still have people who are believing in the immigration under Republicans and under Democrats. So people would be rejecting any kind of change or radical change, I would say, to the INA Act itself, which has been existing since 1990. So what kind of impact would Trump be able to do to immigration would be direct impact. So even though he has control over the borders, he can actually advise Homeland Security to not allow people in. He doesn't have much control over USCIS except as directive opinion. So he would be giving a directive statement to USCIS saying, well, please try your best to do better when it comes to evaluating the national interest waiver or whatever. And my idea, again, would be that he would actually broaden the scope, not as people think, that he would actually make it exclusive to scholars or scientists. And I believe so because he even suggested to give a green card to everyone who's graduating college from the US. So what we're seeing right now is Trump is probably pro legal immigration for the talented, for the people who are actually making a difference to the US. And people who are making a difference would be called, the EB2 NIW applicants and EB1A extraordinary ability applicants. So probably I would actually expect some broadness, and that is going to be broadening this kind of categories. And I'm not the only one who thinks so. I'm not the only immigration attorney who thinks so. So people who are versed in the field actually agree with me. I believe he is going to be giving directives to USCIS to accept more applications under EB2 NIW and EB1A if really the person is going to be making a difference. And that question remains a question to be answered in the case itself, in the petition and the exhibits. So whether a person is going to be making a difference or not is basically proved in a case, which is usually like 200 up to 400, 600 pages of documentation. So it's a completely objective um, way of evaluating what Trump is about to do here regarding the EB2 and IW and EB1E applications. And I think they're going to be much better than right now, even though we do have a direction from Biden's administration when he took office to try to grant as many EB2 and IWs to people who are working on AI, for example. But from the statistics posted by USCIS, what we're seeing is a drop in the acceptance rate down to 65%. So that direction didn't help much, which shows the nature of the direction. It's not binding. It's just suggestive to the president.
Much, Amin, for your answer. And also, I would like to ask and being a little specific about what specific changes to evidentiary requirements for EB2 and IW petitions can we expect under a Trump's administration based on past policies?
Yeah, so that takes us back to the matter of Dinosaur. So the matter of Dinosaur, as a landmark case, actually places all the evidentiary requirements that are required for EB20W, uh, and basically, if we complied with the case law, which is matter of Dinosaur, and the INA Act, we complete the case correctly. So there is no say of a president here. It's all legal work. It's all decided by a court. We cannot bypass a court. President cannot bypass a court. The court itself may revisit the decision if it wants, but at the moment, it has been existing since 2016. The matter of Dinosaur. Before then, we had a case called New York State Department of Transportation. So we have multiple case law that basically a body of case law precedents that actually put forward the evidentiary requirements for EB2 and IW petitions. We never rely on what the president says or what the president did not say. We rely on case law, we rely on the law itself for regulations, and we have to comply, us and USCIS officers. If a USCIS officer might be subjective somehow, he or she might actually make a decision that is not relying on the regulations. And in that situation, the correct action is usually an appeal. Or a motion to reopen, of course. So it's just a matter of complying with regulations. I do not believe.
Um, Amin, can you hear us? I think due to some reason he might got disconnected. But there's no problem, friends. Still you can continue posting your questions, and we are definitely going to take them for an hour as Amin Yacoub is with us for an hour. So till the time Amin will come back, we will try to have him back again with this episode. But you don't go anywhere. We'll be coming back with another short break. So don't forget to join us here. We'll be right back.
Yeah, I don't know what happened, but I'm back now.
No, no worries, no worries. I mean, not to worry anything about it. So, yeah, I was saying, everyone, that Amin will be back again with a very insightful discussion as we were going on. So, Amin, please go ahead and continue with your insightful information. We would love to
Yeah.
hear that.
What? So where did it go off so that I can continue from where I stopped?
That's okay. You can give a brief about it.
Okay.
Yeah.
So I think the last question was, would Trump be able to actually influence the? Okay, now I see. So
Yeah.
what specific changes to evidentiary requirements for EB2 and AW petitions? Uh, Again, I said briefly, based on past policies, he only can give directions, but for specifically EB2 and AW applications and EB1E. For EB2 and AW applications, we have to rely on the matter of Donasar, which is produced by a court. So only a court can revisit that landmark case. No one else can actually change it. A president cannot interfere with the court decision and produce another decision. So that's regarding the evidentiary requirements for EB2 and IW, and also the regulations in place. They're actually an extract from the INA Act, which was passed in 1990. Again, it's not expected from the president under the Constitution to have the authority, which he doesn't have, obviously, to actually change something in the INA Act itself by direct will. So if that needs to change, the Congress has to change it. Now, what remains is the EB1A, which is not a part of the question, but I can cover it. EB1A is also placed by the INA Act. So again, Congress will have to change the law for us to actually change the evidentiary requirements. Now, what the USCIS officers might actually have from Trump's side is, please broaden your interpretation of the law a little bit, or narrow it. And I believe what we're going to be seeing, according to what he said multiple times regarding legal immigration, and that he is pro-legal immigration, and also because now we would have Elon Musk, who's an immigrant himself in his administration. We will be seeing broadening of that interpretation of those evidentiary requirements that are put forward by the law itself, the INA Act, and the matter of Donasar court decision.
Amin, I would like to ask from you that you are saying that we are going to see a broader aspect. We will be seeing more opportunities, for EB1 or for everyone. So I would like to know it from you that how can you explain it in a bit that how we can see a broader opportunities, because most of the time we are seeing that Trump is trying to implement this and trying to reduce or making the immigration process a little lengthy. Yeah.
Yeah. So now I will use some data, but I don't think I can share the screen here, but it's accessible. You can just type in Google USCIS statistics based on EB2 and AW. So you're going to find the graph going up in 2017, 2018, 2019 of the number of petitions, EB2 and AW petitions, and EB2 and AW approvals.
I'm so sorry to interrupt, but if you want to share your screen, you can also do that. Or you want us to share, then you can share the link in this private chat and we can share it from our side.
Yeah, okay, sure. Just give me
Yeah.
1 second.
Yeah, sure.
So here's the link.
Yeah,
this is just one statistics, but we have multiple statistics as well.
Mm-hmm.
We can go through this one and
yeah, I think control, if you could please show this data. Yeah, I think we
yeah, can I control it? Can you scroll down a little bit? So yes, zoom in. So we have here 2017 as well was up. If we looked at here, it's going to be 2017, 2018, 2019 under Trump. And then 2020 was the COVID. And then 2021, Biden's administration. And then 2023, we're still in Biden's administration. Now we're going to see that the blue line, which is the receipt, EB2 NIW, or EB2 category in general receipts, is still going up, but the green line, which reflects the approvals, is starting to go down under Biden's administration of 2023. In 2024, it went down even below. So what we're seeing here, except of course in 2020, which is an exception, is a rise in the petitions and a rise in approvals under Trump in 2018 and 2019, and in 2017 as well, based on another statistics. And if we can you go down a little bit? I want to show you something else. Yeah, next page, please. The one below this. The one below this. Yes, here. So here we're looking at the O1 petitions, for example, STEM and non-STEM related. So they kept going forward and upwards since Trump, again, had a hiccup in 2021, went bad a little bit, and then it went up again. So O1 is not as influenced as EB2 NIW and EB1A because they're non-immigrant visas. So we're not going to be seeing the same difference on E2s, O1s, and L1s as we're going to be seeing a difference on EB2 NIW and EB1A because they allow people to get green cards, basically. Can you go to the next page, please? Next page. Yes, here. So here we actually see approval rates. If you could zoom in a little bit, it's towards the right end of the table. So 2018, that was under Trump, that was 97%. In 2019, that was 97%. That's for EB2 in general, but it's included. The NIW is included in there. You would actually see the petitions included in all of this. In 2020, we have a high percentage rate, but then it dropped down towards the end of the table to in 2023 down to 90%. Again, that's including the EB2 petitions that are sponsored by an employer, not only the national interest waiver. And that was published by USAS. It's not like something that I drafted for this live stream. So if we just took a look at the data, we're not going to be finding a source that would actually collaborate the statement that Trump's era was bad for EB2NIW and EB1A, especially. Maybe it was a little bit stricter when it comes to the H-1Bs, which I agree with, but it's not the same for EB2NIW and EB1A. And I do not believe there is any reason to actually think that Trump's coming back would actually make things worse, because they haven't. So why would I be convinced that Trump would actually come and say, well, let's change it to 40%? So why didn't he do the same thing in the past administration if he wanted to do it? So it's kind of unconvincing to me. And based on what I said, again, the court has to change its decision. And I don't believe that's going to be happening anytime soon. Congress has to change the law. And I don't think that will be happening anytime soon either.
All right. I think that's great and that's very well explained. And thank you so much, Amin, for the data also, because that's pretty much very clear from our side also. And we can see the stats. So with this, we can have a clear picture about it. So again, thank you so much, Amin, for that. And meanwhile, I would also like to, greet our viewers, Ram, Jitendra, and Maisha. I mean, these are lovely viewers who has joined us for today's episode. So I think welcome to everyone. And here we have a question from our viewer from LinkedIn. That is, at the moment, how long average time to process EB1A and EB2 NIW?
Yeah, so regular processing usually takes 8 months up to 12 months for both EB1A and EB2 NIW. If someone would like to have a premium process, they have to pay an additional $2,805 to USAS, and that would actually allow them to receive a decision in 15 days for EB1A and in 45 business days for EB2 national interest waiver. So A decision means an RFE, an approval or a denial. So it does not mean that they're going to get an approval faster or like they're going to get so a decision can be very general. What usually happens is a premium process, especially for EB2 and AW, would actually, and EB1E as well, would actually influence USCIS officers to produce RFEs. And it has been the case since, I would say, last year, middle of last year. And that's because the applications went up. Again, we have to consider that everyone who came through the borders, illegal immigrants, they stood in the same line before USCIS, but from the asylum side, because we have two types of asylum: the affirmative asylum for people coming through the borders in a port of entry, like an airport, using their passports and a US visa, and people coming through the borders without passing through any CBP officers, without having a visa, and basically, getting their way into the US borders through Mexico or anywhere else. So all these people combined, which is unfair for affirmative asylum applicants, of course, they're all in the same line before USCIS. So people are asking me and asking multiple attorneys, what's happening? Why are applications being late? And what's happening in all of this? What's really happening is whoever came into the U.S. through the borders, they're standing in the same line as everyone else. So now I-140 applicants, they're paying a fee called an asylum program fee, which is an additional $300. So the USCIS started charging the additional $300 fee so that they actually try to do whatever it takes to hire more officers to get the process going, because we have more than 4 million people who came into the U.S. through the borders undocumented. So what I'm saying here, or what I'm trying to get at, is if Trump really stopped whoever coming through the borders undocumented and only allowed legal immigration, things are expected to go faster in 2 years or 3 years, because we already have millions of people before USCIS. So it takes some time to actually finish the cases that the extra cases that they have, the frivolous asylum cases, and so on. So right now, as I said, just to summarize briefly, it's just 8 months up to 12 months regular process, and 45 days premium process for EB2 national waiver, 15 days premium process for EB1E.
All right. So thank you so much, Amin, for answering this question, and thank you so much, my Chaw, also for participating in today's session. In case if you still have any follow-up question or would like to know about any other topic related to immigration, then please go ahead and dial on this number, and you can also give a call on this number and can also participate in today's session. And you can also comment us with any other different topic or any other follow up question that you would like to ask from our today's attorney. All right, so now I would like to take Jitendra's question, and he's saying that I'm a physician applying for an EB2 NIW based on serving underserved communities. Could changes to the program's national interest definition under Trump affect how these cases are judged?
U.S. will always welcome physicians, especially if you're focused on underrepresented people or underdeserved communities. And there is always, of course, I have to note here, a shortage is not a reason for the EB2 and IW eligibility, because it's covered under the PERM process regulations. So if you are sponsored and you have a full-time job offer and you're basically before the Department of Labor doing the labor certification, what we call the PERM process, there is an exception for having a shortage in your field. So the argument, the same argument does not apply for a waiver. But what I'm saying is a waiver is actually not relying on the shortage, but it's relying on you serving those kind of communities. So that's different. But what I'm here, if you want to apply as a physician, your chances of approval would be really high because USCIS really appreciates doctors and physicians, especially if you're really about to serve or you have a proposal to serve the underdeserved communities or people who are being basically without doctors. But again, even though it sounds the same, we're not going to be arguing the shortage. We're going to be arguing that you're going to be serving those kind of communities, which is kind of different.
Absolutely. I think healthcare is the most important sector in any nation. And, that's like a backbone of any country.
Yeah.
So I think that's very well explained, I mean, from your end. And to Jitendra also, if you want to know any other topic or if you have a follow-up question, then please go ahead and feel free to comment us on this session. All right. So, I mean, I would also like to ask about, are there any specific fields or professions that may be favored or disadvantaged under a Trump administration concerning EB2 NIW and EB1A applications?
I wouldn't say fields or professions. I would actually say how the case is prepared. So if someone is trying to argue that basically they're going to be a management consultant, but they're not going to be contributing to any specific field. They're just going to be a management consultant. That's not good enough. The proposed endeavor, of course, has to be very, very specific. It has to highlight how it would actually bring the difference in the U.S. To what sector or sectors, and technically, how would that happen? How would it cause that kind of difference and impact on that sector? So anything that is not specific enough would probably be denied. So it's not really about the field itself. It's about the specific proposed endeavor. And if you do have a specific proposed endeavor in even arts, that would be accepted, as opposed to having a very general proposed endeavor in being a physician or in being an engineer. So it's not about STEM versus non-STEM. It's not about being an engineer or a doctor or an artist or a theater production company or whatever. It's about the specificity of the proposed endeavor and how can we convince a USCIS officer that you have already had some success in the past, which we should have prove in the petition, of course, and all the documents, and that you're aligning your education and professional experience and past contributions to your proposed endeavor in the future, which will bring in that difference, which is going to make America a better country in the future, or even a sector in the U.S. a better sector in the future through business or scholarship.
Right. And we really hope that America becomes great again, as Trump says, and that's how America feels. So, all right. We also have another viewer, Knife here, and Knife is saying hi. Hi, Knife. And the question that Knife has is, do you think that Trump government can be doing all what he talking, and if not, what are the challenges?
I don't think Trump will be able to do so because we have laws here. The Constitution, you have to understand that the U.S. is a democracy, right? So its rule of law is dominant here. So Trump cannot be a one man who's doing everything. So we have the judiciary, and we have the Congress, and we have the president. So three branches of the government. They have checks and balances, of course. The Constitution says, or documents basically the relationships between all of them. So Trump does not have any authority to actually reverse a law that was enacted in 1990, which is the INA Act that provides most of the immigration visas. Trump does not have the authority to reverse a court decision, which is a landmark case. It's a precedent. So a court can only revisit and reverse that decision. Trump cannot do so. He cannot basically interfere with the court judgment and say, well, I'm going to reverse it tomorrow because I feel like it. What Trump can do is give directions to USCIS and CBP officers. Now, all these directions binding. The answer is not really. They're suggestive, and they are not binding. So USAS, and based on what I showed on the statistics, has been doing favorably. Basically approving many petitions for EB2 NIW and EB1A under past Trump's administration. So there's no reason to believe that in the next Trump's administration he's going to be doing something different. What I think is he's going to be actually broadening the visas, EB2 NIW and EB1A, to some extent, so that they accept more talented people. Because now he's having Musk in his administration as well, who is, I believe, is an EB1A or EB2 nationalist waiver himself. I would say probably he is either EB1A or EB2 NIWs, although some people argue that he's EB5. But why would he choose EB5 if there is a higher category? So, we should ask him this probably.
All right. So I would like to say, Kinfi, thank you so much, and my apologies for mispronouncing your name. But Kinfi, if you still have any questions that you would like to ask from our attorney, then feel free to post them, and we are definitely going to take them up. All right. So Amin, you are explaining fantastically about all the questions that we are taking up. Here's another thing that I would like to know from you, as you also mentioned about the border and about the security. So we all know that Tom Homan being appointed as border czar under Trump's administration. So how do you think that his approach will affect the border security, asylum policies, and immigration in the future?
So the question here is about asylum as opposed to EB2 NIW, or?
I think, okay, let's take about asylum, EB2 NIW, because we are taking that as a topic. So yeah, please go ahead and talk about it.
Yeah. So again, the affirmative asylum wouldn't face many challenges in the future, in my opinion, because these people enter the U.S. legally using a visa, and they are documented. USAS can easily, in connection with the FBI, can figure out if someone is or has been a criminal or not in their home country. So they vet people, and vetting is important to get people in. Affirmative asylum, in my opinion, would actually go faster. People would have interviews scheduled faster than 6 years, in 2-3 years from now, because we have to, again, the USAS has to decide millions of cases so that it actually creates that faster process in the future after undocumented people came in through the borders. So that's number one regarding affirmative asylum. Affirmative asylum people who actually applied and got the CO8 legal status, which is a pending asylum interview, and they're waiting in the U.S. legally for the interview. They shouldn't be fearing anything, again, because they are documented. And the first sentence in the USAS receipt that they have received actually says you may remain in the U.S. lawfully until you are scheduled an interview. So right now, they shouldn't be fearing any changes in anything. Also, you have to understand that from a legal standpoint, laws cannot be applied retroactively. It's unconstitutional. So even if Trump, let's say, which is, I would say it's an 0.01% chance. Let's say he said, well, now I believe that I want to get rid of affirmative asylees who are living in the U.S. legally with a CO8 pending asylum interview. That cannot apply to you because you are already here. You're already having the CO8 legal status. You already have the documentation. So that probably will stop people in the future from getting the same card as you, the CO8 employment-based, not employment-based, it's called the EAD, Employment Authorization Card. And that will prevent that for the future, not apply to the past or the present. So that's important to note because status quo will remain the same it is right now.
All right. So,
Yeah, I think there is an interesting question here, if I may reply to it. It's by Kavya.
is saying that for EB2 NIW applicants, there's a speculation that USCIS could enforce higher education or professional thresholds. So, do you think that applicants with advanced degrees but limited publications could be at risk?
Yeah. So I wanted to reply to that question because there is a misconception that is going around that you have to have publications and citations to have an approved EB2 NIW petition. And that's not true. So we have three kinds of applicants. We have the scholar applicant for EB2 NIW. We have the entrepreneur applicant for EB2 NIW. And the entrepreneur is not expected to have any publications or citations. And we have the professional path, which is a third unexplored path somehow, which is basically someone working somewhere in the US saying, through my employment in that institution, let's say nonprofit, I will be doing some novel technique, and that novel technique will bring in the difference on the US nationally and on the field itself. And therefore will have substantial merit and national importance to the U.S. So for the second and third paths for immigration under EB2 NIW, you wouldn't expect to have publications and citations. Only as a scholar, we would expect you to have publications and citations. So it's not going to affect you in any way right now or even in the past, since I would say the matter of Donosar, which actually reversed the New York State Department of Transportation. And the matter of Donosar said you can have a proposed endeavor that is important for the business, for entrepreneurship, for arts. So it broadened the criteria for EB2 NIW to actually cover multiple non-STEM fields and STEM fields that are not scientific or scholarly based. So that's regarding this question. Regarding the advanced degree question too, the INA Act itself, which belongs to 1990, so it has been enacted for some time and never changed, is the one that actually states that you have to have a master's degree or a bachelor's plus 5 years of experience. No one can change the INA Act except the Congress itself. Now, if the Congress decided to change it, that Congress needs the majority of votes, which is very, very, very difficult to get when it comes to immigration. So my answer is there is not going to be a change to the advanced degrees requirements for EB2 and NIW, and there's not going to be a change or a possible change for the criteria itself for non-STEM, STEM professionals, entrepreneurs, and scholars. All paths would be the same probably for the next 4 years. It would be interesting to see if he would really broaden the EB2 NIW category or not, show his directions to USCIS officers. But otherwise, I don't believe that there's going to be much change in this practice.
Wow, that's so insightful. And okay, so thank you, Kavya, for your participation and for your question too. So here's another question, I mean, that I would like to ask: that how might the reinstatement of policies like remain in Mexico affect the asylum seekers' chances of success in their application?
Yeah, that's a very interesting question. So if that person is Mexican, for example, and he or she has a visa and they can come into the U.S. Through a legal way, then probably they wouldn't face much challenges. Now, if that person wants to come illegally into the U.S., probably that statement will apply to them. Now, if that person is not Mexican, and let's say he or she is from Argentina and they traveled to Mexico and they wanted to come through the borders, Mexican-U.S. borders, then USCIS will actually try to stop them by, again, building a wall or whatever, and that will be through the CBP officers at the borders. So if Trump changed the policy again and tried to spend a lot on building that wall, that would be number one. Number two would actually be, and he tried to do that before, actually. He tried to sign an agreement with Mexico which we call in immigration a third safe country agreement. If you are an Argentinian living in Mexico, do asylum over there. Do not come to U.S. To do asylum, to seek asylum. And that's crazy because Mexico may not be safe for Argentinians or for even Mexicans. So he tried before to pass this kind of international agreement, and he failed. It's very difficult to do, and because Mexico is also in the NAFTA agreement, which changed to the USMCA agreement between Canada, US, and Mexico, it's very, very difficult to try to build a different agreement, especially for a safe third country, saying, well, anyone who is in Mexico on a Mexican land will have to apply for asylum in Mexico, and he or she would not be allowed entry into the U.S. So it's very, very unexpected. I hope that covers all types of people who might actually come from Mexico, whether Mexicans or non-Mexicans coming to the U.S. legally and versus, of course, illegally.
Absolutely, and I think that's very well explained. So, to our viewers, also, friends, if you are navigating, your immigration journey, or have any doubts, or need any type of guidance related to immigration, then please feel free to contact Attorney Amin at the number that is provided, that is 407-578-1334. So this is the contact number that you can call him and ask your doubt. And with this, you can also email him on yacoub@boganmonths.com. And you can also visit his website, that is www.boganmonths.com. So these were the contact details that I would like to share. And now moving ahead with my one more question, I mean that I would like to know about family-based immigration, right? So
Yeah.
now I want to know that how do you anticipate Trump's approach to family-based immigration will impact the individuals who are applying for visas or seeking asylum?
Um, Applying for visas or seeking asylum.
Mhm.
So if someone is marrying a U.S. spouse, they are allowed to adjust status based on their marriage if it's a bona fide marriage. So if it's a good faith marriage, of course, and we could prove that that you can actually skip all the asylum process, you can skip all the visa process, and completely go ahead and apply for the I-130 and the I-485, I-765, I-130 and one, and basically get all the cards you can get in the least period of time possible under USCIS. So family-based immigration is highly recommended if you do have an American spouse, or if for example you have a father or a mother who is a U.S. citizen. Now it differs from, again, it's just the categories are different. So you would have a first preference for the spouses, father and mother, and first preference is actually for the spouse. Second preference is for the mother and father. Third preference would go towards sons and daughters, and fourth would be the brothers and sisters. So the lower the preference, the more years you would have to wait. Otherwise, there is no interrelation between visas or seeking asylum and family-based immigration. We can see some cases where basically a person who is applying for asylum in the middle, having a CO8 card, for example, pending asylum, waiting for the interview, he may actually marry someone in the process. And just by marrying an American citizen, that will completely change matters into getting the green card through marriage, not through the asylum process. And later on, after they have the green card, they can basically send a letter to USCIS and ask USCIS to withdraw their asylum case and basically go ahead and do the green card through the marriage-based immigration, which is family-based. Otherwise, there is no foreseeable impact on these types of visas.
Absolutely. And I mean, I would like to know from your side that it's almost 1 hour that we have reached. But I have some more questions from my Facebook group. So if you have some time, is it okay for you to give 5 to 10 more minutes to our audience?
Yeah, sure. 10 minutes are okay.
All right, that's pleasure. Okay, so I mean, we can see here. I hope you can see my screen, right?
Yeah, I see it.
Yes.
So, would a
Yeah.
pending E2NIW affect you when getting H-1B visa? Waiting time can acquire H-1B while there is a pending EB2 G1 holder. Thanks, Burden. Yeah. So that's an interesting question. So the H-1B especially is a different breed of visa. So we call it a double or a dual intent visa. It's an immigrant and non-immigrant at the same time. And that basically means there's no contradiction whatsoever between the H-1B and EB-2 and IW, because EB-2 is an immigrant visa. So applying for a double intent visa like the H-1B at the same time was applying for EB-2 national interest waiver, which is an immigrant visa, that does not show any contradiction in any intent. So you can go ahead and apply for the H-1B and also apply for the EB-2 NIW. But the trick here is to maintain your legal status through the H-1B, because otherwise you may actually fall out of legal status since the dates are not current yet for the EB-2 NIW. Meaning that if you got an I-140 approved, you would have to wait some time before you can apply for a green card and a combo card. So that means between the approval and applying for a green card, you would need to maintain legal status through the H-1B. So it would be highly recommended to actually go ahead and secure an H-1B before you apply for the EB-2 national interest waiver.
All right, that's wonderfully explained. And here's another question that is, do we need to submit ETA 9089 and related for EB2 and IW self petition?
Yes, it's a part of the regulations. So even though it sounds and it reads like it shouldn't be submitted, because it's basically a labor certification application for the firm process, you must submit it. You have to complete specific sections in the 9089 form. Right now, they have produced a new one, so you would have to download the new version and use it. And once you comply with the regulations and fill it out and sign properly, you have to include it in the submission. Otherwise, you will probably get an RFE requesting you to do so.
All right. So, moving ahead, here's another question that before submitting or mailing the petition, do we need to create an online account on USCIS?
No, you don't need to create an online account on USAS. I would say it would be helpful to do so, but you don't have to. You're not required to establish an online account on USAS. Now, it's helpful because it allows you to track the case, to actually get notifications whenever something is going on. If they updated your case, for example, into decided or approved or issued an RFE, you will get notified if you do have a USAF account. Now, if you're doing this through an attorney, your attorney would actually have access to your case and would actually get the notification from USAS on your behalf. So you don't have to do it if you have an attorney. I would recommend doing it if you're doing this on your own and would like to stay updated regarding any changes that may happen to your case.
Absolutely. I think taking expert advice is mandatory in immigration process. So, friends, if you still, need any guidance or need any help, then here's the contact details of our attorney that is mentioned, and you can see the contact details like phone number, email ID, and also the website that is being provided on the screen. So, please go ahead and share your, any information or any doubts that you have, and I'm sure that attorney Amin Yacoub is definitely going to take them up and he's going to solve them. All right. So, I would like to ask a few more questions, if you allow. That is,
Yeah, go ahead.
Yeah, that's great. And I don't know why. Yeah, that's great. My screen is visible now. So which part of the ETA 9089 need to be filled for EB2 and IW? I have already filled in the Appendix A and final determination forms.
Yeah, that's all what you need to actually provide for the new version. So it's just final determination and the appendix A. So basically, education, experience, certification, skills, which is appendix A, and then the two pages where you have to sign basically as the beneficiary, and that's all. And the preparer, of course. So you would have to sign. If you prepared your own 9089, you would have to sign twice on the two-page towards the end.
All right. So I think that's all from my end because I have covered a few questions that I wanted to ask from you. And yeah, I think, I mean, it's almost time for our very insightful session. And it's just 1 hour we passed and we didn't even realize. So from my side, it was a very, amazing, a wonderful experience and obviously an honor to have a show with you. And you were outstanding. You were clear. You made up a very great points that that was very insightful and that was very eye opening too with the datas and with all the facts and stats that you brought up. That was great. So how was your experience in today's episode? How it was?
It was amazing. I really enjoyed my experience, and I actually really enjoyed the questions as well. They're very, very interesting questions from your side and from the audience side as well. It was really a pleasure being here, and thank you for the invitation.
Absolutely. And I think the questions, those were, interesting, but even the answers, those two were very much interesting. So I like that too. And there's another comment from Freelance Mastery also.
Yeah,
So
let's do that as the last question and move
all
on.
right. That's
Yeah.
great. So it's that what if my case was submitted under Biden's administration and got adjudicated when Trump's administration? Which administration am I entitled to?
Yeah. So probably that question has to do with the importance of the proposed endeavor than which administration would actually adjudicate the case, because they're the same USCIS officers. People think that, again, Trump is going to remove all USCIS officers and replace them with other USCIS officers. So they're just the same officers deciding the same cases under the same legal framework, whether under Biden or Trump. But your question might have a hidden question, which is there is a difference in the importance of policies between Biden's administration and Trump's administration. For example, solar energy is very, very important for Democrats and for Biden's administration, but it may not be as important under Trump's administration. So, since you have filed your case under Biden's administration, your case should be aligned with Biden's administration's importance when it comes to policies regarding solar, etc. Again, these are not black and white, so you have to understand that Trump is not like he's not going to dismantle the solar energy when he arrives. Again, like the biggest producer of electric cars is by his side right now. So we actually that's why.
I think due to some reason, Amin, can you hear us?
Yeah, yeah. I'm just saying, last thing I wanted to say is um, there is not going to be a huge difference in policies and the importance of those policies, because right now Trump is more convinced of not solar, but basically clean energy and stuff like that. But he's not willing to sacrifice oil and gas either. So we're going to be seeing a new Trump administration basically focusing on all energies, probably nitrogen as well. He talked about nitrogen cars, but he said, well, they're risky. So now that Musk is on his side, probably we'll be seeing a different approach towards electric cars, towards solar energy, and towards policies that Trump was in the past kind of reluctant to accept as important. Otherwise, to answer your question directly, your application will be decided based on the policies that are considered important at the time your application was received. So when you have received your USCIS receipt under Biden's administration, that's the time limit, that's the time estimate where actually the officer has to look around and say, you have complied, you're actually contributing to an important policy under Biden, not Trump.
Wonderful, wonderful. So, yeah, I think, Amin, we also took the last question of today's episode, and that too very well explained. So, again, to our viewers, also, guys, if you are navigating any immigration journey or having any doubts, then please go ahead and contact our attorney, and he's definitely going to help you out. And I mean, from my side, as I also said, that it was a wonderful experience to have a show with you. And you were also saying that you also enjoyed the questions that we prepared, the audience they were asking. So big thank you to attorney Amin Yacoub for making this session a brilliant one and bringing a very insightful and a very eye-opening stats and facts about today's topic. And I think, yeah, that's all, and to our lovely viewers also who participated in today's webinar, thank you so much to everyone. Keep on posting your question, friends, and we are definitely going to keep them on asking and try our level best to provide a best solution to you. So thank you so much, everyone, for this amazing session. Don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. I'm Sam, signing off for now.
Thank you.
Thank you so
Have a
much.
good day. Bye-bye.